Now that we have begun the best day ever. Good afternoon. This is the House Judiciary Committee. It's February the 7th, 2023, a little after 1 o'clock. We have one of the canines from the Maryland State Police who's visiting the committee room today, who apparently is our therapy dog today, as we begin 120 witnesses on 14 bills. As I mentioned a moment ago before we came online, Delegate Lewis, Jazz Lewis, is unfortunately standing on the side of the road because the tire on his vehicle blew out. So we're going to hear from his aide, Henry Snurr, who's here today, about House Bill 332. Also, I have three other people to testify. Is Sarah Sample here? You're favorable on the bill or favorable? You're favorable. Straight favorable. Okay. So we're going to hear from you too. Members of the committee should be aware that when we have a situation like this, we are kind to and do not cross-examine at all the staff person who is merely filling in for their boss who's stuck on the side of the road with a bad tire. Everybody else is open season. So with that, having said that, Mr. Snurr, if you'd like to begin for House Bill 332, and then we'll hear from our other witnesses.
Thank you, Mr. Chairman, and members of the Judiciary Committee. For the record, my name is Henry Snurr. I'm Delegate Lewis's Chief of Staff and Legislative Director. I'm here today to testify in strong support of House Bill 332, the Body-Worn Camera Appropriation Financing Act of 2023. This bill is a continuation of the work from the Law Enforcement Body-Worn Camera Task Force, which was charged by Speaker Jones with establishing cost-efficient ways to scale the use and acquisition of body-worn cameras across Maryland. In light of what we've seen out of Memphis and the murder of Tyree Nichols, it's now more important than ever that we see these cameras across Maryland and widely used throughout every agency in our state, because we can't have accountability without transparency. House Bill 332 will allow for statewide negotiation of body-worn camera contracts and acquisition of devices, which will help eliminate the significant financial barriers that many law enforcement agencies encounter when attempting to implement a BWC program. This is a problem especially true for Maryland's smaller and mid-sized agencies. This approach outlined in the bill will streamline the resources necessary for a successful program and will offer a standardized statewide system that reflects the needs of law enforcement and promises transparency while integrating those BWC programs that already exist in the state, all the while removing the most significant hurdles to implement these programs for our law enforcement. Not only does this bill help cover the cost to ensure the successful rollout of BWC, but also provide increased accountability, provide transparency, and most of all, increase trust and strengthen our police-civilian relationships. Current research shows that the benefits of body-worn cameras include reduced use of force, improved transparency, and increasing corroborating evidence. Though they are not a catch-all solution to the issues we face when it comes to accountability, they are an essential item in our toolkit and we need to use them. The instances of brutality that have been showcased on the news are not new. What we have seen most recently out of Memphis shows how impactful this footage can be. And this is why it is pertinent that we not only require law enforcement agencies to wear body cameras, but that we provide a way for these agencies to actually be able to purchase them. This is what House Bill 332 sets out to do. The initial cost of body-worn cameras can fall between $1,700 and $3,700. And when you're a small local agency with only a handful of officers, your budget may not be able to bear such a cost. That's why the state needs to step in and help these agencies acquire cameras. I want to thank those stakeholders who have been working with us for years on getting this bill done right and are continuing to work with us on friendly amendments, which will be provided to the committee once they are ready from the amendment office. But with this bill, we ensure that the transparency brought by body cameras can be present in every place in Maryland where law enforcement officers are. This is so that we can have more accountability and to help law enforcement do its job more effectively. For these reasons, I urge a favorable vote.
All right. Thank you very much. If people have not to say that Mr. Snurr couldn't maybe handle tougher questions, but if you have very basic questions about the bill, we can address those to him. Otherwise, you can address those directly to Delegate Lewis when you see him here in the legislature. We have three other people who are testifying, and you can direct your fire there. But we're going to hear from Delegate Simmons first.
Thank you, Mr. Snurr, for coming out and testifying. Can you just advise me on who's your state delegate?
It would be a wonderful man named Delegate Gary Simmons.
All right, thank you. No further questions. Appreciate it.
Well, that changes everything, really. All right, if there are no other questions, and probably not, then that would be fine. Thank you very much. We hope that Delegate Lewis gets back on the road here shortly, and we're going to hear from 3 other witnesses now. Sarah Sample from MACO. We have virtually Russell Hamill, I think, from the Chiefs and Sheriffs. He's not here. And then the MML, Bill George, are you here? Yeah, come on up. Mr. George is testifying favorable with amendments, so we're going to, but these are the other people who are here to testify, so I figured let's go ahead and hear both of them. We'll hear from Ms. Sample first. So if you'd like to begin, please, for 2 minutes, that'd be fine.
All right, thank you everyone for having me today. Thank you to the chair and members of the committee. And so what I'd like to start off with is that we are in support of House Bill 332. I think we're all familiar with the police legislation, the reform legislation that rolled out in 2021. And with it came body-worn cameras, which represented a fairly significant unfunded mandate. I think it's important to point out that it's not just the cameras, it is storage. So this is servers and cloud software potentially. It's software for redaction. It's the personnel that has to manage the programs and the redaction. And it's also the cybersecurity that comes with protecting what is ultimately incredibly sensitive material. So this legislation represented the potential, the 2021 legislation represented the potential for just massive widespread duplication of effort by the counties, but also the potential for counties to suffer the premiums that come with single user contracts. So we believe that this legislation signifies a partnership with the state to go ahead and implement what is very important infrastructure in police accountability and police reform. And it centralizes those resources with an opt-in option at the state level for counties to take part in the state level provisions that are negotiated. It also lets counties reserve the right to maintain the programs that they've started if they choose to go ahead and do that. So we think this, again, represents great progress in police reform and police accountability, and we think that the state feels the same way. And so we are hoping that the state would be willing to meet us part of the way in making sure that this program gets rolled out effectively. So our language in our testimony, we didn't have formal amendments, but we did just go ahead and add some clarifying line edits in there that would just streamline the process so that it doesn't sound as though the Department of General Services has to be doing a custom job per county. So for those reasons, MACO urges a favorable report on this program. Thank you.
Thank you very much. The next 2 witnesses are signed up favorable with amendments. I see Mr. Hamill has joined us, but we'll hear from Mr. George first, and then we'll hear from Mr. Hamill for 2 minutes, please.
Thank you, Chair. Members of the committee, my name is Bill George with the Maryland Municipal League, today supporting House Bill 332 with amendments. Ms. Sample talked a bit about the costs of body-worn camera programs generally, and we appreciate the work of the sponsor and all the stakeholders on this bill in particular, which, while it may not address some of those ongoing costs, does have the potential to really add some cost savings for municipal and county and state agencies with upfront costs. Mr. Snurr mentioned that this may be most impactful for the smaller and mid-size police agencies, many of which reside in municipal world and are some of our members. I can tell you that there are 89 municipal agencies in the state. Probably just under half of them have 10 officers or fewer. So we have a lot of those small agencies that really could use some help as they try to roll out their own body-worn camera programs for all the benefits that have been noted earlier. Our amendments are those that we've worked on with the sponsor, as well as the counties and the Chiefs and Sheriffs Association, and it would, in our opinion, I think, make it even more of a cost savings for the local agencies if they were to be able to piggyback on top of a state contract and use the economies of scale to help bring down the cost of the acquisition of the cameras and equipment for everybody. And therefore, if the Department of General Services puts out a notice when a state acquisition process is going on, local jurisdictions can jump onto that contract and therefore lower the cost for everybody, since more will be ordered and therefore going out on more and more officers. So with those amendments, Mr. Chair, we ask for a favorable report. Thank you.
Mr. Hamel?
Good afternoon, Chair Clippinger and members of the Judicial Proceedings Committee, and thank you for this opportunity to
I'm sorry,
address.
which committee are you?
I am.
Judiciary.
I'm sorry, sir.
Judiciary.
I'm sorry.
Our carpet's different. It's you know,
I am.
it's blue
Sorry about
carpet.
that. Great way to start off, but you're going to appreciate this. I'm the current president of the Maryland Chiefs Association. I'm representing both the chiefs and the sheriffs today. And I just got a message that the amendments that we wanted to address have actually been included in the bill now and I'd like to thank the sponsor on our behalf. We'd echo what MML offered. And again, the chiefs and sheriffs would like to thank the sponsor for his past and continued support and work on this issue, and respectfully request a favorable committee report on this bill with the described amendments. Thank you very much.
All right. Are there questions for this panel? Really? Okay, seeing none. Thank you all very much. That concludes the testimony on House Bill 332. We're going to go now to House Bill 336 with only one witness, and it's Delegate Terrassa, and I saw her come in, and there she is. This is House Bill 336. And whenever you're ready, we'll hear from you.
Excellent, thank you.
3 minutes.
Yeah. 1 second. Okay. Good afternoon, Chairman Clippinger and Vice Chair Moon and members of the Judiciary Committee. Thank you for this opportunity to present House Bill 336, Courts, Expert Witnesses, Letters of Exception. For the record, I'm Delegate Jen Terrassa. This bill may sound familiar to some of you because you heard it last year. And thanks to this committee's support, the content of this bill passed the House last year and made it through the Senate by being incorporated into another bill on sine die. But unfortunately, it ran out of time to get across the finish line by midnight. So I am bringing it back this year in the same posture as it passed in 2022. The problem this bill addresses is that under existing law, it is difficult for defendants to present expert testimony challenging the drug evidence presented against them in court by the state, essentially. Essentially, under existing interpretation of law, defendants seeking to have an expert testify in court after reviewing analysis performed by a state lab must get the state's permission. From my perspective, posing a serious risk of conflict, the state has to give them permission to testify against them. So what HB 336 does is prohibit a court from requiring an MDH letter of an exception in order for the expert for the defense to be able to testify in the criminal proceeding challenging the state's expert. As a reminder, we amended the bill last year to resolve some of the concerns the State's Attorneys Association had. We changed it from prohibiting MDH from denying the letter to prohibiting the court from requiring a letter. And that was fine with me, and I kept that language that we agreed on. House Bill, once again, has the support of the Public Defender's Office and chemist forensic scientist Ben Streifel, a constituent of mine who brought this matter to my attention. Unfortunately, they're unable to testify before you today, or fortunately, because I know you have a lot of witnesses, but there's written testimony for your consideration. I respectfully urge a favorable report.
There are questions for Delegate Terrassa? Okay. All right, then. Thank you very much. That
Thank
concludes
you.
the testimony on House Bill 336. We appreciate it. We are, there you go, we're going to the Vice Chair of Economic Matters to House Bill 212. And this is Delegate Crosby. Delegate Crosby, oh my, there are quite a few people. Anybody else you want to have come up with you?
I didn't arrange for any of them, Mr. Chair.
All right, so you want to go up first and then we'll start to take them. Okay, there aren't that many of them.
You had me nervous.
That's all right. It's fine. We'll hear from you and then we'll take the rest as a panel and we'll go from there.
Okay, good afternoon, Mr. Chair, Vice Chair, members of the committee. For the record, Delegate Brian Crosby here to present House Bill 212 entitled Criminal Law and Decent Exposure within a site of a minor. This bill passed the House last year and got out of JPR in the Senate. It did not get through the Senate on sine die. And it is in the exact same posture that the bill passed last year out of the House. This bill is in direct response to an incident that happened in St. Mary's County in front of young girls. And all the bill simply does is increase the penalties for those who commit the offense in the site of indecent exposure in the sight of a minor. And it increases the penalties from 3 years to 5 years, not to exceed 5 years imprisonment, and a fine not to exceeding $10,000 or more. And the reason for the increase in penalties is because in that incident in St. Mary's, the individual had a security clearance. And the judge gave them the max, but the max wasn't enough to trigger an investigation to remove that individual's security clearance on the base. And so that individual was allowed to move states. They moved to a different state. Still having that security clearance, was still able to obtain a job that I would venture to guess was in six figures, just in a different location. If the penalties were what this bill makes it, there would have been an internal investigation and that individual would have had their security clearance stripped. That's it. Doesn't change anything else within the law. And with that, I know Maryland's laws already recognize the importance of the issue, and I urge a favorable report on this bill, and happy to take any questions, or if you want to call up other favorable, I don't even know if there's any other favorable witnesses, to be honest with you, Mr. Chair, but happy to take questions.
There are four others, so we're just going to take questions for you, and then we'll bring those four people up.
Okay.
Are there questions for Delegate Crosby for starters? Delegate Conaway?
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill. Is there any other reason for this change other than to capture people with security clearances?
No, not at least under my intent.
Okay, thank you very much.
Other questions for Delegate Crosby? All right, seeing none, thank you, Delegate Crosby.
you.
We'll now hear from Lisa Jordan, Joyce King, Debbie Feinstein, and Hermione Morgan. There's one person signed up to testify in opposition. We will hear from Vanita Taylor on the next panel. I see three.
Ms. Feinstein's not able to
Right.
make it today.
Okay, that's fine. So we'll hear from the three of you for 2 minutes each. Go ahead.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 212. For the record, Delegate Crosby's office did indeed invite me to be here, but apparently forgot. I'm just saying. However, we still support the bill because indecent exposure really is often a gateway crime to other types of sex offenses. And although there's certainly, and we absolutely acknowledge there are minor incidents of indecent exposure, there are also intentional incidents of indecent exposure that are specifically directed towards children. And so this bill is really trying to capture that. And I did want to also just draw the committee's attention to the gap that's built into the law to make sure that the two people involved are at least 4 years different in age. And this is to make sure that we're not kind of interfering with inappropriate but, all too common play between minors. That also is the same 4-year age gap that we use in other parts of the sex crimes laws. So this really is just recognizing the heinousness of this crime and also capturing those folks who have security clearances that we need to really restrict a bit more carefully. For those reasons, we support House Bill 212.
Good afternoon, Mr. Vice Chair, committee members. My name is Joyce King. I'm here on behalf of the Maryland States Attorneys Association. I'm Chief Counsel at the Frederick County State's Attorney's Office. I have been prosecuting child exploitation crimes for almost 10 years, and I am here in support of HB 212. As Ms. Jordan did speak and the delegate did talk about, these enhancements are necessary and not uncommon. There are over 15 states that really distinguish this type of exposure versus a general urinating in the public or flashing. There is a viciousness, a predatory nature with regards to this type of crime. So this distinction and categorization is how I see it. This is a categorization type of bill. And I echo the sentiments of Ms. Jordan talking about this as a gateway sex offense, and that is what my experience has shown me. In Frederick County specifically, I had a case where an individual was a janitor at the school system and would expose himself at the schools, record himself exposing himself. This behavior began to escalate. He began installing cameras in his own children's bedrooms to capture them with period interest, and then eventually escalated to hands-on offenses. I spoke with the MSAA subcommittee and got other case examples, and what we do see are predators that go to playgrounds, to go to school grounds. In Frederick, just last year, we had a neighbor watching children come home from school and waited until they were playing on their front yard until he exposed themselves. I mean, this is absolutely should be distinguished from what is on the books right now as just a generic exposure. So with that, the prosecutors of the state support HB 212.
Good afternoon, Vice Chairman. My name is Hermione Morgan, and I am also a State's Attorney out of Prince George's County, Maryland. And I'm here on behalf of Ms. Aisha Brayboy, as well as the Maryland State's Attorneys Association. I did have the opportunity to try a case where there was an indecent exposure to a child, 11-year-old child, in her stairwell. And the perpetrator of that crime was actually her neighbor. The child reported initially to her parents that she saw the defendant and that he was making sounds which could be interpreted by an adult as sexual. The mother did not believe her the first time. A few months later, the child was leaving to go to school, trapped in the stairwell. She left her apartment. The defendant was standing at the end of the stairwell in between her and going to her school bus. And what she described when seeing his private parts as a quote-unquote chicken neck, because that's what she understood as a child. It is to be noted that during trial, and really to my surprise, even after prep, she told the ladies and gentlemen of the jury that this was her first time seeing something like this. And so her parlay into adulthood is seeing a male's genitals who was predatory, which the state believes in nature. At that time, of course, the statute allows for 3 years. The state asked for 3 years, and I believe the guidelines were 90 days, which are very low, I believe, for this predatory behavior. The court did give 45 days, offered a probation, and that the defendant be monitored by comment and have a psychosexual evaluation. And I would tell ladies and gentlemen of this committee, now that defendant has absconded from that probation, and he was allowed, because we could not stop him from living in the same apartment complex. So I do not know where he is now. I do know there is a penalty, of course, against him to have him arrested.
And do we have Debbie Feinstein here, or is this it?
No, she's unable to make it.
Okay, great. Are there any questions for this panel? All right, thank you very much. We have one person signed up unfavorable from OPD.
Good afternoon. The Office of the Public Defender was unable to submit their written testimony because normally I say, read my written, because of technical difficulties. So I'm going to read it extra fast so that if you have any questions, you can give it to me. The Maryland Office of the Public Defender respectfully requests that the committee issue an unfavorable report on House Bill 0212. This bill codifies a prohibition on committing a common law crime of indecent exposure and establishes a new offense because of someone's age. The Office of the Public Defender, we recognize that there are times we have to create legislation that addresses a specific class of victims because of the nature of the offense and the trauma or the damage to the victim. We do not believe that this is one of those bills where we have to make a difference, where there should be a difference in penalty. There have been no statistics provided to show that there is even a need to do this. The sponsor spoke about a case in his area, and because the person couldn't get a clearance, they could continue to get a clearance. That is not a reason for us to make a difference in the penalty for if the victim is an adult or whether the victim is a child. This is not something that we would say that there is an additional harm because of the age of the child. so that we should have a different penalty based upon who the victim is. It is still indecent exposure. And also, we have a problem because a lot of times indecent exposure that we see for clients, a lot of times are people who are homeless, people who are rushing, not people who are doing it with a prurient intent, but people who are out there not because they want to. So we request an unfavorable response.
Are there any questions for this witness? All right. That ends the hearing on HB 212. We're now going to go to House Bill 287 from Delegate Fair. And you'll have 3 minutes whenever you're ready.
Thank you, Chair Moon, and thank you to my esteemed colleagues here from the Judiciary Committee. Here, for the record, Delegate Chris Fair, District 3, bringing forth House Bill 287, which seeks to repeal an antiquated law criminalizing an individual for transferring HIV to another individual. Currently, people living with HIV face a misdemeanor penalty punishable by up to 3 years in prison and a $2,500 fine for quote-unquote knowingly, and I want to note that that's in quotations, transferring or attempting to transfer HIV to another person. Any type of HIV exposure, including consensual sex, blood and tissue donation, breastfeeding, and or needle sharing, may be subject to this prosecution. Disclosure and using of condoms are not allowed as affirmative defenses to prosecution under the law. Moreover, few cases clarify the scope of what is considered an HIV exposure. So, despite the law's initial intentions, it has had a dramatic negative impact on the ending of this epidemic, unintentionally discouraging people from knowing their HIV status. UNAIDS encourages countries to follow a 90-90-90 rule. 90% of people living with HIV know their status. 90% of those who know their status receive sustained antiretroviral therapy, and 90% of those people are considered virally suppressed, meaning they carry a 0% viral load. This ambitious goal could end mass outbreaks of HIV in our country and our world. However, many fear the legal repercussions of knowing their status and thus refuse to get tested. This law disproportionately impacts many disenfranchised communities, including Black and brown communities, which are disproportionately charged with criminal offenses under this current law. Maryland falls behind most of the country. It actually has one of the top 10 strictest HIV laws compared to the other 40 states in the country. And it actually is one of only 2 in the Northeast left that actually have this law sitting on the books. So we're looking to catch up with folks as well. The science has drastically changed on HIV since the 90s. I cannot stress that enough with this committee. We have noted that what was originally seen as a death sentence to many people that live with HIV is now simply taking a single pill a day. It guarantees a full life for that individual living with HIV. There is also a shot that an individual can take once every 3 months. So the science around HIV has significantly changed since the concerns and the backlash of the 1990s, where people sought to enact legislation and criminal code similar to the one that we're seeing here today and talking about today as a reaction to that backlash. And with that, I thank you for the time, and I urge a favorable report on HB 287. I try.
Do we have Jamie Grace Alexander or Alex Biggis here?
Good afternoon, Chair Clippinger and Vice Chair Moon. I'm here with Free State Justice, which is Maryland's LGBT advocacy and legal organization. We write today in support of HB 287, which would eliminate the unequal treatment of people living with HIV for prosecution and stigma. Currently, HIV is the only infectious disease specifically named in a criminal context within Maryland's criminal code. This statute allows a court to fine a person at 5 times rate higher with 3 times as long of a prison sentence compared to the general disease statute applied against other infectious diseases. People living with HIV have faced prosecution even without exposing others to any risk of disease transmission. In 2008, a 44-year-old was sentenced to 18 years of imprisonment. 10 years of his sentence stemmed from a charge of knowingly attempting to transmit HIV to another person because he allegedly bit a police officer during the arrest. The officer did not test positive for HIV, and according to the CDC, there exists only a negligible risk of HIV transmission from a bite. Yet according to Maryland's statute and its application, they ignore those findings, leading to prosecutions for behavior that poses a remote and minuscule possibility of transmitting HIV. Importantly, this law frustrates public health goals. Stigma against this disease and the severity of the criminal code reduces the number of people getting tested, potentially leading to higher transmission levels throughout the state. Furthermore, the context in which the law was enacted and is still applied leads us to understand its discriminatory intent. The specific statute that singles out HIV transmission above all other diseases was enacted during the height of the AIDS epidemic, where fear and homophobia governed much of our public policy. And with that, thank you for the time.
All right, now we've got 2 virtual witnesses. We will hear from Kara.
I think that there's one more in person.
Who would that be?
Sorry, Alex Biggis.
Sorry, go ahead. You have 2 minutes.
Okay, good afternoon. So I'm grateful to be here today because my presence here indicates that this was something that was important for everyone today. So I'm Alex Biggis, and I'm representing the HIV Coalition of Frederick. And we're a conglomerate of diverse organizations, and our job is to make sure that we address the needs that are lacking in our HIV communities of Frederick. And so, and that purpose is to reach the goal of no new infections, parallel to that of the nation's goal, and 90% of positive persons knowing their status by 2030. And so Maryland has done a great job in health departments across the state and in medical initiatives of providing affordable antiretrovirals for individuals who are HIV positive. But when looking at barriers to HIV and general sexual health testing, access to medication is not the barrier. The barrier is stigma. And stigma uses fear and misinformation to place shame upon individuals who have HIV and mark them as a threat to their peers in general society. And the vague and unscientific criteria that's listed under current Maryland law for what constitutes an offense while living with HIV shows that stigma is the foundation of these very laws. Perception of exposure, attempted murder, reckless endangerment, and the spitting on someone are listed under current law as punishable offenses. And so this vague verbiage under current law does not recognize the reality and the pathology of HIV. HIV cannot be passed via spitting. HIV, when treated, poses no mortal threat. Those who are undetectable cannot pass the virus on to others, especially in the manner of spitting. And so current legislation therefore presumes that HIV positive persons are a threat by their mere existence, and they do not take into account undetectable equals untransmittable, the use of things such as condoms and PrEP and other preventative measures, and even includes consensual relationships in those statutes. And so just in that saying that this is not hyperbolic, the damage that gets done to our communities. These are things that happen, and having consensual relationships when these individuals pose no threat to the greater society is something that needs to be tackled. And so I would encourage the delegate to
wrap up. Okay, thank you.
to
All right.
support this.
We have two virtual witnesses.
Excuse me, I signed up as a in-person and written testimony. I'd like to be heard.
What is your name?
Melanie Reese.
I do not have a Melanie Reese on this. I'm sorry.
There's no.
We have no Melanie Reese on our witness list for the day.
Oh, I
I
filled it out on
apologize.
the MGA witness, the testimony. I've put both written and in person.
I apologize. I don't have you on our list. We don't take day of changes. I'm sorry.
Okay, but could you look and see if my written testimony, you have it?
Yeah, I'll have someone take a look offline, and hopefully we can right.
I'll make sure it gets, just send it to my office.
Okay.
Thank you.
Thank you. Okay, we do have two virtual witnesses. We'll start with Kara Engelhardt and then Kiana Voorhees, and you'll each have 2 minutes.
Good afternoon, Claire Clippinger and Vice Chair Moon and members of the House of Delegates Judiciary Committee. Thank you for the opportunity to provide testimony today. My name is Kara Engelhardt, and I'm an attorney at Lambda Legal Defense and Education Fund. Founded 50 years ago in 1973, Lambda Legal is the oldest and largest national legal organization dedicated to achieving full recognition of lesbian, gay, bisexual, and transgender people and people living with HIV through impact litigation, education, and public policy work. It's my pleasure to offer testimony today in support of Maryland's HIV criminalization statute repeal. Lambda Legal has experience representing the interests of people living with HIV and has advanced public policy and litigation to ensure access to treatment, as well as to help combat discrimination, bias, and stigma. Our HIV project has led cases across the nation concerning HIV discrimination in all areas of the law, including healthcare, employment, discrimination, privacy, and criminalization. Laws that criminalize HIV are outdated, given the medical advances that I've heard here discussed today, but not only, and they're harmful to public health goals, but not only are they harmful to public health goals, their direct and indirect impacts are disproportionately and disparately felt by historically marginalized populations, and they result in prosecutions grounded in stigma rather than scientific fact. Today, at a time when medical advances provide for people living with HIV to live long, healthy, and fulfilling lives, the condition remains criminalized in many states like Maryland. And I'll refer people to my written testimony for discussion of the public health impacts, but what's important today to talk about is that it disproportionately impacts historically marginalized communities, including Black communities, Latinx communities, gay and bisexual men, transgender women, and Black women. And although HIV can affect anyone, today in the US, Black women are currently experiencing the highest HIV transmission rates of any demographic group. And as with any criminalization scheme, the most impacted by HIV criminalization, policing, prosecutions, etc., are people of color and LGBTQ people. And I think that this disparate impact is vital for your consideration today and your attention as elected leaders in Maryland, a state in which HIV rates are 10 times higher amongst Black people than white people. Thank you. Please let me know if you have any questions, and please see my written testimony.
Kiana, whenever you're ready.
Okay. Hello, everyone. My name is Kiana Devereaux Borges. I am a 20-year-old Black trans woman of Maryland. At the age of 16, I was diagnosed HIV positive. This journey with HIV has been a struggle, but what has kept me afloat is being able to be a positive voice for the change and spreading correct education about HIV and AIDS with amazing prevention resources within the Baltimore City area. The HIV criminalization law has had a negative effect over my experience of being HIV positive, with incorrect stigma and lack of education, putting my life at risk and struggling with mental health due to mistreatment of being treated differently for being positive. The education on HIV is outdated from a time where HIV was an unknown disease and there was no education. As of now, we have more scientific knowledge and prevention for this disease. I speak from the point of view from a citizen that lives every day with HIV, and the barriers broken down with being HIV positive due to lack of education and the lack of knowledge and the outdated laws.
All right, does anyone have any questions for the sponsor or witnesses? I see Delegate Arakan. Anyone else? Grammer? All right, we'll go in that order. And then Boucher.
Thank you, Mr. Chair. Thank you for being here. Is this your
And
first time
Conway.
in Judiciary, Delegate?
Thank you, it is. It's actually my first bill,
All
period.
right. Well, welcome.
Thank you.
Could you let me know how many people have been charged in the last 5 years with this crime?
Sure. I don't have exact data for 5 years, but I do have 3 years worth of data. It has been charged 10 times with 0 convictions in the last 3 years.
Okay, and can you tell me how many times a breastfeeding woman has been charged?
I do not have that information. I can certainly pull that for you and have it sent over to your office.
Thank you. So when I look at the actual bill, it's really only got one main substantive piece. An individual who has the human immunodeficiency virus may not knowingly transfer or attempt to transfer the human immunodeficiency virus to another individual. That's all it says. There was some comments about spitting, breastfeeding. Those things are actually not in the law. So I'm just wondering, where did those come? It was multiple times referenced that it was in the law. I don't see it here. Is there another place I should look?
Yeah, so what you're looking at is the word knowingly transfer or attempt to transfer can be left up to the discretion of prosecutors. And so they choose, as the example was used with the biting incident with the law enforcement officer, prosecutors had the option to define that as the knowing transfer of HIV from one individual to another, or attempt to transfer.
And it was a failure. As you've said, there was 0 convictions. So it seems to me that the law is working perfectly because the judges are hearing the facts of the case and are ruling to the best of their judgment that this is not a situation where the person was knowingly attempting to transfer something.
At the stigmatization of all people carrying HIV, that is true. It shows that I believe that the law is actually being used as a weapon and not as an appropriate tool. I believe that the bill highlights the fact that the stigma that this law currently creates is underscored by the fact that most people, when it is applied inequitably. And you're right, the court has to step in every time and shoot it down in order for it to not continue to carry on this unequal application.
I have heard the mention now several times that it's a deterrent to getting treatment, although the same population group, I think we can all admit, has many serious adverse health disparities that they experience that have nothing to do with this. So how is this law impacting them in a different way than heart disease, diabetes, many other illnesses that are also at a higher risk in subpopulations that you're referring to?
That's a really great question. I want to dive into just the stigma of this existing law. When you look at individuals looking for testing, you are basically putting a law in place that sets aside one specific disease in our community and says if you have this one specific disease, you are held to a different standard of law. So let's talk about real world impacts that could create. Individuals who are nervous about having HIV and are aware that it is criminalized in the state of Maryland for having it and not disclosing it to your partner would likely not get tested because they naturally don't want to know their status, and then they can be kept out of this law. Sex workers are another great example of individuals that can be negatively impacted by this law and choose actively not to get tested and be encouraged not to get tested for the sake of protecting themselves legally. So if the goal is to end the HIV epidemic, which I believe all of us in this room genuinely want to do, we need to look at these things as the CDC has pointed out, as MDH has pointed out, the largest barrier to testing is stigma around HIV. Breaking down those barriers is critical.
I'm not sure that this law, when it was conceived with the goal of just ending it, I think it was conceived with the goal of preventing the citizens of Maryland to become victims of someone who maliciously knew that they were going to be making someone sick with a disease that it's not like COVID or something else. This is a permanent disease. This is a lifelong disease. It is not the same as some of the other transmissible illnesses. So I think that the motivation may not have been just ending it, but also punishing those who are willfully willfully exposing people, including minors. So I would ask you, would you support a bill that allowed for the knowing exposure of a minor to HIV or AIDS for them to continue to be criminally prosecuted?
I encourage the intent of any organization that means to look at the emotional traumatization because of the transmission of any infection maliciously. So to your point, Delegate, I just would like to reiterate, syphilis is a lifelong disease that can kill you when untreated. Herpes is a lifelong disease that cannot be treated. COVID, to your point about COVID, COVID is a disease that people can obtain and can die from. HIV treated today, you will not lose a single day of your natural life because you are HIV. In fact, if you are properly treated with your antiretroviral medication, you present what's called a 0% viral load, meaning you are untransmissible. You cannot transmit HIV to another individual if you are on proper antiretroviral medication. And so it is not correct that this is of a different caliber. This is of the same caliber, but for some reason is specially called out in criminal code.
I think it's because of the long-term health implications, but I understand your answer is no, you would not support protecting minors from this. Thank you very much, Mr. Chair.
Thank you, Delegate.
Excuse me. Yes, you can go next.
And welcome to Judiciary Delegate Fair.
Thank you,
So,
Delegate.
are you an attorney?
I'm not.
I'm not either. These kind of bills are really interesting, and I think the most important word in this current statute is not the virus, actually, is the word knowingly.
Yep.
It's the mens rea, it's the culpability. Can you tell me in other states, take, for example, the Northeast, states that do not have a law specific to immunodeficiency to virus, what do they do in regard to, and this is where I see the issues more broadly, syphilis or gonorrhea or something more permanent? Is there a provision in those states which governs the knowing or intentional spread of a virus?
It depends on the state. I'll give you some examples. Texas, New Mexico, Oregon, Wyoming, Illinois, Maine, New Hampshire, Vermont, Rhode Island, Connecticut, all are states that have no criminal law or criminal statute in place for any transmission of any disease. Some states, such as Alabama and Virginia, West Virginia, New York, they have laws that mandate that all communicable and infectious diseases are covered in some form or fashion, but I will note that there is a lot to unpack there with language as far as the criminal punishment associated with it, as well as the lengths to which you can claim that this was a knowing or a transfer.
Sure. So I have a constituent who's in this room today. We're going to be talking about different subject matter, but very much kind of like a mens rea question. There was a crime that could not be prosecuted because of the definition of the law. So is your objective to kind of destigmatize immunodeficiency to virus, or are you looking to strike this altogether? Because if you strike this, one day some person's going to come to this committee and they're going to say, there's a person who knowingly and willingly tried to give me AIDS and I have no remedy. So is your goal to have the law apply more broadly, or do you just want to strike this because you don't?
And I think that prosecutors will point out that they have a lot of tools in their arsenal when it comes to this issue. This is one, this specific one, it targets, and again, I consider it to be used as a weapon against certain populations of people. However, in your scenario, depending on the interaction between the individuals, the prosecutor has plenty of tools at their disposal to charge an individual in that specific scenario that you just outlined.
Well, such as what?
So they can charge them for sexual assault. In many cases, in fact, one of the major issues that we face in our society is that prosecutors many times can charge for sentence enhancements as well as for putting an individual at risk, at a health risk. And so there's been numerous, including all the way up to prosecutors charging for attempted murder in some of these situations.
Can you point me to that code?
I can't, well, I'm just saying, I mean, I can't point you to the attempted murder code.
Well,
I can tell you that prosecutors use it as a tool.
And that's kind of the point I want to get at. Like, we tell the prosecutors what tools they have. And it seems like this one's pretty clearly defined, and whether we want to deal with the particular virus, make it more broad, but I'm just concerned that short of this, a person may actually knowingly and intentionally try and communicate this or some other virus, and there's actually no remedy if we get rid of this. So I'm just trying to suss out what your kind of intention are. But if you could forward me the information you have, I'd very much like to read it. Thank you.
Sure, happy to do it. Thank you, Delegate.
All right, we've got Delegate Boucher and then Conaway.
Thank you, Vice Chairman Moon. And thank you, Delegate Fair, for being here in front of the Judiciary. It's a wonderful group of people. You made a very good point about the transmission of COVID. Thank you very much. And I appreciate you bringing up the criminal code of sexually transmitted diseases in other states. I don't know whether I missed or not, but are there any other sexually transmitted disease criminal codes in Maryland?
There are not. Thank you for asking the question. HIV is the only sexually transmitted or otherwise disease that is specially called out in criminal statute.
Thank you for clarifying that.
Thank you.
No more.
All right, go ahead, Delegate Conaway.
Oh, thank you, Mr. Chairman. Thank you, Delegate, for coming, and panel for coming in to testify today. You mentioned the unequal application of this law. Could you speak to that?
Sure. It is, there are plenty of studies which my office could be glad to give to you.
I just want you to speak to it.
Yeah, that outline the fact that it is utilized mostly in low-income communities. It's utilized against Black and brown communities at disproportionate rates to the rest of the general population. And I will say, again, to Delegate Boucher's question about unequal application of the law, it is the only disease in our criminal statute.
Okay, do you think that people who use drugs intravenously, or people who are bisexual, or people who are sex workers, are they affected by this law?
Absolutely they are. Thank you. Again, the word knowingly becomes complicated in your scenarios that you outlined there, because people will actively try not to know to protect themselves legally.
So under knowingly, if a person is taking the medication, and the medication, I've seen it on the television advertising saying that you cannot pass this on. So they might not tell another person that they come in contact with, have sexual contact with, that they were positive, but they have the medication, and then that'll be okay. Is that correct?
Correct. If the individual does not inform them, even when they are untransmissible, they can still be charged under this.
Have you ever heard of people getting pregnant, women getting pregnant when they're on birth control? Does that ever happen?
I believe so.
You don't think that it's a person's responsibility to tell another person? I mean, the two adults will say, I'm HIV positive, but I'm taking medication. Is that what you're saying? You don't think that's a person's responsibility to let another person know where they stand medically?
I believe
before they engage in unprotected or even protected sex, which is not 100%, just not 100% protection.
I would say that I believe that it is also, first of all, use of protection is not an affirmative defense that's been allowed so far. However, I will add that I believe that two consensual partners go into a sexual relationship in their own way, and that it is not our job to step in, our job as government officials to step in between those two individuals. I will mention that it is unique that HIV is called out independently from anything else. So to this end, this bill allows, to your point, for us to have a conversation about my HIV status, but not if I'm carrying syphilis, gonorrhea, any other STD.
Thank you, Mr. Chairman. Just one last thing.
Please.
Do you know that the legislature was shut down basically for 2 years because of the COVID virus?
I worked here. I am aware.
All right. So then you know that there's a responsibility to make people aware of the potential of being caught up in an environment that could negatively affect them. Is that correct?
That is correct on a public health, from a public health perspective.
Thank you very much.
Thank you, Delegate.
All right, we have, thank you very much. We have one person signed up unfavorable. That's, oh, wait, hold on. We have one question from Delegate Valentine. Go ahead.
Thank you, Mr. Vice Chair. I just wanted to go over a couple of statistics. Thank you, Delegate, for being here today.
Thank you.
I believe in the one part of your testimony, you referenced 10 individuals had been charged with this statute in a 3-year period. Is that correct?
That is correct.
Can you give me the breakdown, if you have them, of the individuals charged by their race and their gender?
I actually received that information from the legal analysts in Judiciary, so I do not have that information or the breakdown of the race or gender of the individuals, but I can find out that more information on that. It is on your fiscal note, just so you know.
Thank you.
Thank you.
All right, that looks like the end of questions for the sponsor and witnesses. Now we will go to Vince McAvoy, who is the one person signed up unfavorable.
Thank you so much, committee. I have a new headset. I hope you can hear me okay. Can you hear me all right?
Yes, you're good.
Very good. Thank you so much. As stated, I'm very much against this bill. I find the sponsors' notes on this extremely disingenuous. To look at the bill, what you need to see there is the intentional piece. This was already brought up, but I want you to try and picture how this would work its way through the courts. In other words, the details have to be so present as for a prosecutor to believe that they can realistically make a case, knowing that they're all different types of scenarios, not the least of which is the high partner rate in certain subsectors, which would be a good defense. But I also find this bill, which was withdrawn from a senatorial sponsor the other year, to be disregarding the actual state of HIV very close to us. If you look at infection rate in 2020, DC, of which this sponsor is living in a suburb of, DC has the highest rate of HIV by 3 times. And though not the highest state's rate in the nation, Maryland ranks among the top 5 thereafter DC. This is particularly alarming when you give recent statistics provided by the state of Minnesota. 2/3 of new HIV cases, they listed at 65%, are among communities of color. You just heard testimony that lesbian populations are increasing in HIV. This is not the time for this bill. And the notion that there are other diseases, this is disingenuous. Syphilis gets treated, HIV gets treated, and to Delegate Conaway's point, the issue of not taking a birth control bill, you're talking about HIV positive IV drug injectors taking their dose. This is just silly. I strongly urge an unfavorable. Thank you so much for your time, committee.
Are there any questions for Vince McAvoy? All right, we had one final person, Lisa Jordan, signed up informational. Did you actually want to speak?
Good afternoon, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. In the past, we have certainly opposed this bill. However, it's way past time to repeal this bill. You have the information in our testimony. There certainly are concerns that have been raised. If people want to make the specific intent crime of causing harm to someone else with a disease, you're all legislators. I encourage you to introduce a bill that does that, but prosecuting people for this conduct in this way is discriminatory, and this should be repealed.
Delegate Cardin.
Thank you very much. Thank you, Ms. Jordan, for testifying. Excuse me. Just an expansion of the policy to say, basically, as you indicated, like a specific intent to harm somebody by knowingly doing something not specific to a particular virus, but whether it can be for all viruses. Let's say, for example, I had COVID, I knew I had COVID, I intentionally went over and breathed in somebody's face because I wanted to get them sick. What is your opinion as somebody who's been down here throughout the eons as to whether that's the appropriate public policy, or to just, not deal with the intentional infliction of some sort of harm based on knowing that you have a virus that you can give somebody else?
Certainly, I appreciate the question, Delegate Cardin, and I did speak with a number of other lawyers about whether that scenario that you're talking about might already fall under one of the assault statutes, and I think there's a colorable argument that you do that, but I also spoke with prosecutors who felt that would be very difficult, so it's certainly a reasonable thing, and we absolutely have had cases where someone has said they are trying to transmit a disease to a sexual assault survivor. And so it does appear to be a gap in our law, but this bill is overbroad. It doesn't talk about specifically harming someone. It doesn't, and it's also too narrow in that it only covers HIV, not the many other permanent diseases and infections that can be caused.
Delegate Grammer.
Thank you, Mr. Chair. So if you did go down that route, would you iterate the diseases that you think the law should cover, or would you just focus on the mens rea, the culpability standard, to say if a person intentionally and knowingly tries to communicate a virus, what?
My preference as a drafter would be the second approach, to have it something that was a little bit broader, and that way in the future, you remember 5 years ago we had never heard of
X virus.
COVID,
Yeah.
so it could be a different virus in the future.
All right, thank you.
Delegate Conaway.
Thank you, Mr. Chair. Thank you, Ms. Jordan, for coming in to testify. As you know, we've talked about adult consent of adults questionable while, let's say, maybe being intoxicated, and we discussed the 4th-degree sex offense. Do you think that it's okay for a person to engage in a sexual act with another person without disclosing that they are HIV positive, and it's possible that it could be transferred, even though they might be on the medication and the doctors say it can't be transferred?
I think that's a conversation between those two consenting adults, and certainly if you have that conversation and someone misrepresents, that would be a harm. However, I think that consenting adults also know of these risks and should have that conversation. I would also just further bring the committee's attention to the issue of tort liability, and note that there are attorneys in Maryland who sue based on that sort of transmission, the unknowing engaging in sexual activity when someone didn't tell them they had herpes, for example. So it's not correct to say that there is no remedy at all if you repeal this law.
Okay, so if a person, two adults, one adult asks the other adult, are you HIV or have you been tested HIV positive? Another person says no, and they come to find out that they have, then what does that mean legally, other than a tort? Because a lot of people might not know what a tort is who are listening.
Yes, well, if they're listening to what a tort is, a tort would be a civil lawsuit, and I would dare say that someone would need to prove intentional infliction of emotional distress, which has several different components to it, and so that would be something to consult a lawyer with, and it really would depend very much on the circumstances. Certainly, that's a different bill than the one that is before you right now.
Well, the one that's in front of us now says, or imprisonment not exceeding 3 years. So therefore, if I ask you, are you HIV positive, or have you ever been HIV, diagnosis being HIV positive, and you tell me no, then I come to find out later that the answer is yes. Don't you think I should be able to bring a charge against you?
Not necessarily, Delegate.
Really?
I think under the law that you have in front of you that you're considering repealing, there would have to actually be transmission. Right? And we've already heard several witnesses testify about how
it says attempt to transfer.
Yes, but it does sound like in the hypothetical you have, if you've got someone who's on medication, their viral load is 0, they're not transmitting thing because of the many advances we've made in medicine since this law was enacted, that the one person was not attempting to transmit.
Yes, but you've trained me over the years to be specific and ask you the question of permission. You've come in and testified about spousal permission, so I'm asking about permission on this, and you're beating around the bush, in my opinion. I'm very disappointed at the way that this is going, because if you know that you've been HIV positive and I ask you, then you're knowingly trying to deceive me. Therefore, I do have reason to believe that you're intentionally trying to do something to me, if no more than deceive me.
Well, certainly I agree with you that there is deceit there, and certainly, Delegate, I would never want to disappoint you. It's absolutely a wrong to deceive someone in that manner, but there does seem to be, at least in my mind, a difference between deceit and intentional transmission. Again, perhaps this is a different bill, Mr. Vice Chair.
Thank you very much.
All right, thank you. That's going to end that bill hearing. Thank you. That's the end of bill hearing 287. I guess I'm up with a few, so Delegate Crutchfield's going to take over.
All right, let's give Delegate Moon an opportunity to come forward. Okay, I think if it's okay, Delegate Moon, would you like to have your witness to come up? It's only yourself and another witness that are going to be testifying today on HB 189, and that would be Elizabeth Hillard from the OPD's office. So why don't we just have both of you come up?
Good evening, colleagues. House Bill 189, you can blame this one on the Senate. I'm quite serious about that. So what this is, it's just a small technical correction. The fiscal note in specific says it's a rearranging of words. And the reason for it is in 2021, we passed a bill that was intending to automatically expunge non-convictions after 3 years, but it was flagged for us that the order of the words in which we attempted to make this happen changed how people interpreted this. And so it previously said a crime or a civil offense under 5601, but does that mean a crime, ... or a civil offense under 5601? Or did it mean to limit crimes only to those under 5601? In fact, this automatic expungement law was intended to be broader. It was intended to clear crimes that were not resulting in a conviction. And so this provision of law got miscaptioned by one of the commercial legal text services. And so we were asked to come in and fix this. It's just rearranging the words to get the legislature's original intent in order. So that's the bill in a nutshell.
Okay, thank you, Vice Chair. And Ms. Hillard?
Good afternoon, Acting Chair, members of the committee. We also are here just to blame the Senate. So thank you, Delegate Moon. Now, we also understand that this is having an unintended consequence of confusing the language. We appreciate Delegate Moon for cleaning it up for us and hope that moving forward it can be effectuated in the way it was originally intended. Yeah.
Okay, thank you very much. Are there any questions? I see Delegate Cardin.
To push the button, sorry. Thank you very much for bringing the bill. There's been an issue that I've been dealing with a lot, and a lot of people have come to me and asked regarding automatic expungements that's impacting undocumented immigrants' ability to get proper documentation so that they can get their legal papers worked out. and it has been a fiasco for the criminal defense bar. This is an issue that the chair, I don't think necessarily appreciates as much, because it doesn't involve really the prosecutors. It involves just the folks after it's automatically been expunged. Now they can't access, if they don't know their case number, they can't access documents to prove that it's been expunged, yet INS or other federal agencies may know that they've been charged, but they can't access the information showing that it's been expunged.
So let me just say, I asked Chief Judge Morrissey about this specific issue, and what he said is for many years in his district court and the others, that if they encounter this scenario, they have a pre-written form that says something to the effect of, we can't find this record, it doesn't exist, and the only reason that would be possible is because of X, Y, or Z, that would relate to a valid reason for not messing with your deportation order. Now, what happens after that in the immigration process, I can't tell you, but that's at least what Judge Morrissey's response was to this specific issue. Either way, I'd say this is not a problem specific to this technical bill that we're trying to.
I was wondering if maybe we could use this as a vehicle, perhaps.
I don't think we should do that.
I would be happy to work with you off session to craft something. I've represented numerous immigration consequence clients who have faced that.
Okay.
But I agree that different vehicle might be necessary because it's impacted by more than just this article.
Yeah, oh no, I know, I agree. I
Yeah.
just wanted to bring it up here because it's an issue that somebody's got to start working with, so let's talk about it. Thank you.
Are there any other questions? Okay, well, I think that concludes this bill hearing. Thank you very much. And up again, we have Delegate Moon again.
All right.
All right, Delegate Moon, hold on for a second.
Oh, yeah.
All right, and Delegate Moon, I'm going to go ahead and do the 4 in-person people, which would include yourself, as well as, and sir, what is your name?
My name is Andrew Northrup. I'm with the Forensics Division of the Public Defender's Office.
Okay. All right. Make sure I've got everybody. Let's see. Okay, this is going to be HB 223, and I've got Delegate Moon. Let's see. We should have 4 virtual folks, 4 in person. Let me make sure I've got my other folks. Okay, Mr. Sawyer must be virtual. Okay. Hold on.
Good afternoon, colleagues. House Bill 223 is a bill that actually has been worked on very hard over the last several years by Senator Charles Sidner, and I have partnered with him to try and get this off the ground in the House, and it relates to facial recognition technology by law enforcement You may or may not be familiar with this, but it's quite widely used in Maryland now, might even be used by your local police department. Through the course of policymaking, I discovered that Montgomery County is using facial recognition technology through a private third-party vendor. And to give you a sense of what these capabilities are, that particular vendor, Clearview AI, has downloaded everybody's social media profile, photos, and content across the web into a proprietary database that they then can match other photos against to try and locate people. And in this context, the product is being sold to law enforcement agencies around the country. It has been used in everything to find a bank robbery suspect. I believe the January 6th insurrection charges, many of them came from use of this type of technology, again, matching people's social media info to images of suspects in cases, all the way on down to young ladies being harassed on a bike trail in Montgomery County by someone ripping down Black Lives Matter posters. So that's a range of types of cases that we've seen this deployed in. And the bill would essentially start to ask some questions. What kind of databases should be allowed for this? Those public social media ones, or just the government ones like mugshots and driver's licenses? What types of crimes should this be allowed for? This bill purports to say it should be serious crimes. We shouldn't use this kind of technology for run-of-the-mill offenses. And with the remaining time left, I'll just say this has been a discussion product between both sides, the law enforcement and the defense, for several years, and I think this is the kind of product that ought to hopefully result in a consensus vehicle eventually. And we did exactly that, Senator Sidnor and Delegate Shetty, with forensic genealogy when Maryland put ground rules in place for searching private genetic databases for criminal suspects. So happy to pass it on to my panel.
Thank you, Mr. Vice Chair. And Mr. Northrup, please, for 2 minutes.
Thank you, Madam Chair. Delegate Moon and distinguished members of the panel, as stated, my name is Andrew Northrup, and I am a public defender in our forensics division. Our position on this bill is now favorable since our amendments that we have sent to drafting have been adopted. On March 31st last year, Alonzo Sawyer was arrested and held without bond in Baltimore County for assaulting an MTA bus driver and stealing her phone 5 days earlier. This arrest was based solely upon a facial recognition hit confirmed by his probation agent, a man who had met him only a couple of times, and during those meetings they were wearing COVID masks. He was cleared of these charges only because his wife would not take no for an answer, and you will hear directly from her, Karan Sawyer. How did this happen? The fundamental problem with facial recognition is that we as humans believe that we are good at it. We are not. A 2015 study of Australian passport officers asked to pick out a face in a lineup were wrong 50% of the time, with 80% of those errors being false inclusions. So even if the algorithm is perfect, we are not. In fact, unlike other forensic sciences, analysts in Maryland don't even take proficiency tests when they're engaged in this work. This bill changes that. What is particularly troubling about the Sawyer case is that it occurred in a jurisdiction where the proper procedures were followed and corroborating evidence was collected. In other jurisdictions, as you're going to hear from Ms. Levy, we have seen charges or no-knock warrants issued solely based upon the hit itself. This legislation will set up minimum standards for when and how facial recognition can be used in investigations. It requires additional independent evidence for establishing probable cause. It also sets forth discovery and transparency requirements. Our office still has grave concerns about the use of this technology. My personal fear is that bad facial recognition hits could replace bad eyewitness identification as a major source of wrongful convictions. Nevertheless, this bill is a good step forward to regulate what is currently unregulated. Thank you.
Thank you very much. Let's go ahead with our virtual testimony. We also have now Ms. Karan Sawyer virtually. We have Nathaniel Erb virtually, Deborah Levy, and Russell Hamill. I'm sorry, not yet. Yes, that's all we have virtually. So let's go ahead and start with Nathaniel, if we can.
Yes, ma'am. Good morning. For the record, Nathaniel Erb here on behalf of the Innocence Project. We are here in support of House Bill 223. Importantly, the bill restricts the use of facial recognition to serious crimes while allowing to identify missing children, deceased persons, and for other public safety concerns. For example, the bill allows for the use of tools to identify children who are exploited through human trafficking. That is an important distinction for myself, having served many years as a policy representative of the anti-trafficking community here in Annapolis and nationally. We have three primary concerns regarding the use of facial recognition. Firstly, community agreement to surveillance is not often sought or properly weighed. Secondly, the reliability of the technology is often unclear. If unreliable technology is being used, it can lead to a tunneling towards the wrong suspects. We see throughout wrongful convictions that innocent people can be misidentified and exculpatory evidence is ignored because there is a belief in the means by which the suspect was identified. This is compounded when there is a piece of technology purported to be more sophisticated than a human eye and brain. Lastly, there simply isn't yet adequate training to ensure accurate identifications. What training exists is focused on how to use the system, but not how to ensure the system is functioning properly and not misidentifying innocent people. Currently, facial recognition is being used in Maryland without limits and without oversight. While we do not yet have the trust in these technologies, nor the belief that communities in Maryland had properly been consulted on their use, in order to move beyond our general position of a moratorium, we support HB 223 and thank the Vice Chair and all members of the working group who compromised in its development. The bill is a good step forward, developed by many perspectives, and we urge a favorable report. Thank you.
Thank you very much. Can we have Ms. Sawyer next, please? Unmute yourself. Perfect.
All right, can you hear me now?
Yes, thank you.
Okay, thank you. Thank you, Mr. Chairman and distinguished members of the panel. My name is Karan Sawyer. I am in support of House Bill 0223. On March 31st, my husband Alonzo Sawyer was arrested and charged without bond for 9 days for assaulting an MTA bus driver and stealing her phone based on facial recognition. Those charges carried about 30 years total. He was falsely identified through facial recognition and positive ID match from his parole officer. The person on the photo they identified through facial recognition as my husband had many discrepancies that if law enforcement had done their due diligence would have not arrested or charged my husband. The disparities range from the age difference, height, the spacing in the teeth, facial hair. The officer even said that he questioned my husband in great detail, so he should have seen this. The parole officer that gave my husband a positive ID match only saw my husband twice behind a mask and has never seen my husband standing up. The fact that the court found that sufficient enough, in addition to witness statements that my husband was not at the scene of the crime that day, to hold him for 9 days without bail is still baffling to me. No other evidence except facial recognition and ID match from the PO officer. I had to advocate for my husband, sending actual photos of my husband to the detectives, speaking to the parole officer that ID'd my husband, who after me showing him the actual pictures of my husband said it wasn't him. So I am in support of House Bill 0223. Thank you.
Thank you, Ms. Sawyer. And next we have Ms. Levy.
Thank you so much, Acting Chair. When I last had the pleasure, my name is Debbie Levy, I'm from the Office of the Public Defender. When I last had the pleasure to testify in front of this distinguished committee, I spoke about a case that involved the execution of a no-knock warrant. It was coincidentally that same case that involved facial recognition technology. To get that no-knock warrant, the officers in that case relied on a facial recognition hit. And that began our quest, not just in Baltimore, but all across the state to figure out how is this technology being used and what is the discovery that we should be getting. And I'm focused on the discovery part. What did we find out in our query across the state? We found out that individuals are making identifications using facial recognition without any actual training. In the case in Baltimore, the notification was made over email by an individual who was a research analyst, former parole and probation officer who had no actual training to make that cross-racial identification. The information in that case was withheld from us for over a year. We've also learned that facial recognition technology produces multiple reports. In some cases, our clients are getting a single page request form that will show how facial recognition is being used. In other cases, we're getting a 2-page report to show how facial recognition is being used. And in other cases, we're actually getting a photo lineup to show what hits were generated and what is the percentage of probability that those folks who are identified match the target suspect. We're not getting uniform discovery in any of these cases. Facial recognition discovery ought to be uniform, like DNA discovery, like fingerprint discovery, like blind photo array discovery. Law enforcement is excited about this new technology and they really want to use it. But you can see that the unfettered discretion to use it is producing insanely unfair results across the state. Even the own documents that we got from law enforcement show that this is only supposed to be used as an investigative tool. Complete discovery is required. And even though it says in big bold letters, it's not happening. So we welcome uniform regulations governing discovery.
Thank you very much. Okay, that ends the testimony for the favorable. Are there any questions for this panel of favorables for this bill? No questions. Oops, my apologies. Delegate Conaway.
Thank you, Chairperson. How you doing today? You doing okay?
I am good.
Thank you. I'm glad to see you there. All right.
Well, thank you.
Thank you, Delegate and witness, for coming in today. I was wondering, in Maryland, do you know if the facial recognition is being used to, let's say, scan 695 or 97 just randomly, just to identify people who are going up and down the highway?
I am not aware of that. I've never seen that. I've seen LPRs, like license plate readers, from the roads, but I've never actually seen facial recognition on the highway.
And I'll say I'm learning more and more about different elements to just how deep down the policy road we could go. But something like what you're contemplating would be deploying this technology for real-time use in some way. Like if you were to post something at a stadium gate or on the highway, and it's just checking that. I mean, China does that at crosswalks when you have a social score that'll get displayed to shame you as you're crossing, in certain places, and they're using facial recognition technology, and so they're analyzing your gait and things like this. So there's pretty far-reaching uses of this, but the specific use case that I've at least encountered in Maryland is this whole realm of, after the fact, having a photo or images of the suspect of whatever quality you might have available to you and trying to match them of other databases of known photos. And again, that could be mugshots, it could be driver's license databases, and once you bring the private vendors into it, it opens the world up to any image that might be anywhere on the internet now scraped into a private database. I've said for a long time that this is a very complicated topic, and that it's better for everyone to get around some rules rather than have nothing whatsoever. And in the pursuit of those some rules, I've been willing to give quite a bit of, on the policy, and I think Senator Sidnor and I might even disagree on where these lines are. But what I'll suggest to you is right now we're living in a bit of the wild, wild west with this, where police departments across the state currently are using this with either people who are quite trained in these sort of deploying technology for initial investigatory steps, others who might not be, using a range of different circumstances. Are you validating this with independent investigatory information, or is this the sole information? Real basic stuff, I think, that we use in other parts of law enforcement, I think need to be applied here. And so again, the guiding model you were here for was when we embarked upon just this process with forensic genealogy, because people were getting excited by, you can go on Ancestry.com or 23andMe, and anyone that paid a subscription now, we're going to go find the next unsolved serial killer or what have you. And law enforcement and the defenders came together and put together some compromise to create ground rules something, it's not quite the same here, but this is trying to get close to that, where it was, okay, here are the rules, these are the types of crimes and circumstances we're gonna allow this to be used for, et cetera. We're gonna, and in this instance, there's even more, as you're seeing on the discovery side, we've had problems with some of the early deployments of this technology for being accused of misidentifying certain racial groups at much higher numbers than others, again, depending on how often, when was this data validated, what was the source data that you used, was that source data representative of the suspect's demographic?
Okay, Delegate, you used your 2 minutes. So who is authorized?
Okay.
Who's authorized?
Delegate Conaway.
Second bite. So who has authorized the law enforcement to currently use the facial recognition?
Well, nobody. And I'd say in some ways that was our choice, because you might also remember the same Senator Sidnor, when he was a delegate, had a bill in that tried to suggest law enforcement needed to put these technologies before a public disclosure process before deploying them in our communities. We had that with stingrays and so forth. So
Police body cameras. Thank you, Delegate.
Yeah.
Thank you. Okay, I see some more questions, so we'll go next to Delegate Boucher, and then Delegate Simmons, and then Delegate Arakan.
Thank you, Chair Crutchfield. And thank you, Delegate Moon, for bringing this forward. I think you already alluded to the answer I have is, are you aware that the Chinese Communist Party depends very heavily on this technology, completely unrestricted?
I think it's an interesting use case in the world, and so we should be aware of those use cases as they try to bring them into our communities with no regulations whatsoever.
Thank you very much.
How you doing, Vice Chair? Just wanted to ask you, pertaining to our gaming venues here in the state of Maryland, the casinos and so on, do you know of any technology being currently used in those events?
I suspect they are using exactly this kind of, that a lot of private institutions are using some of this. And I think I don't know if it's the feds, I assume it was the feds and not the airlines, but at airports, they're beginning to deploy this as alternatives to, paper and things of that nature, boarding passes, just walk through and knows who's coming
What
through.
about Maryland Live or any of those type of events?
I suspect they are using this technology, yeah.
Thank you.
All right, Delegate Arakan.
Thank you, Madam Chair. Thanks for being here, Mr. Vice Chair. Can you just touch on what some other states have done in terms of a compromise of some kind between the two parties? Have any states successfully navigated this yet?
That's it. I couldn't answer that, to be honest. I'm unaware of what accords were reached. But that's why I say, at least in Maryland, we do have a decent template for how to approach ground rules, since we literally just did this recently with the forensic genealogy.
Yeah, it did take us a few years and a lot of meetings, but yeah. All right, hopefully we can get there.
All right, any more questions? Oh, Delegate Bartlett.
Thank you, Madam Chair. My question is for Mr. North.
Yes.
So as it stands now, Facebook, at least Facebook, I don't know who else, uses a form of facial recognition.
Mm-hmm.
Okay. And is that a similar mechanism that is currently being used with respect to law enforcement?
That I am not sure of. I know that Facebook does have these algorithms that will do that, but I also think they rely upon other information sort of to provide context so that they sort of get it closer to the actual match.
Okay.
However, I do think that just the way that it looks like is Ms. Levy showed you what happens when you run a face through facial recognition. And part of the problem is there are no standards of what actually gets entered into the database. And as we all know, you've seen surveillance footage that can range from crystal clear to very, very grainy. And so, but there's no standards of what can actually get uploaded. And when you upload something, what you get typically are, you get a number of images. It's like a fingerprint, like APHIS, where you get a number of fingerprint matches. You'll get maybe whatever the limit, the cutoff for the candidates are, but I mean, sometimes you'll get like 8 to 20 candidates, something along there. And then it's up to the individual then to look at these and determine if any of these are a match. And that's
Okay.
also a real problem because we're very bad at this.
Okay, so now you're going to where I wanted to go.
Okay.
So we start with some type of AI tool to get the information, is that right?
Yes.
Okay, and then from there, we rely on human analysis to pinpoint
That's
an
right.
individual. Okay, can you tell me the accuracy, percentage-wise, with respect to the recognition of individuals who are non-white?
Are you talking about for the algorithm or for the human beings?
For the algorithm first, and then human beings.
Okay, well, first of all, again, because this is such a new area, coming up with firm numbers on that are very difficult.
I didn't know if studies had already done the work for you or not.
Sure, I mean, there are some studies out there, and I'll say that in terms of the algorithms are actually getting better. They used to be terrible, but they've actually gotten a lot better in the last few years, and NIST, National Institute of Standards and Technologies, runs different programs where they sort of test these different algorithms, and they can be pretty accurate in terms of making sure that the actual target image is in the candidate list. But whether it's first or second, there's a lot of variables that go into that, particularly when you've got the questioned image can vary so much. But then the second question about how good people are at this, imagine all of the issues that we have with eyewitness identification. And this is exactly what we're dealing with this. So, for example, transracial identification, which we know causes huge problems in eyewitness identification. That problem still exists here. And the other thing is that because photography has only been around for about 100 years, we as human beings haven't adapted that facial recognition sort of gene, as it were, yet. Because when we look at people, we learn to identify them by their height, their weight, their body movements, things like that. So the notion of facial recognition, we're still in its nascency. Frankly, we're still trying to understand it. The one thing that we do know, though, is that a person's ability to recognize a face typically doesn't get better with experience. It doesn't necessarily get better with training. It's one of those things you're either born with or you're not, which is one of the things that's really important in this bill to have proficiency tests so that we know how good the people who are doing this job actually are at doing it.
Okay, Madam Chair, may I ask a quick follow-up?
Yes, you may.
So are you familiar with Mr. Sawyer's case, or should I ask my question directly to Ms. Sawyer?
She is more familiar than I am, and I will tell you, quite frankly, this was not my case. I came upon this case, I was talking to a colleague about a case, and she just sort of mentioned that this had happened. And I was just like, wait a second, what did you just say? And that's how I sort of got involved in it. And so basically, I found out about this case in December, that it had happened in April, or in March, and then he was released in April because Ms. Karan was such a very good advocate for him.
So I guess what my question is for either you or Ms. Sawyer is, was it a situation like Ms. Levy is describing where there were several individuals who were in, for lack of a better word, an array, because I just don't know what else to compare it to, and they said, this is the person, or was there just one specific person who was identified through facial recognition?
Well, here's the way that it works. Like I said, when you run this thing through the program, what it comes up with is a list of candidates. Since I was never on the case, I never got the discovery on the case, and quite candidly, the attorney who was on the case, I spoke with him, he never got the discovery because the case was dropped before discovery was tendered over in terms of the process. But the way that these things work is you come up with a list of candidates, and it's up to the human being to make the identification among that list.
Mm-hmm. So, Ms. Sawyer, I saw you shaking your head, though. Is that what happened with your husband's case? You're on mute.
Ms. Sawyer, you have to unmute yourself. Thank you.
I'm sorry. Yeah, in my husband's case, they identified him through facial recognition, through an old photo, and said it was him. But in his case, the police officer that actually interviewed him actually saw his face. So the picture that they showed us of the person that they were saying was my husband was about 20 years younger. My husband at the time had facial hair, mustache, beard. This person in the photo did not. My husband has spacing in his teeth. This person did not. So if the human person had looked at this and said, okay, this is not even a person. this is not him, but you're sitting there looking at my husband in this photo and saying that they are one and the same, and they were not.
Okay. Thank you, Ms. Sawyer, for being here. Thank you, Madam Chair.
Sure, thank you. Any other questions for this panel? Okay, thank you very much. We're going to go to the next panel with one unfavorable, and that's Mr. Hemmel. If you'll go ahead with your testimony for 2 minutes.
Good afternoon. I just want to make sure you can hear me.
Yes, we can.
Thank you. So good afternoon, Acting Chair, members of the Judiciary Committee. Thank you for this opportunity to address the committee today, and at least I know which committee I'm in front of now. I'm Russ Hamill, and serve as the current president of the Maryland Chiefs of Police Association, representing chiefs as well as sheriff associations today. And both those associations currently and respectfully oppose 223 as it's currently written. But to be clear, the Chiefs and Sheriff Associations fully support strict guardrails and audit protocols to mitigate the risk of impartial and biased law enforcement and misuse of this technology. Frankly, Ms. Sawyer's husband's case is horrifying to me, and we agree on uniform regulations and discovery protocols, as Ms. Levy discussed. We need to sit together to develop appropriate protocols for personal liberty and the public safety working hand in hand together. As currently drafted, there are several provisions that we think would hamper or adversely impact public safety in Maryland, limiting types of incidents to be investigated. We believe that probably needs to be expanded to more include more serious crimes endangering the community. We believe the technology has also been used to identify missing persons, deceased persons, incapacitated persons who can't identify themselves, and we believe it should be expanded further in those regards to help law enforcement aid these such vulnerable populations. Limiting the databases concerns us as well, because we're looking at missing children, human trafficking victims, and missing adults. We believe there's further technology out there that can help, including sex offender websites, the National Centers for Missing and Exploited Children, persons images, and wanted posters and others put up by members of the community and families. Facial recognition is a valuable investigatory tool. Safeguards in place for government's use of this technology. We believe we'd like to work together to further adjust this to meet public safety needs, and would be anxious to do so with Delegate Moon and other representatives. Thank you for this opportunity today.
Thank you, Mr. Hamill. And then I have 2 in-person unfavorable testimonies. I have Mr. Schallenberger that we'd like to bring up, and also Mr.
Picerno, yes, ma'am.
Okay. All right, Mr. Schellenberger, if you're ready, let's proceed with you first. And I understand that Mr. Picerno has, I guess he's favorable with, or are you favorable?
I think technically it's favorable with amendment.
Okay, so we'll hold off for you. So we'll let Mr. Schellenberger go.
Madam Chair, thank you so much. First, I would like to say I deeply apologize to Mrs. Sawyer and her family. I'm the only thing that makes me glad is that it happened in 9 days, but 1 day is too many. And so we need to do a better job. Number 2, I thank Delegate Moon greatly. This bill has changed a lot in 4 years. We're getting really close, but we're not there yet. Some of the things I think we have to remember is I put in my written testimony one of my first cases back in 2015 where two individuals robbed someone, and we got to one of the robbers through use of facial recognition technology. It's a very effective tool. I have been told, I don't know the exact numbers, but I have been told that many of the individuals arrested as a result of January 6th were identified because of facial recognition. And that certainly was one way to do it. And the reason why limiting the use to just driver's licenses and mugshots are because, social media, there's a lot of people who aren't on either one of those who are also on social media. And it's my understanding that law enforcement, the FBI, used facial recognition through social media, and that's how they got a number of the individuals caught in January 6th. The other problem I find that we're down to is the completely outlawing live facial recognition. When you're looking at a riot or looking at an outburst,
The police need all aspects of technology to try and identify people. And certainly being able to do something like that live on January 6th would be a very important tool that you would be taking away from the Maryland individuals. Please remember, with regard to Mr. Sawyer's case, it operated the way that this statute is set up because it was verified by an individual. It's just that individual was wrong. And I wish we had could have moved faster. But at any rate, we are so close. And I worked with everyone on genetic genealogy. We were on that one. We've been working tremendously with Delegate Moon. We've come so much farther than we were. But those two issues, being able to do live under certain public safety information and also being able to expand into social media, not limiting us to driver's license and mugshots, are the two last changes. The rest of this bill, I accept. I agree with. We are so close to being there, and I thank you so much for the extra time.
You're welcome. Thank you. Okay, so are there any questions for Mr. Schellenberger or Mr. Hamill? Okay.
We haven't heard from
we'll hear from you separately, okay? Because you're, okay. All right, so were there any questions? Delegate Conaway?
Thank you, Chair. Thank you, Mr. Schellenberger, for coming in. So in reference to the live feed from January the 6th, how would that work? Would you scan everyone's face in the audience before what you consider violence started happening?
I think you'd be limited to those who had broken the law, which means those who were in the Capitol.
So once law enforcement identifies that a member of a group of people has broken the law, then you would start the facial recognition to scan the whole crowd so you could identify who was doing what?
Right, the individuals who have broken the law. So here's a perfect example. In your bill, it says that if people are lawfully protesting, that you can't use it. I agree with that.
Yes.
And so, perfect example is January 6th. When they were outside having the speeches, law enforcement, in my reading of Maryland law, would be prevented, would not be allowed to use facial recognition because that was a lawful assembly and those exercising their rights. They could only use it when they've broken the law by entering and trespassing in the Capitol.
My question is, could they use it on the people that are inside the Capitol, outside the Capitol, or both inside and outside?
I would say inside because you know they have broken the law.
Thank you very much.
All right, any other questions? Okay, Delegate Bartlett?
Thank you, and thank you, Madam Chair. Thank you, Mr. Schellenberger. I have a question regarding the secondary nature of the information that was obtained from January 6th. So a lot of people who were there posted on social media. And so I don't know, perhaps you know, how many of those individuals were actually identified by their post on social media versus how many people might have been identified through the camera system of the Capitol itself.
I don't have that information. I can tell you that what they did was they used the facial recognition to focus in on the social media, and then they used good old-fashioned police work. All these cases require good old-fashioned police work after you get the hit. This is no different than 30 years ago saying, go to the precinct and look at 5 mugshot books. It's just now we're doing it so much faster with a computer, but this statute would require a person to make the identification. All right, here's the person on January 6th, and here's what their social media looks like, and they have to put them together. And the statute requires that you can't just rely on facial recognition technology.
And your bone of contention with the proposed legislation again
is that it would prevent us from using it in live situations. So in other words, if this bill were law in DC on January 6th, you could not have used it on January 6th while it was going on. You would have had to wait till January 7th.
I see.
And that is how they used it, predominantly.
Thank you.
All right, are there any other questions? Okay. Delegate Arakan.
Thank you, Madam Chair. Thank you so much, Mr. Schellenberger. It is really, really good to see you here, and I know the people of Baltimore County will agree with me.
Thank you so much.
Yeah. So I was just thinking while I was hearing this, is there any restriction currently on private industries using this? It feels like this is geared only towards law enforcement, but a private contractor could technically be doing the same thing, wouldn't be captured in this bill. Is that right?
That's correct. In fact, I don't know for sure, but I know pretty strongly that when you're walking in the airport, you're being checked. When you are, I absolutely believe if you walk into Maryland Live, you know, you're being checked. There is no restriction on private industry using this. Delegate Moon, I think we at one point, one of the original bills was trying to regulate private industry, and I had a lot more people sitting with me to help me when I was opposed to it back then. So this is being utilized in a lot of places.
Okay, that's good to know. So hopefully we can come together. You wouldn't happen to know if there's any other states that have sort of already navigated this successfully, have you?
I do not. I know that we were one of the first on genetic genealogy, and I'm still tired from that.
Yeah.
And I think we're getting really close here. I don't know if we'll be the first, but we'll be near the top.
Awesome.
And I'm certainly willing to work with all of you.
Great. We appreciate you. Thanks,
All
Madam Chair.
right, and we've got Delegate Boucher next.
Thank you, Chairwoman. I noticed in the testimony that the Department of State Police says that they support some additional amendments and were willing to work with Delegate Moon on it. Would you be willing to team up with the state police and bring those potential amendments to his attention and work on them?
Absolutely. I've worked with Delegate Moon on other things. I'm happy to do that and bring the state police's ideas along.
Good. I'd like to see a unified front. Thank you.
Okay, I see no other questions, and we'll go ahead with you, sir, with favorable with amendments.
Good afternoon, ma'am. Good afternoon, committee. My name is Nick Pacerno, and I'm a captain with the Montgomery County Police Department. I am one of the authors of our facial recognition policy, and I maintain oversight of our facial recognition capacities. There are many facets to this proposed legislation that are in line with best practices, facets which exist within our current policy. I wholeheartedly agree that facial recognition should never be used as an element of probable cause in a charging document or search warrant affidavit. Facial recognition should solely be used as an investigative lead that requires independent, separate corroboration. Essentially, it should be treated much like an anonymous tip. My concerns are limited to 3 elements that are also raised by the Maryland chiefs and sheriffs. Those concerns are restricting the types of crimes where the technology can be used, restrictions limiting the softwares that can be used, and restricting the pool from which comparison images can be pulled. Like the proposed legislation, Montgomery County Police policy also limits the type of crimes that facial recognition can be used for. However, unlike this bill, our policy permits the use of facial recognition in crimes involving firearms possession, weapons on school property, child pornography, subjects involved in organized crime, hate bias incidents, domestic violence, cruelty to animals, crime trends, suicidal subjects, and identification of witnesses in those crimes. So when a subject assaults a child hanging flyers on the Capitol Crescent Trail, or when a child was being abused on a TikTok video, or when a subject indecently exposed themselves on a doorbell camera, we were able to use facial recognition to establish an investigatory lead, resulting in identity of victims or suspects. The proposed legislation will restrict its use in these cases. Limiting these technologies to one source acts as a barrier to competition in the space. Competition between technologies pushes innovation and results in better products. Having technology meet certain standards, such as NIST validation, guarantee effectiveness that would better ensure law enforcement using quality products compared to one vendor. Finally, I also note that overregulation of the space could result in technological vigilantism. Facial recognition platforms are no longer expensive. They can be available for around $250 a year. If crime victims can't rely on law enforcement with their images, the private sector will step in, resulting in unvalidated anonymous tips to the police. I ask you to keep these concerns in mind as you consider this legislation. Thank you.
Thank you. Any questions? Okay, I don't see any questions for you, sir. And thank you very much for this last panel. And I think that concludes our testimony on HB 223. Next up, again, is Vice Chair Moon with HB 193, which is probation before judgment, probation agreements. And let's bring up with you Vice Chair Moon, Let's bring up Brian Zavin. Let's bring up Gabrielle Carrell. She's here. Let's see. Let's bring up John Gossart.
I work hard for early bill hearings.
John Gianetti, if he's here.
Madam Chair, I represent a group, and we brought an attorney from that group. That person.
Okay, are you representing MCDAA?
I am.
Sure. How many?
Mr. Wooten, I've already gotten the permission from the chair.
Okay, that's fine.
And
Okay.
Madam Chair, we also have the Prince George's County State's Attorney with us, who is on limited time, if we can get her on the first panel.
Sure, okay. So let's change this up just a little bit then. Let's bring up the Prince George's State's Attorney. Let's see, do we have enough space up there? How many folks do we have?
We'll make space for her. Please.
Okay, perfect. Okay, let's go ahead and do that. Let's make this our first panel, and then we'll come back and pick up the others, okay? All right, go ahead, Vice Chair Moon.
Thank you, Madam Chair, colleagues. Many of you who are here will recognize this bill, as well as its previous sponsor, our friend, former Delegate Juanita Fisher, who has left us for the County Council. So I hope I do justice to the bill this time around. But HB 193 is, in short, about keeping families together. It is known as a PBJ reform bill, particularly geared towards stopping unintended consequences for folks. So here's the issue in a nutshell. You have someone who takes a PBJ, it might be for a pretty petty offense, and they're sort of unaware, for whatever reason, their attorney might not have apprised them of what was going on, that downstream you might have some immigration consequences if you are a non-citizen. And that might be true, again, not even for undocumented residents, just people who might be here on a student visa, an H-1 visa, we don't know. But you have some minor run-in with the law, and now you're facing a PBJ situation. And all parties agree that this is a slap on the wrist. They are not intending to ruin your life, have you separated from your family and shipped off to another continent due to this minor thing. But here we are some time later, because for federal immigration purposes, the PBJ is treated as a conviction. So Virginia has handled this with an alternate PBJ mechanism, and we are attempting to bring that to Maryland. It's been looked at by many eyes from all sides of the equation. I think we got pretty close under Delegate Fisher last year and her Senate counterparts at getting this thing across the finish line. And you'll hear from a series of people today to talk about why it's important to have this humane alternative that keeps families together. So with that, I will turn it over. Thank you.
Thank you. Go ahead.
Thank you so much, Madam Chair and members of the committee. For the record, my name is Aisha Braveboy, and I serve as State's Attorney for Prince George's County. I believe that my office has testified on this bill 3 times, so we're hoping that the 3rd time is the charm. So we look forward to working with this committee to ensure that this bill is passed. As was mentioned by the sponsor, and I want to thank the new sponsor of this bill, when a PBJ is entered, it is entered because there's a recognition that a permanent conviction is not the best solution for that particular defendant. However, because of the immigration status of some, and even for residents and people who are legally able to be here, there may be still consequences for the admission of guilt and the finding of guilt in a court of law for jobs and other purposes. And so it's really important that, again, the punishment fits the crime. And when a PBJ is recommended or agreed to by the court, that means that the court recognizes that that individual may need support, may need counseling, may need drug treatment or some other type of interventions. And if they don't commit any further offenses, then they are really should not suffer any additional consequences. But because of that finding of guilt that is required in a PBJ currently, it does create a framework where there are collateral consequences for people that may be rather extensive and too harsh for the type of crime that was committed. So for these reasons, we ask that this committee this year adopt this bill and move it favorably. Thank you so much, Madam Chair. And if I could, because I do have to leave, I'm also here to testify on House Bill 330, sponsored by Delegate Williams. And that is a prosecutorial initiated reconsideration bill, which would give prosecutors the ability to ask for reconsiderations of sentences. That would be up to the discretion of that prosecutor, so would not require prosecutors who are not interested in these types of cases to have to do it. But it does give us a tool to ask for reconsiderations of lengthy sentences where defendants are fully rehabilitated. And my members of my office are here and will be testifying on that bill when it is called. I do apologize that I have to leave. Thank you.
Thank you very much, Madam State's Attorney. You may proceed.
Good afternoon, Chair, Vice Chair, and committee members. My name is Gabriela Kersia Carl. I'm a professor at the Maryland Carey Law School Immigration Clinic, and I ask for a favorable report on HB 193, a bill which eliminates the unintended consequences of probation before judgment. The Maryland Probation Before Judgment statute became law in 1975 when this General Assembly recognized the need for a disposition that would allow first-time offenders of minor crimes to take responsibility for their mistakes without saddling them with the stigma and collateral consequences of a criminal conviction. Since 1975, however, the federal laws and regulations have changed considerably. One of the consequences of that is that the Maryland PBJ is treated as a conviction under federal law, notwithstanding the Maryland General Assembly's intent to the contrary. This problem came to our attention because it was harming our immigrant clients, leading to unintended detentions and deportations of lawful immigrants, separating them from their U.S. citizen families. Since then, though, we've learned that the Maryland PBJ doesn't just harm immigrants. It also harms people who work for the military, those with security clearances, often veterans employed in jobs that depend on that very clearance. This bill proposes a simple solution: amend the statute so it includes another way of getting a PBJ that won't trigger the federal definition of a conviction. This bill fills an important gap in Maryland law. All other dispositions available, nolo contendere, not guilty, agreed statement of facts, offered pleas, they're all deemed convictions under federal law. This bill will contribute to the finality of judgments in judicial economy. There will be no need to undo unjust pleas if they're entered fairly from the outset. The bill before you today was developed in coalition with the Office of the Attorney General, who supports the bill, the state's attorneys, and other legal experts, and enjoys broad support from various organizations and government entities, as reflected in the written testimony and in the witnesses you will hear from today. And while we believe that this bill as is written today is consonant with Maryland law and due process, we continue to be open to making adjustments to ensure that this law is easy to follow and entered properly. And just one final thing, Justice Marshall said, you do what you think is right and let the law catch up. And what we need here is for the law to catch up, and we need your help to do that. Thank you.
Okay, next, please. Thank you. Someone will have to shift to, okay.
Good afternoon, and thank you for the opportunity to testify before the committee again. My testimony today is like others. It's about fairness, it's about justice, and it's about treating all Maryland residents and citizens equally. My name is John F. Gossard, Jr. I'm a retired United States immigration judge. I sat on the bench in Baltimore for 31 years. At my retirement, I was the third most senior judge in the United States. I tell you that so that you understand my experience, my insight, and the validity of my testimony. I have filed with you my written testimony, which speaks about why Maryland probation before judgment, not a conviction under Maryland law, is a conviction under the federal definition of conviction, and therefore has consequences to the immigrants in the state of Maryland. I want to share with you a story. Darrell was a lawful permanent resident, a green card holder here in Maryland, married to a United States citizen. He had 2 United States citizen children. He and his wife were gainfully employed. They owned a home. They paid their taxes. They had high regard and a good reputation in their community. Unfortunately, Darrell made a mistake and was charged with a minor offense, his first and only offense. And like a first-time offender here in Maryland, he was able to receive the benefit of probation before judgment. But because Darrell was not a citizen of the United States, he was subjected to the federal definition of conviction. I was required under the law to order him removed and deported from the United States, a permanent banishment and a permanent separation from his United States citizen children and spouse. How tragic, how unnecessary, how unfair, how wrong. Darrell is one of many Maryland immigrants who have been deported or have been subjected to adverse consequences. Your bill will allow these individuals a second chance. May I just say this? Darrell's wife wrote me a letter. Judge Gossert, you have ruined my life and the lives of my children. May God forgive you because I cannot. While correct under the law that day, I did not do justice. I asked for justice with a favorable recommendation of House Bill 193, and I thank you for your indulgence.
Thank you very much, and you may go ahead.
Good afternoon, Madam Chair, members of the committee. I am Brian Zavin. I'm the Chief Attorney of the Office of the Public Defender's Appellate Division. House Bill 193 provides a much-needed correction to Maryland's probation before judgment, or PBJ statute, and the public defender urges a favorable report. The other witnesses you've heard from discussed why the law needs correcting. I'd like to address how the law will work if it's enacted. The key takeaways are that it will be easy for our courts to implement, and that for purposes of Maryland law, it will function the same as current PBJ. House Bill 193 spells out the procedure in detail, but to the extent that there's confusion, the proponents are happy to add any helpful clarifying language. In practice, it will work as follows. The defendant will enter a not guilty plea. If the court is open to it, the court will then hear a proffer of facts, as it would do if this were a guilty plea or a not guilty agreed statement of facts. And if based on the proffer, the court finds there to be facts sufficient to support a guilty verdict beyond a reasonable doubt, and that a PBJ is in the best interest of not just the defendant, but the community, the court may then enter an agreement with the defendant under which the defendant will provide an on-the-record waiver of rights, trial and appellate, and will agree that the court will defer making a finding of guilt, a verdict, in exchange for the defendant's agreement to complete probation. And the defendant agrees further that if there's a violation of probation, the court may enter a verdict at that time and impose sentence accordingly. That's it. Courts already make findings based on proffers of fact in the context of guilty pleas and not guilty agreed statements of fact. And courts already impose probation and probation-like consequences on pleas other than guilty in the context of NOLO pleas and no process and stets with a requirement of drug or alcohol treatment. What's needed, what ensures that the defendant's rights to due process are protected, is the requirement that the defendant give consent and give a knowing and voluntary waiver. Other than that, this is a PBJ in all forms for purposes of Maryland law. The public defender urges a favorable report.
Thank you very much, and sir, you're next.
Thank you. Good afternoon. David Wooten on behalf of the Maryland Criminal Defense Attorneys Association. I work at, I'm a partner at Jessica Moise in Wheaton, Maryland. I speak fluent Spanish. I'd say about 60% of my clients are Hispanic. Maybe 99% of those are not United States citizens. And so we're talking about absolutely from, as I was hearing before, people on tourist visas, people with DACA, people with green cards, people with TPS, people who've been here since 1999, 2000 on this very delicate executive action visa, but they're legal, they're working, and they get it ripped out from under them. Prosecutors are not immigration lawyers. Judges in district court do not have to be immigration judges. And so what this does is it takes away that vagueness from people who, they shouldn't be required to know all the intricacies of immigration law. And they're trying to treat people fairly and the same. And so when I'm coming, and I have the benefit of having one of the best immigration attorneys in Maryland in my office who I can harass and call every day and ask, most people don't have that. In the hustle and bustle of district court, they don't have on-call immigration advice. We go into court every day, 4, 5, 6 different clients, traffic cases, misdemeanor cases, and people just don't have the ability to maneuver intricate immigration law through district court. I had a a student visa, American University undergraduate. She was just at the point of graduation last May. She got into a fight with her boyfriend. There was no getting past the prosecutor. It was no, PBJ, we'll give her a PBJ, but we're not budging. And the boyfriend was showing up to court, and he was angry, and so she got her PBJ, and she will not be able to come back to the United States. It's just unfortunate. DACA, a single mom. She is a DACA recipient. She is legally working. She has a good medical billing job. Now she doesn't. And now she's an undocumented immigrant with a U.S. citizen child. Thank you.
Thank you very much. Are there any questions for this panel? Delegate Hardin, please.
Thank you, Madam Chair. Thank you for bringing the bill, Delegate Vice Chair. You know this is important to me, and I love this bill. I think it was House Bill 559 last year. Is that correct, Anika? It passed the House and the Senate. Is that correct?
Yes.
Yes, it had a late death.
Okay.
As these things go.
This, I guess this question is for the professor from University of Maryland, or whomever might want to ask. But you spoke a little bit about how this doesn't just impact immigrants, that there are other consequences to military folks and other folks. Is it true that the intent of the legislation originally passed in 1975 was to make sure that people could continue life as if they did not have a conviction?
Yeah, I think assuming that they complied with the terms of their probation and were rehabilitated as a consequence of it, got the support that State's Attorney Braveboy alluded to that many people do need to get through whatever it is that precipitated the criminal conduct that resulted in this offense. Yes.
So let me give you an example. I'm a contractor, a defense contractor. I work on Fort Meade. I have security clearance. And I got into trouble, and I say to the judge, I am willing to do, and the judge agrees that I am, maybe the judge that I'm a good candidate, a good risk to do whatever you're requiring me to do to show that I've corrected whatever the mistake was. And however, I just need to make sure I don't have the conviction so I can continue to work helping make sure that our Fort Meade is working smoothly and keeping people safe. And the fact that, and that's the intent of the original intent of the legislation. And what's happened is that is not happening anymore because of a quirk in federal versus in a conflict of state federal law.
You got it exactly right, Delegate.
Okay, so what would be the reason, this is really the last question, what would be the reason why somebody wouldn't want to allow this bill to pass? Why would anybody oppose this legislation?
That puts me in an awkward position, Delegate, as I find
You're
it hard
a lawyer.
to imagine myself. However, I believe that it is true that the Administrative Office of the Courts did write a letter in which they kind of drew out some of their concerns. I think the concerns that they did bring to our attention are concerns that actually we have already addressed through some line item edits. For example, they were concerned about making sure that the finding that the court made when this PBJ was entered was one that was made beyond a reasonable doubt, and that's a language that we could, for example, very easily add to the statute. So the concerns that they raised are ones that are fixable, and the intent of this legislation can still exist with those edits. So I think any opposition is addressable and fixable, and like I said, we are very open to making amendments that would allow this bill to become law.
Thank you very much. Thank you.
All right, Delegate Tolles, next.
Thank you so much. I, of course, want to shout out Juanica Fisher, my good friend, dear sister, little sister. I told her she can't leave. She just keep coming back, but we will take it. I know the county council, it's no fun over there right now. I can say that being a former council member. So with that being said, I do want to also recognize the Vice Chair Ways and Means, our chair of the Legislative Black Caucus of Maryland. So I don't know if she's testifying, but I did have some initial reservations, but we supported this bill in the Black Caucus, supporting ensuring that we have some equity and fair treatment. So because this is the Black Caucus, I have a question because I'm referring to the bill being supported by the Black Caucus. I want to ask a question to the law professor regarding the support for Black immigrants and how they have been impacted by the current law and how this new bill can help with that effort, improving, equity for them in the legal community, in the legal system.
I thank you so much for that question, Delegate Tolles. The problem with the PBJ originally came to my attention when I was representing clients, immigrant clients who were in detention. And I would say that 99% of them with PBJs were Black immigrants. And that's because Black people are more likely to be over-policed, over-prosecuted, and also to then, as a consequence, end up with something like a PBJ for even minor crimes, just to put the case behind them and to move on with their lives. It's easier than fighting it, they're told, and that is often true. However, because they are Black immigrants, this PBJ put them in detention, and that ICE detention, and that is where they met me. And more often than not, I was able to work with the prosecutors to resolve those cases. But in the meantime, these people, some of them very young people, because it's often the young people that make the minor mistakes that get the PBJs, would spend a year or more in ICE detention. And these were sometimes very young people. The youngest was 18 years old. He was a boy from Baltimore City. He didn't even know, because he came here when he was 2, that he was from Liberia. And he ended up in ICE custody in upstate New York, because it's a federal system, so of course he could be taken anywhere, and he was away from his parents, from his siblings, for an entire year, and that's how long it took me to fix his case, even with the prosecutor willing to agree to it. So this bill, for me, is a Black immigration bill. It is about Black people, because those are the people who are suffering the harshness of the consequences the most. They're punished by the criminal justice system, and they're punished by the immigration system again. And the immigration system is notoriously unfair to Black people. They are less likely to win their immigration cases. They are more likely to suffer mistreatment in detention. This is all well documented by studies and reports that I would be happy to share, well, unhappy to share, but can share with this committee. So I cannot stress enough, and this is such a big reason why Delegate Fisher's leadership was so important on this bill, because she really understood this, and I know this was very important to her, and I'm happy to answer that question. Thank you.
Thank you, Madam Chair. Just have another quick comment. Thank you. So just want to thank you for meeting with me and stating that, because we don't want to leave out, the Black immigrant community in this conversation. So I thank you for that. And also thank you for referring to the young kid as a young boy, because when you're 18, you are young and you're not, to be treated like you're an adult. So I thank you. I know we met, we had opportunities to meet. So I thank you for that, and how this can create a domino impact on young people's lives. So fixing this now will make a difference in the future for them. So thank you again, and thank you, Madam Chair.
And
thank
isn't
you,
that so?
Isn't that so? Reason, be quiet.
No, that's not, since we're asking questions. You got it.
Thank you.
All right, Delegate Arakan, please.
Thank you, Madam Chair. This is for the Vice Chair. So I'm just reading through Chief Justice Vader's letter, where he suggests to use sort of a mimic of the Virginia statute, because he had some concerns about the court being tied to the plea without being able to make sure that there was compliance. Is that one of the things that you're going to be addressing in the edits to the bill, or?
I have not had a chance to look at the Chief Judge's letter, so I'll take a look at it after the fact. But I will just say they've been well aware of this effort, as they are, this has been moving for years.
Yeah, well, he's new, but yeah.
Yeah. I mean, but the bill has been around for some time, so I don't know. I can't prejudge exactly what sort of final tweaks will be made before it is codified, but I would promise we will take a look.
So it's still a work in progress, though.
Well, it hasn't passed yet, so.
All right, thank you.
May I answer that question, Delegate?
It's up to the chair.
Chair?
Yes, go ahead. You may comment.
That isn't the intent of the bill. We wouldn't intend to bind judges in this. To the extent that clarifying language would help, we'd be happy to put that in. The intent of this is that the judge would only come to an agreement with the defendant if the judge first determined that it was in the best interest of the defendant and public safety, and that's already in the statute regularly for PBJs. And second, that the judge would hear the proffer of facts and determine that this was an appropriate case for a PBJ. So the judge would not be bound to give this type of PBJ unless the judge determined that it was appropriate in that particular case.
Okay, so your intent of the bill is actually to get closer to that deferred disposition that Virginia has, that structure?
To an extent, I mean, the Virginia statute was certainly a model for this originally, yes.
All right, thanks.
All right, and Delegate Conaway, please.
Thank you, Chair. Thank you, witnesses and delegate, for coming in to testify. I'm over here looking to see, I was struck by the language that the 18-year-old was considered to be a boy. And I thought at 18, you become a man under certain circumstances. And now I hear that this is a black bill. Are we saying that it's a black bill as in African American, or black as in African American and Hispanic and other? Can you answer that question?
Well, this is just the opinion of a witness or so on the bill. I can't.
Well, then you shouldn't be speaking, I don't think. Let the witness who said it speak on it. You want to come back to me?
Thank you for your question, Delegate. What I meant to say, and thank you for giving me an opportunity to clarify, was just that in my personal experience as an attorney, it was black immigrants who I encountered the most with this PBJ requiring intervention as a consequence to prevent their deportation. And go ahead, Delegate.
For the record, I have no problem with it being black and Hispanic. And I want to know, of the black people you're talking about, are they non-immigrants? Are they illegal immigrants?
They were all the people I'm thinking of right now. They were all lawful black immigrants. They had all lawful status. And the young man I was referring to, or the boy, as I think of him, because he very much acted like a boy, in my opinion. That's just one woman's opinion on when men become boys, Delegate. Or when boys become men, I should say.
Well, same difference.
Well, you know, this is
Thank you very much. Thank you.
Please, no one tell my husband about this testimony. No one do that, please.
Thank you.
You're welcome.
I walk back in the room and everything's falling apart. Okay, so you did a wonderful
Juanita
job.
Fisher is here.
Sorry.
I think that explains it.
Wow. See you at 10 o'clock tonight. All right, Delegate Phillips.
So I just want to understand, and maybe you guys can help me, the distinction between what you're proposing and what is currently the law in Virginia, and what are the differences between the two? And with those differences, what were you attempting to address in Maryland that may be different from Virginia?
So thank you for your question, Delegate Phillips. So are you talking about the Virginia statute that the Administrative Office of the Courts referred to in their letter?
Yes.
Okay, so actually, that's not the statute we modeled our statute after. Our statute was modeled after a different Virginia code, which I can send you the exact code later. And it was also the subject of a Fourth Circuit case, the Crespo case, which I can also send you later and to the committee later. And it's also cited to in my written testimony and Mr. Zavin's, and I'm sure a few other of the legal testimonies. And so in that court case, the court held that Virginia statute was not a conviction under federal immigration law because it did not require an admission of guilt by the defendant. And so that piece of it is very much what we modeled. The pre-BJ in Maryland, the original, requires the defendant to plead guilty, and then the court strikes that finding of guilt. And so what we did, the main difference, is that we don't require the defendant to plead guilty or to admit to the facts, which is like the Virginia statute. So it's modeled after their statute in that it mimics those components because we were following the legal opinion of the Fourth Circuit. So, but the Administrative Office of the Courts, just to be clear, they referred to a statute that Virginia passed later on that they included a requirement of state's consent, and that's not the statute that we were referring to or that we modeled our bill after. So I believe that was a misunderstanding.
Okay.
Thank you so much, Delegate.
All right. Are there further questions for this panel? Seeing none, we thank you all very much. And now we'll figure out what the next panel is. Should I start here? Or do you want, oh, well, Wanika's here. All right, so we're going to hear from former Delegate Fisher, Chair Welter from the Office of the Attorney General. Judge Davis is on virtually, so we'll hear from him. I'm kind of working my way backwards through the list. And then Casca Watson, are you here? Yes, sir. All right, come on up. And then we'll also hear from Alexis Turner Laughing. I apologize if I've messed that up too many different ways. Why don't we stop right there and then we'll go on with another panel. So 2 minutes for everybody who's up there and the two names that I said, and then we'll go from there. Okay? If you'd like to begin, and then we'll move across. Ms. Fisher goes second.
Good afternoon, Chair and committee members. My name is Casca Watson, and I am a clinical law student at Maryland Carey Law School here on behalf of the Immigration Clinic, the Justice for Victims of Violence Clinic, and the Gender Violence Clinic. Maryland Carey Law's clinical program prioritizes addressing racial injustice, and therefore I ask for a favorable report on HB 193 because it prevents harm to communities of color. More than half of immigrants who receive a PBJ will be detained by ICE, and 99% of people in detention with PBJs are people of color. Therefore, at its core, this is a racial justice bill. As Professor Carl mentioned in her testimony, there's a long history, especially for Black people, of being over-policed, over-prosecuted, and then deported for even minor criminal contacts. This is because Black immigrants are more likely to have encounters with law enforcement and then end up charged and prosecuted for crimes which lead to deportation. While in custody, Black immigrants often face worse treatment by immigration authorities as compared to other immigrants. Black immigrants are also more likely to lose their legal cases for immigration relief as compared to other immigrants. For example, Black immigrants reported that ICE officers had tortured them into signing their own deportation orders and then deported them to countries where they were likely to be persecuted. This bill's passage will prevent racially unjust detention and deportations of non-citizen Black and brown Marylanders. This bill will help the state's attorney and judges to ensure that all people receive equal justice under the law. Ultimately, this bill is about fairness and equal treatment under the law for all Maryland residents, regardless of their citizenship status or the color of their skin. I therefore urge you for a favorable report on HB 193.
Thank you. Thank you, Mr. Chair. Thank you to the hardest working and the baddest committee in the Maryland General Assembly, the House Judiciary Committee. It is such an honor to be back here with my friends and I would say my family. Thank you, Chair Clippinger. I want to thank Vice Chair Moon for taking on the baton of this bill. I'm going to try not to tear in my testimony. I just want to thank you, sorry, for taking this forward. Can I have a moment, Mr. Chair? Sorry. For those of you who don't know me, I served in this committee for 4 years, and I am a proud Black immigrant My mother immigrated here to the United States from South Africa after fleeing apartheid, in which my uncle was killed by white South African police. And my father is Nigerian Yoruba. They met in the United States only like any immigrant story, and I arrived and ended up here in Maryland and in this committee. This bill is super important. I think you heard a lot of testimony, but I want to give you an economic lens to this. The district that I represented here in the General Assembly and that I represent as the current county councilwoman in Prince George's County is filled with immigrants from around the world. And I got into this bill my freshman year because I had a neighbor whose husband was stopped by Prince George's County Police for a minor traffic infraction and was later deported back to his home country. He had 2 citizen children that are my neighbors and her, who's also a U.S. citizen. This is about keeping families together. And for those who know me, I'm economically moderate. It's also about families being able to work and support their children and pay taxes and be here to do that. When you deport someone's family member for a minor violation, you are also now setting up those children to be dependent on state aid. It is so important to me that we also see the economic impact of this bill. And to conclude my remarks, Mr. Chair, I just want to also flag the testimony that I heard about making sure there are consequences with this bill. This bill has been worked and reworked a lot of times, and there is accountability. When someone either violates the terms of their probation before judgment, I'll be really quick.
Yes.
A judge can actually enter the guilty and find them later on that secondary pass through court when they're actually allowed this PBJ. The chairman of this committee and the vice chair worked really, really hard on me on that part of the bill, and I'm very, very thankful for their effort. I'll wrap my remarks up there.
That sounds good. Good wrap.
Thanks,
Well
Mr.
done.
Chair.
Good job.
I appreciate you all for your consideration.
You've
Please vote
forgotten so
favorable.
much. I mean, what
I'm
is-
sorry, I'm like out of it and I got emotional seeing you all and it took me off my testimony.
It happens all the time when people come here. It's
Okay, so I'm so sorry.
Mr. Welter, please.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Jer Welter. I'm an Assistant Attorney General here on behalf of Attorney General Brown and the Office of the Attorney General to urge your support of House Bill 193, which will help avoid devastating federal collateral consequences, particularly for immigrants. And for people who commit minor crimes, PBJ under Maryland law, for most purposes, is not considered a conviction. It doesn't carry the consequences of a conviction. And this bill ensures that this mode of granting a PBJ would continue to have the same consequences of a PBJ under Maryland law. It specifically provides for that. Other witnesses, particularly Mr. Zavin, have stolen much of my thunder in terms of the substance of my testimony. So I will just point out that the criticisms of the bill from the Maryland Judicial Conference we would respectfully submit misunderstand the bill. For instance, the conference notes that it creates a new type of plea without defining the new plea, but the bill expressly provides that the plea would be not guilty. And that's important because under the federal definition, the federal immigration definition of conviction, that this bill is trying to avoid triggering, a plea of guilty would qualify as a conviction, and that's why a Maryland PBJ doesn't work and is problematic right now. So I know that the advocates on the bill have indicated that they are open to amendments to further clarify the bill if it's necessary. Certainly, the Office of the Attorney General's position is that this should carry the same consequences under state law as a PBJ, and we would urge your favorable support.
All right, we'll hear from Judge Davis, please. We'll hear from Judge Davis virtually.
Mr. Chairman, Delegate Moon, members of the committee, thank you very much for giving me this opportunity to address you. Thank you for considering my written submission. I am not with you in Annapolis today only because I am out of state attending a juvenile justice convening a matter that is very close to my heart. As a judge for 30 years, including 8 years on the Court of Appeals for the Fourth Circuit and 8 years as a member of the state court at the district and circuit court levels, I'm very familiar both with the PBJ practice as well as with the delicacies of immigration law. For all the reasons that you've heard, that you're aware of, I urge favorable report on this bill. This is not the only instance where peculiarities of federal law operate to undermine the intent of the Maryland General Assembly. But surely this is one of the most egregious and most unjust. And while I am very disappointed at the report of the Administrative Office of the Court, which has been alluded to, I can tell you, and I know you know, in my discussions with judges, primarily in and around Baltimore City and Baltimore County on both the district and circuit courts, I have heard no opposition from those judges, no confusion whatsoever from those judges about how this particular bill would operate. So accordingly, thank you for the courtesy of hearing me, and I urge favorable report, and thank you very much.
Alexis Turner Laving.
Good afternoon. My name is Alexis Turner Lafing. I'm a student attorney at the University of Maryland Francis King Carey School of Law's Clinical Law Program. I am also a business immigration professional with 4 years of experience. I urge a favorable report on House Bill 193 because amending the probation before judgment bill would ensure that the visas used by foreign students and professional immigrants are not inadvertently stripped away because of a one-time minor mistake. The types of individuals who could be affected includes, but is not limited to, foreign national executives, scientists, academics, outstanding athletes, computer scientists, engineers, and undergraduate and graduate students. A non-citizen resident of Maryland who obtains a PBJ may be deemed inadmissible or ineligible to obtain or maintain a visa or gain admission to the United States. This means that when a non-citizen visa holder leaves the US, they would not be allowed to return. It is common for foreign students and other professional immigrants to travel back and forth from the US to their home country to see family or take care of other business. Not being able to do so, or doing so and being denied entry as a consequence, would be highly disruptive and problematic for many foreign students and professional immigrants. In addition, many of the non-immigrant visas utilized by these individuals also allow for their spouse and children to accompany them while they work or study in the US. As such, if their spouse or child has a lapse in judgment that results in a PBJ, they would be inadmissible upon their next departure from the US and would not be able to use their existing dependent visa to return. Amending the PBJ statute will make it easier for the US companies, universities, and think tanks to attract and retain foreign talent. I therefore respectfully urge a favorable report.
All right, questions for this panel go to Delegate Cardin.
Thank you, Mr. Chairman. Thank you all very much for coming and testifying. Councilwoman, it's great to see you.
It's good to see you.
Are you still practice, or you now have to be full-time?
I still practice a little bit.
Okay. So do you think there would ever come a time that you were in front of a judge and a judge would have a problem with this? A defendant pleading not guilty, a judge finding sufficient evidence to be able to say they're guilty, but offering them a probation before judgment instead. Have you encountered a judge that would have a problem with that scenario because it doesn't seem consistent?
Yeah, I practice in Prince George's County, Montgomery County, a few in Baltimore City, and I don't do cases in Calvert anymore because it stresses me out. I would say, I think a judge, all the judges are different, but I think they would be, as long as that there is agreement, it's in the best interest of the defendant. I have not found resistance from a judge. I think you'll find resistance depending on the facts of the case. And the fact that maybe as a defense attorney, the prosecutor and I are not in agreement, and I'm just proffering and asking for the PBJ to be enrolled, and it's up to that judge's discretion on each case based on the facts.
But you don't see that a judge would say, I can't uphold my end of the bargain as being a judge by saying, I see that there's enough to maybe find him guilty, but I've agreed, because I believe it's in the best interest of all parties, that we find a probation before judgment as appropriate.
Yeah, so I agree with you on that.
All right, so the language in the bill is probably, is perfect, it seems to be perfectly fine based on what I've heard from the folks, the witnesses, in its present stance. Of course, there could be some tweaks done, but it seems like it should be okay.
Yeah, I would say this. I think my iterations with carrying this bill for, I think, 3 years, I would leave it to Delegate Moon. It's his bill now, and it's up to his discretion what he thinks is best. But I think the language was worked multiple times in the state that it was to account for any of that. And whether it's you're using this PBJ mechanism or our current PBJ statute, it's up to a judge's discretion to want to enroll that on behalf of the defendant. And I think that stays true no matter what, and especially the way that this is written.
Can I have one quick follow-up, Mr. Chair? And this is actually to Judge Davis. It's good to see you, Judge Davis. Given that, I don't know if you were able to hear all the testimony that just came up, but is it the intent, as a former federal judge, is it the intent of the federal government to create a scenario where a 1975 statute to avail people of a PBJ to overdo that or outdo that? Have you spoken to any folks on the federal bench recently who may say, no, that's not the intent, but it's just a quirk? I'm not exactly sure why, if this was something intentional or something that was just coincidental.
Thank you, Delegate. I have not spoken to any of my colleagues on the federal bench recently about this, but I can assure you absolutely, it was not the intent of the federal judiciary, or frankly, I think really anybody in the executive branch who administers the immigration laws to achieve this result. To be perfectly frank, Delegate, I think what happened here essentially is that a NOLO is a conviction. An Alford plea is a conviction. A plea of guilty is a conviction. And federal courts simply refuse to accept the distinction that clearly was intended by the Maryland General Assembly in creating the PBJ process. And so against all evidence to the contrary, our court, the Fourth Circuit, years ago, interpreted a PBJ under Maryland law as if it was a NOLO plea, a no contest plea. And it wasn't. It was never intended to be that. Indeed, you might say the reason the Attorney General created the PBJ statute was because of the harshness that attends a NOLO plea, a no contest plea. So it's one of those situations, Delegate, you raise a great point. Inertia sets in the law, and nowhere does that happen more frequently with greater adverse consequences than in the immigration law. As we are all aware, Congress has been struggling with a comprehensive immigration reform for decades now and cannot get anything done. And so to answer your question, I think it's a matter of inertia. The case was decided and nobody's been moved to change it as a matter of federal law. And so now I think it's time for the Maryland General Assembly to step up and say, okay, you've undermined what we were after, now we're going to fix it. And it's a very simple and straightforward fix. No one would ever bind a Maryland judge to do anything when it comes to a PBJ. And so I think it's, again, regrettable that the Judicial Administrative Office has expressed its opposition. Although, as you notice, it says the judiciary takes no position on the policy. Well, in some ways, that's the most disturbing part of that report. The judiciary should be taking a position on the policy, because the policy as it now operates is so unjust. And so I think it's a matter of inertia. The law, the case was decided and nobody's been moved to change it as a matter of federal law. And so now I think it's time for the Maryland General Assembly to step up and say, okay, you've undermined what we were after, now we're going to fix it. And it's a very simple and straightforward fix. No one would ever bind a Maryland judge to do anything when it comes to a PBJ. And so I think it's, again, regrettable that the Judicial Administrative Office has expressed its opposition. Although, as you notice, it says the judiciary takes no position on the policy. Well, in some ways, that's the most disturbing part of that report. The judiciary should be taking a position on the policy, because the policy as it now operates is so unjust. And no one other than Attorney General Brown and before him, Attorney General Frosch fully understood that.
Thank you.
Delegate Conaway.
Thank you, Mr. Chair. Thank you, panel, for coming in. Good to see you again, former delegate.
Good to see you.
Does the PBJ, current and the change, the proposed change, does the PBJ cause the denial of a wear and carry permit or the delay of a wear and carry permit and the purchase of a handgun?
So under Maryland law, there are PBJs for certain offenses are considered convictions under Maryland law for purposes of firearm disqualification. And so that's why the piece of the bill where it says, ensures that this is a PBJ for all purposes under state law is very important. So every time, for most purposes under state law, a PBJ is not a conviction. But for purposes of firearm disqualification, it can be, and this would also be because of that provision.
So you would need to know what convictions now, or what PBJs would be disqualifiers currently, and then if you change the law, those will be the same rules that will disqualify the person, applicant?
It would mirror it. It would be the same. It's specified in section 5-101 of the public safety article, and it depends on whether it is a PBJ for a crime of violence or a domestically related crime. But in those circumstances, this would be treated exactly the same.
Okay, thank you very much.
I have a couple questions. So, and this has been an issue that we've talked about for several years, and an issue that kind of tends to revolve around issues of due process, specifically related to probation, related to the authority that a court has to hold someone responsible. And I guess my questions are these. So you have someone who has pled not guilty. They are found neither guilty nor not guilty. Is that correct?
It's on a justification of, are you talking?
Yeah, whoever'd like to answer, it's fine. I see everybody, at
Okay.
least this current panel. I mean,
Okay,
that's
and
fine.
I'll let Attorney General's Officer Judge Davis enter in, because I've got like zoning in my brain now.
We're talking about a residential dwelling.
Yes.
No,
No.
okay, so
it
we're-
would be on the justification of facts. Yes, Mr. Chair.
But they're not found guilty or not guilty.
Correct, Mr. Chair.
So we're in sort of another region here where there has not been a finding of guilt. And I guess the question then becomes, where's the authority of the court to act if the person has not at some point been found guilty in the process? And I can direct that to all of you. I guess I'm kind of looking at the Attorney General here.
Sure.
We can
Okay.
start with that because Councilwoman Fisher was kind of going that way anyway.
Sure, I'd be glad to take that. I think, and this may also be somewhat responsive to Delegate Cardin's questions about the history of the PBJ statute. Before we had a PBJ statute in 1975, we had what was called probation before verdict. And there was a case of then the Court of Special Appeals, and it's the Bartlett case, it's cited in our written testimony, where the Court of Special Appeals found that to be constitutionally problematic for some of the reasons that you mentioned. And so PBJ was initiated where there would be a finding of guilt, typically based on a plea of guilty, and then you just withhold the actual judgment of conviction on that. Now, we believe that this bill addresses those concerns from Bartlett. It moves it so it's still before verdict, but after a finding of facts justifying a finding of guilt, beyond a reasonable doubt, certainly, and also an agreement with the court by the defendant based on a full waiver colloquy of the type that would be entered during a plea that would agree to deferring the finding of guilt, would agree to enter into probation, and would agree that based on the finding beyond a reasonable doubt of facts justifying a finding of guilt, that that verdict of guilty could be imposed and they could be sentenced if they violate probation.
But if someone isn't actually found guilty at some point, what authority does the court have to exercise any supervision and probation anyway? I guess the question that keeps coming back, that has come back, I know in the discussion in the Senate last year, and that has come up here again, is are we sort of creating this, I mean, the PBJ is a legal fiction almost in and of itself, and I get that. The question comes back to if you have, if what authority does the court have to act on that agreement, I guess, is where I'm getting to. They don't have any authority based on finding a finding of guilt. There's no finding of anything. There's merely a person who has signed an agreement under the bill, signed an agreement. And look, it has gone around and around, and yes, it is passed here, but I'm trying to get to this issue because I think it's where this all ultimately turns. It's based on quite literally nothing. And so where does the court, if there is nothing there that has put the person on probation, apart from, as I see, a probation agreement, what makes that enforceable?
Mr. Chairman, may I take a run at that briefly?
Sure.
Go ahead, Judge Davis.
The key here is the judge finds, based on the factual proffer, that the facts are sufficient to find the defendant guilty beyond a reasonable doubt. That is a finding of evidentiary sufficiency satisfying due process.
But doesn't that create then the problem that you're trying to avoid, where if then down the road, an enterprising attorney from ICE decides to say, well, the judge made the ruling. The judge made the ruling and found that the facts were sufficient to find the person guilty. Why doesn't that then trigger the same immigration consequences that you've been talking about already?
Great question, wonderful question, and the reason
Don't
is
butter me up. I know it's your birthday coming up and you want a card. Just stop. He's a constituent. It's fine. Go ahead.
Thank you. The truth of the matter is that's the nub of the matter. The Fourth Circuit made the ruling it did because the defendant admitted guilt. And you can admit guilt by either admitting facts or by pleading guilty. And in the amended PBJ statute, what this does, it empowers a court to treat a defendant as if he had admitted guilt after a full panoply of warnings and colloquy, exactly the way it would look if he were in fact pleading guilty. But there is no admission of guilt and there is no verdict of guilty. But there is a finding of sufficient evidence so that if the probation violation comes along, we're no longer in beyond a reasonable doubt domain. Beyond a reasonable doubt has already been determined at the original proceeding. The only issue before the judge at the probation violation hearing is, as even the administrative office of the courts acknowledges, is whether there has been a violation of probation proven by a preponderance of the evidence. So there is no due process impediment to this procedure whatsoever.
And
So,
Mr. Chair,
Judge, let me follow up quickly with Judge Davis. So what you're saying is, as you were saying, and as every circuit and district court judge for years has done here across the state, is they'll go and say, the litany that you said, and then they say, and I find you guilty. then we go to sentencing and go from there. You're saying that the "we find you guilty" part is not in any way dispositive to dealing with a probation charge down the road? Because I guess the other question is, are we really kind of setting up two tracks that where you're violating the probation agreement, but then are you, I don't know, I guess it would depend on what was in the probation agreement, that you could be setting that up to create a little bit of an issue too. But Councilwoman, go ahead and make your statement, and I think I'm going to move us along here because no one else has got questions, and I feel this has become a law school class.
That's okay, Mr. Chair. I enjoy being back on memory lane. So I think it puts the defendant in the same stature as they are with a STET, Mr. Chair. So when you're offering someone to put someone on the STET docket, they're not entering you're not entering a guilty when you put the case on the STET for 3 years and you're waiting for them to complete it. When it comes back off, and when you do have that violation of probation, I'll let Professor Call correct me offline if I'm wrong about this, that is the time that the judge can then enter a guilty because you violated the terms of either the STET or this alternative PBJ, and then enroll whatever punishment or consequence there is for that VOP. So I find, at least in my reading, I'm only one attorney and one person, I find it a very similar setting for the defendant in the agreement to be on the STET docket as you are with this alternative PBJ.
But if you're on the STET docket, all that means is I pull it off the STET docket and now we're going to trial. That's not going to happen in the cases here with the probation agreement. That precisely won't. What the person is saying is, I'm going to waive my right to a trial, and I guess it again kind of raises an issue of at that inflection point where the court decides to take that next step, what authority does the court have? And I can read the bill, and I got it. I'm not playing totally dumb here, but it does feel like there is that still missing component of getting from point A to point B, where they don't have the ability to question it at all. They don't have the ability to have any due process rights. They just failed to, you could have judges that say they arbitrarily failed to meet the probation agreement. And now here we are, and you're found guilty, and they don't have any way of coming back on that. And I guess that sort of gets to that sum and substance of the due process challenge here that I think has hung us up to some extent. Isn't that so? Please don't answer. Let's keep moving. Thank you all very much.
Thank you
and
all.
That concludes the testimony from this panel. We're going to keep going because there are quite a few other people who want to testify, and I think I've talked enough on a day when I've been saying that we have 50 billion witnesses. We're going to hear from, I see Erica Suter on here, so we'll hear from Erica Suter. Jessica Emerson, are you here? All right, come on up. And Elizabeth Hilliard from the Public Defender. Are you here? Yeah. Oh my goodness, there you are. Janice Alonso is here. We'll hear from Janice Alonso here. You're virtual. And then that leaves us with the last two, as actually virtually, Judge Baer and Andrew Gross. We'll hear from the two of you, and then that'll be, I believe, all those people signed up in favor. And so we'll start with the people at the table. We'll take everybody else who's here virtually, and we'll go from there. So please, starting on my right, your left.
Great. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project at the University of Baltimore School of Law, which seeks to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking in those populations put at highest risk of exploitation. I am also here in support of House Bill 193. In the political rush, unfortunately, to demonize undocumented criminal defendants, it is often forgotten that hidden among these defendants are foreign national victims of trafficking who frequently have criminal records stemming from acts they were forced to commit by their traffickers, as well as the instability that so commonly precedes or follows a trafficking experience. Arrest, detention, or even deportation of foreign national trafficking victims is not uncommon. These victims may be arrested for working without a visa, for prostitution-related charges, or for a range of other crimes, including theft and drug sales. National data bears out the regularity with which this occurs, as indicated by the 91% of sex and labor trafficking survivors, both domestic and foreign-born, who report having been arrested at some point in their lives. However, while criminalized U.S.-born victims are saddled with collateral consequences such as difficulty obtaining safe housing and gainful employment, foreign national victims face the additional, far more severe consequence of deportation, allowing for some leniency in situations where a foreign national defendant is a first-time offender or where the crime is nonviolent would reduce the risk of these life-altering collateral consequences, as well as allow for the possibility of connecting the victim with service providers who can assist them with pursuing the support and immigration relief they so rightly deserve as victims of crime. House Bill 193 will reduce the risk of this harm, as you've heard from the other panelists. And for these reasons, the Human Trafficking Prevention Project supports House Bill 193 and respectfully urges a favorable report. Thank you very much.
Thank you, Chair, Vice Chair, members of the committee. As far as my professional opinion, I'm going to just say me too to all my esteemed and learned colleagues who have preceded me. However, I'm going to do something I don't usually do, which is talk about my personal experience. I have a family member who has directly benefited from this type of statute in a different state. I can tell you the Hilliard family is Ohio born and bred for many, many generations. There were no immigration consequences to the matter. But there could have been serious work consequences and employment consequences that were successfully and actually very successfully now, 10 years later, avoided for my family member after some very stupid mistakes when he was younger. And I know I am extremely grateful. I know his wife and he are extremely grateful that that opportunity was presented to him, because it has allowed him to have a clean record and it's allowed him to have a wonderful career with no impediments. So again, I think we've talked, I work in post-conviction. I have handled many immigration consequence cases that would be alleviated by this bill. But I also know firsthand and personally the impact that it can have on a wide range of people who are involved in the criminal legal system. Thank you.
All right, let's hear from Ms. Suter, and then we will make our way around here, and we'll hear from the remaining 4 witnesses who are here virtually. So, Ms. Suter for 2 minutes.
Thank you. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Erica Suter, and I'm here in my capacity as president of the Maryland Criminal Defense Attorneys Association. Years ago, I received a frantic call from a father whose daughter was picked up from their home by ICE. She was being held in a local jail and was in expedited deportation proceedings to a country beset by political conflict and human rights violations, a country where she had never lived and to which she had no ties. She was born in a different country than the one she was being deported to, where her family had fled as a result of the conflict in their homeland. She and her family had entered the United States legally. She was a valid green card holder. A decade earlier, she received PBJs and 2 minor theft-related cases. Again, she was legally in the United States. She had not incurred new charges. It was unclear what flagged her for ICE, except that she was thinking about moving, and it may have been a credit check that put her on their radar. Fortunately for her, the state consented to the 2 quorum notices we had to file. The court accommodated our request for an expedited hearing. I was able to locate the theft victims, and they consented to relief. But all of the stars had to align for this relief to happen. The amount of resources used in this process to fix this outcome, the court's time, the lawyer's time, the weeks that my clients spent incarcerated, not working and not contributing to society, the cost incurred to achieve a result that was the original intention of all the parties is astounding. If HB 193 were in place at the time, none of this would have happened or been necessary. It is a common sense measure that will ensure that the outcome that the court intends is actually achieved. And the Maryland Criminal Defense Attorneys Association would urge a favorable report. Thank you.
Judge Baer, go ahead for 2 minutes.
Thank you, Chair Clippinger and members of the committee. I don't want to take up too much time. I do want to add my strong support to the other judges who have testified, Judge Andre Davis and Judge Gosart. I'm retired state court judge from Montgomery County Circuit Court. And the one thing I would like to add, in addition to what's been said, is the effect this would have on the judicial system as a whole if this bill becomes law, and I think it's a good one, mainly because it would actually increase judicial efficiency. As you can imagine, when we have PBJs with immigration consequences, oftentimes years later, collateral attacks are made through post-conviction, through quorum nobis, and this would eliminate those things. We would have more certainty in how guilty pleas, or not guilty pleas, in this case, a not guilty plea, and the finding of facts sufficient to support the guilty plea. It would eliminate the confusion that judges have and that prosecutors have, that defense attorneys have. Because a lot of times these collateral consequences come up years after the case is resolved. This would encourage dispositions of the case. It would eliminate most, if not almost all, of collateral attacks on these cases. So I joined Judge Davis, and I'm disappointed with the Maryland judiciary in the way they treated this bill, and I agree with the prior statements of others that we can deal with that. We can, I think, deal with any nuanced additions or changes to the bill's language, but I think for policy reasons, for efficiency reasons, this is a really good bill for all the reasons stated. Thank you very much.
Ms. Alonso, please, then Mr. Gross.
Thank you. Good afternoon, everyone. My name is Janice Alonso. I'm a senior academic advisor and adjunct faculty at the Community College of Baltimore County. I'm also a doctoral student at Morgan State University, working on my dissertation for a degree in community college leadership. I have a bachelor's degree from Ithaca College, master's from Florida State. I'm also fluent in Spanish and a US citizen who was born in Syracuse, New York. I've also traveled to over 20 countries and lived in 3 different states. I'm submitting this testimony in support of House Bill 193 because it needs to get passed so that everyone who has a PBJ is not deported. A close family member who has DACA received a DUI in 2020. After he went to court, his charge was a PBJ. He completed all counseling classes even before his court hearing and worked on paying the fine incurred by the court. He made a mistake that night, but he took full responsibility for what happened. The family member is married and has a small child. He owns his own business, his own house, and pays taxes loyally every year. His child is the most important thing in his life. And every day we worry that this PBJ could lead to deportation and not seeing his child every day. He takes his child to sports activities, playgrounds, and more, and his child loves his daddy. The family member and the rest of our family treat every day as special in the case that his days in the US are limited. We're very worried that the PBJ could break apart his family. So I'm pleading to our elected officials that HB 193 is passed so that no family is affected by this PBJ and that no one's subjected to deportation because of just having a PBJ on their record. Thank you.
Thank you very much. We'll hear from Mr. Gross now.
Good afternoon. Thank you for having me. Much has been said today about the effect this has on immigrants, and in my written testimony, I wrote quite a bit about immigrants who serve in the U.S. military. That's where I'm coming from on this, is the collateral consequences this has on military veterans. So I urge the committee to take a look at what I wrote on that. We do have a large number of actually deported veterans, believe it or not, for this. But what I do want to talk about today, instead of that, is the collateral consequences this has on active duty service members, reserve service members, and DoD civilians who have security clearances. A finding of guilt is, now to back up, when there's, good order and discipline proceeding in the United States military, or fitness for service is evaluated, or a security clearance is evaluated, there is a separate administrative process for that. But when there is a finding of guilt that triggers the federal definition of a finding of guilt, it's one more weight against that individual. And if you're looking at the concept of a PBJ as a device that allows people to pay the consequence to their misconduct and then move on with their lives, get a second chance in the true meaning of it, if you're also putting their livelihood at jeopardy, perhaps forcing them to change careers entirely, they lose their job, they lose their security clearance, they can no longer work in the field they were working in, well, it's not really a second chance at all. That is a total left turn in their entire lives. Now, amending this law so that the PBJ is not a finding of guilt will those individuals truly move on with their lives, living with the mistake they've made and making amends.
All right. Thank you very much. We'll take questions for this panel. Any questions for this panel? All right, I think we worn everybody out on this bill. So I believe that concludes the testimony in favor of House Bill 193. We're now going to go to those people opposed to House Bill 193. There are two people signed up to testify, including Mr. Kroll, who is here. And I believe we have I thought it was virtual. One moment, please. Ms. Wyckoff? Amy Wyckoff? Okay. Mr. Kroll, go ahead.
Thank you, Mr. Chairman, members of the committee. Good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator, the Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984. And I'm here asking for an unfavorable report as to House Bill 193. In doing so, this is a federal problem. Correct the federal problem, and you correct the state problem, and that's where the focus should be on. We have one major objection. That is, there should be consent of the state's attorney before this plea is offered. We are in favor of keeping families together. That's a good thing. We want to do that. But it must be consent on a plea from the state's attorney. It's their case. There should be one that agreed to it from there. And the reason is every defense attorney will be asking for this PBJ. You cannot limit the PBJ offer to just immigrants, people in the military, things like that. It has to be offered to every single defendant. We don't want that to happen. It's not fair to anybody. Good defense attorneys like Mr. Cardin, he wants it because it helps him. And the reason is, as the chair said, there is no entry of guilt. There is no entry of guilt on the record. So as a condition of probation, if the defendant does not pay restitution, does not go to domestic violence classes, you got to retry the case. I was shocked to see former Delegate Fisher say this is the same as a stet. For months, years, the proponents have said it's not a stet. It's not PBJ light. And she comes in and says it's stet. PBJ light. It's like, wait a minute, you're telling us not to say it, and you're calling it that. We've been saying that's what this is for years. I didn't understand that at all. Every defense attorney would want one from there. It's malpractice for a defense attorney not to do it. The answer, as Delegate Cardin said, is to go in a not guilty statement of facts. And I've been saying that for years. A not guilty, not agreed statement of fact, but a not guilty statement of fact. And that will satisfy the federal law. I do take umbrage to Delegate Moon, who said this is for petty offenses. Second-degree domestic violence, Delegate Moon, is not a petty offense at all. And there are PBJs given for much worse than that. For those reasons, and I'm sure I'm going to get questions and many more, we're asking for an unfavorable report as to House Bill 193. But I told the proponents we're willing to work with them, and we're actually quite close.
Okay. Let me begin. So PBJ is effectively a legal fiction, a kind of legal fiction to begin with, though, correct?
Correct.
I mean, it's based on the presumption that you have, you're basically saying you had a guilty, but it's going away, and we're not going to treat this as a conviction because we all pinky swear that this is what's going to happen. Basically, that's what it is. Correct.
Correct.
So I guess what's the difference with simply, I mean, I don't know that it's simple, but what they're seeking to do with the agreement is try to find a different way so that they don't say the magic words that trigger collateral consequences. How would that, I mean, how is that a problem? I mean, if we've already got one legal fiction, we're kind of wrapping another legal fiction on top of the other one.
The problem is we got case law over years that allows the one legal fiction to be true, and we don't have any case law about this legal fiction, and there's no entry of guilt. So say to a victim or witness, you're not going to get your restitution because it wasn't put on the record correctly. You're not going to have this defendant go to DV classes because it wasn't put on the record correctly. Their rights would not be heard at all, and that legal fiction is yet to be challenged.
But your concerns are addressed if the state's attorney has the ability to say, effectively to say no. Those problems that you've laid out just now go away if the state's attorney has the ability to say no?
They're still there, but our main concern is that we consent to it. It's not given to every defendant. It's still there. That's why I brought it up. It's still there, but our main and chief concern is we get to say when there is when there is a PBJ light, when there is a regular PBJ. That's our main objection. There is an objection, as the judiciary pointed out, as to the process. Is there an entry of guilt? Will those victims be heard? Is there to be a retrial? All those I'm just bringing to this committee's attention are problems that I see in the bill.
All right. Are there further questions for this panel or this person? Sorry. Delegate Bartlett.
I kind of have a question, but I can't remember what it was exactly. I know what it was. Okay, I have two questions. First question is, what came first, the federal law or the PBJ mechanism from?
A small bit of history. In 1975, which was actually before I started practicing law, so make that clear. I'm not that old yet. It was probation for judgment under Article 27, Section 641, and that evolved into what PBJ is today. Mm-hmm. The federal law, I believe, came afterwards.
Mm-hmm. Okay, so two more quick questions. We don't have any authority to do anything with respect to the federal laws. So we can't wait. We could wait for them, but the only thing we can do that is within our power to do is to enact state laws, right? Do you agree with that?
Well, we want to see people work on two levels, the federal and the state level. So what we're trying to do is say, start with the federal level, and we can work with the state level. And that's why I said we're willing to work with the proponents about the issues that we have. So we recognize we want to keep families together. So we're not trying to delay things. We're not kicking the can. It's too important of a bill to do that. We said we want to keep families together. We mean it.
Okay. And then there was a third thing. And the third thing was there was something that you said that I didn't quite understand. I can't remember now. I can't remember. I'm sorry, Mr. Chair.
I think we'll give you a pass.
Thank you.
I think that's okay. We might come back to you for a second bite, but now there are three more questions because you started asking questions. We'll go with Delegate Boucher, then we'll go on to Valentine and Conway.
Thank you, Chairman, and thank you, Counselor, for being here. I read the Judicial Conference opposition to this bill, and I see also that the supporters of this bill refer to Virginia as an example. But the Judicial Conference states that the Virginia has a deferred disposition statute. Do we not have that as a tool? What's the difference between the disposition statute and what we do on a PBJ?
Our deferred disposition statute is a STED.
That's the STED. It's called something different.
Yeah.
Okay. Thank you.
I'm going over here first, and I'll come right back to you. Delegate Valentine, then Conway, then back to Bartlett.
Thank you, Mr. Chair, and thank you, Counselor, for being here this evening now. Mine is specifically a question on, are we looking at, from a State's Attorney's Office Association, going down and modifying this type of a PBJ, or kind of what you alluded to was maybe creating two separate versions of PBJs for two separate types of defendants?
This would be two separate PBJs. That's what this bill would create.
Okay. Thank you.
Thank you, Mr. Chair. Thank you for coming in and testify. Will this PBJ change the current law first on the restrictions for the carry permit, the wearing carry permits? Do you know about that?
I'm, again, questioning what a federal or state court would rule, because this is not an entry of guilt at all. And it says PBJ. If you believe the Attorney General, and has the same effect, then it would be covered in that law, if you believe that to be true.
Well, the testimony was that the PBJ under the federal rules would be considered a guilty plea.
That's correct.
Okay, so under a guilty plea, would you be able to purchase a firearm?
In Maryland?
Yes.
It depends what kind of case it was.
Depends on what kind of case.
Yeah, the law is like 5 different or 10 different exceptions depending on what different cases are, whether you can or can't.
But in Maryland, we could go against the federal rules just like we've done on the marijuana. Is that correct?
I'm not sure what you're asking, Delegate. I apologize. I'm not understanding your question.
What I'm asking is, federally, marijuana is illegal as I understand it, but we've passed legalization in Maryland. Is that correct?
At this point, yes.
Okay. Thank you very much.
I forgot my question. No, I'm just joking. Okay. She's back. Okay, my question is, you said that because there are no parameters around it, everybody will want it. But wanting it and getting it are two different things. Wouldn't you agree? Because it's not like you just say, I want a PBJ, and zap, you get a PBJ. Isn't this something that the parties, the state's attorneys and the defense attorney would have to come to an agreement, and therefore?
Not under this bill, no. The John Cardins, and there are many of them out there, good defense attorneys, will all be asking for this PBJ, the PBJ light, not the regular PBJ, because of what's not included.
Okay, so all they have to do is go to the, so that's what the Mr. Chair was talking about, where you just ask the judge to have a finding, to say, based on your finding, there is no guilt.
From a practical point of view, a prosecutor walks into a district court with 60 or 70 cases. And they can move a case, they'll do anything, go on whatever PBJ statute they want just to move that case out of the way. Same with that judge. That's just the practical ends of being in district court with 60 to 70 cases a day. The good defense attorneys will be saying, give me this PBJ and I'll get out of your hair real quickly. They tell their clients, look what I got you.
But didn't we have one of the judges say that that would actually expedite the court system, the judicial system, in the sense that, I mean, we do get pleas all the time on various cases, right? For that exact reason, because we want to be more expeditious, and we don't try every single case that an individual defendant, that all the defendants are charged with, for that reason.
Given all the loopholes that the judiciary pointed out and I pointed out, there are too many question marks, speed bumps in the road, and not enough history to say what could happen. When it comes to speed, speed kills, and that happens to plea agreements too.
Well, I agree with you, but we can talk offline, because I think the reverse of that actually supports my argument. That, you know, in the sense that we could very well say, we don't know, therefore let's do it, and let's see what happens, and let's get our data together so that we can actually say, okay, we have X amount of cases where this was utilized, maybe utilized when it shouldn't have been, but until we know, we don't know.
Well, you tell a victim or witness you may not get your restitution, and I'm not confident about it, and I give my opinion and say you're never going to get your restitution this time. If they come back again and retry your case again, they're going to say, where's my closure? What am I supposed to do?
But wouldn't they get restitution if the defendant is found guilty?
The defendant's not found guilty.
Under this particular circumstance, but I'm saying there are going to be the opposite. There's going to be circumstances where this doesn't apply. And I'm saying that as a state's attorney.
If it's the law, it can apply to everyone, not just people who it's targeted for. That would be wrong. It applies to everyone.
No, I understand what you're saying, and I'm almost finished, Mr. Chair. What I'm getting at is, while the law, hopefully, is equally applied to all in Fairyland, while we hope that's the case, in actual, you always have the, state's attorneys always have the discretion to go beyond this particular proposed legislation and charge and have a trial and go through the normal mechanism. And if restitution is something that is desired, you can still get restitution, right?
Yes.
Okay, good.
No, I agree with that. At least I.
Before I go to Delegate Phillips, as you read the bill, if this comes to pass, we pass a bill, it becomes law, and a person enters into a probation agreement where they had to pay $1,500 in restitution, and the period of time expires before the person is able to finish paying the restitution. They pay a third, $500. They have no more money. They're declared bankrupt. There's no more cash. And the judge simply says, okay, you didn't meet the requirements under the probation agreement. Now I'm going to enter a finding of guilt. Is there anything that stops that from happening?
Due process for the defendant. He says, I don't want that to happen. I object.
Okay, but under the bill, is there anything that stops that defendant or allows that defendant to raise that claim?
I believe in trial that a defendant could raise a due process claim at any time. Nothing in this bill says they can't, or they can.
So in your opinion, does this bill allow them then to request a trial after?
Correct. Yes, absolutely.
Okay, Delegate Phillips.
So we talk a lot about prosecution, talk about the defendant. At the end of the day, it's the judge's discretion about how to apply this, correct?
Judge is the final arbiter.
The judge is the final arbiter. So isn't this just another option that we're offering the judiciary if they have all of the facts and they say, look, I've got a citizen in front of me who, but for, has not risen to the place that I want to ruin his life. And I'm going to, because I now have some additional facts, I'm going to make a judicial decision about how I want to handle this individual. And I don't want this, using the immigration as the scenario, I don't want this person to be deported. Wouldn't that make sense to give a judge that option?
It is an option. The problem with it is the procedural points. Number one, again, there's no entry of guilt. After a trial, there's got to be a finding and an entry of guilt. There's no entry of guilt. There's nothing to say that the person is on probation if they violate. There's a consequence because there's no entry of guilt. So
but we do that all the time. I'm sorry.
We don't do that. Delegate, we don't do that all the time. In a regular PBJ case, judge finds guilty, enters a PBJ, conditions are there. If there's a violation, they're subject to a violation of the original sentence that was given by the judge. This is no entry of guilt. This is a STET or a PBJ light. So if there's no entry of guilt, there's no enforcement. There's no mechanism to enforce this at all. That's the difference. If we're going to do it, let's do it right. This is not doing it right procedurally.
Okay, we're done with this bill now. Thank you very much.
Thank you.
That's House Bill 193, perhaps mercifully now is at an end, those bill hearings. So now let's go, we're going to 173 next. Okie dokie, we're going to go to House Bill 173 now. And I'm calling a first panel that includes the Vice Chair, Jessica Emerson, Stacy Jefferson, Elizabeth Hilliard, and Harriet Smith. We're then going to take all the remaining witnesses on a second panel. There's no one signed up in opposition. All right, so when you're settled, we'll go with the Vice Chair. Please, for 3 minutes.
Thank you, Mr. Chair. Good evening, colleagues. This is the last you'll hear from me on bills tonight. This is 4 of 4. Unfortunately, it is only number 8 of 14 for the rest of the bills, so we will be hanging together after I'm done. So House Bill 173, it's a repeat. We've passed this at least twice before, out of this committee, out of the whole House, out of the Senate. It had bipartisan support coming out of this committee and on the floor, and I believe it just corrects an error and omission from past work by this body. Here's what it does in a nutshell. It takes the penalty for syringes down from 4 years in prison, which is the current penalty, and puts it in line with the regular paraphernalia in Maryland, which just has no criminal penalty on the first offense, fine only, and a penalty on the second offense. Now, why would we do this? It sounds like, to many, oh, you're just going easy on people who use intravenous drugs. No, that's not the point of this at all. It is that this should be a public health-driven mission. In 2015, we recognized this, and the penalty on drug possession in 2015 was 4 years for any drugs. 4 years prison time was on the books when I first got sworn in, and we took that down to a year. We forgot to take that 4 years down on the syringe, and so now the scenario we have in 2023 is that if you are caught with a syringe with drugs in it, the drugs themselves would only subject you to 1 year, but the needle, whether it had any drugs in it or not, would subject you to 4 years. So that is the problem we are trying to fix. And this problem was brought to us by a number of public health professionals. You'll see that the Attorney General, MedChi, the Mayor of Baltimore, county health officers are all supporting this bill. It has very bad consequences to make a high-stakes 4-year prison game out of syringe possession. People then dump them in parks. They share needles. They hide them from police when they're being searched because they don't want to get caught with something that'll land them with 4 years. It's a terrible policy. Please listen to the public health experts on this and do not make the syringe the problem. The drugs are already illegal. So let's pass this for a third time and hope that that's the charm. And with that, I'll turn it over to my panel.
Good afternoon, everyone. My name is Harriet Smith, and I'm the Director of Services and Education at Baltimore Harm Reduction Coalition. Our services consist of making connections with people who are at risk of fatal overdose, contracting bloodborne illness such as HIV and hepatitis C, and often our clients are also experiencing homelessness and disconnected from healthcare services. Our program is part of a network of 22 similar ones across the state, and we provide people with some of their most basic needs, including safe water, hygiene supplies, first aid supplies, Narcan, and of course, clean drug use tools. Research consistently shows that when people engage in a syringe service program like ours and are legally protected to do so, they're likely to take up safety measures, reducing their risk of overdose, soft tissue infections, as well as the illnesses I named, and they're more likely to utilize the healthcare system before a concern becomes severe. The converse is also true, that when we criminalize possession of syringes and other drug use tools, there is an associated increase in syringe sharing, placing people at risk for HIV, hepatitis C, and so forth. Currently, participants of a syringe service program are exempt from criminalization of paraphernalia possession only if they can show police officers proof that they are a registered participant. This is a business card with a code on the back. You can't lose the card, and you have to keep it on you at all times. You have to hope that the police officers in your area will trust that the code on the back of that card corresponds to you and not someone else. This is particularly a problem in counties outside of Baltimore City where these are newer programs. I don't know about y'all, but I lose business cards constantly. And I'm not experiencing homelessness. Requiring people to keep a tiny piece of paper and find it during a tense interaction with law enforcement officers is unreasonable and a deterrent to taking part in this public health program. At the end of the day, we want to encourage safety, and this bill will help align the law with public health common sense. Thank you.
Good evening, Mr. Chair and members of the committee. My name is Stacy Jefferson, and I'm here on behalf of Behavioral Health System Baltimore. I'm the Director of Policy and Stakeholder Engagement. This legislation, as we know, is a step forward and ending the practice of criminalizing substance use. And as Delegate Moon and my colleague mentioned, evidence shows that when there's less fear of arrest, individuals feel safer accessing services, and they're less likely to discard syringes in our communities, our parks, and in our neighborhoods, and which in turn will make our community safer. And so I want to leave you with this. As a young girl growing up in the late 80s and 90s in Baltimore City, I was no stranger to syringe litter. One of the first memories that I have of my mom telling me to be careful of syringes in the park and the playground near my school, and that I could get really sick if I was to pick up one or to step on one. And here I am, many years later, and as I go out into communities, hear other parents have that same fear and share those same concerns with their young children. And so I asked the committee for a favorable report on House Bill 173 with the hope that this legislation will prevent a current generation from having the same fear that my mom had and my parents had, and that they won't also have to give the same speech to them.
Good afternoon or good evening, whatever time it is again. Mr. Chair, Mr. Vice Chair, members of the committee, my name again is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which seeks to reduce the collateral consequences of criminal legal involvement for survivors of trafficking and also preventing exploitation in those populations put at highest risk. I am up here not as a public health expert, but I am an expert in what puts people at risk of trafficking. And so in that regard, I'm here to make mention of a group who are not commonly thought of as benefiting from harm reduction approaches such as that which is presented in this bill, which are survivors of violent crimes like human trafficking. Drug use operates as both a common predictor of and a reaction to this crime. Many trafficking survivors report self-medicating to cope with past trauma and were trafficked as a direct result of their addiction, while those who have survived or who are surviving trafficking often begin using substances in an attempt to cope with what has happened or what is happening to them. Decreasing the risk of incarceration, as my colleagues have mentioned, while at the same time increasing safe usage and support lessens the likelihood of re-exploitation for trafficking survivors who use drugs, because they are less likely to have to rely on a potential trafficker for this essential assistance or to live their lives in the shadows where exploitation thrives as they merely try to figure out how to use more safely. Harm reduction measures like House Bill 173 are important for all people who use drugs, including survivors of crimes like human trafficking. Equipping people to use drugs more safely not only serves to stem the spread of infectious disease, but also to lift the stigma that so often isolates drug users, making them vulnerable to a whole host of additional harms, including exploitation. For these reasons, the Human Trafficking Prevention Project supports House Bill 173 and respectfully urges a favorable report. Thank you.
I think we were going to try and get everybody in on the first panel, but I'm not sure that's going to work. Why don't we take questions for this panel and then we'll go from there. Any questions for this panel? Delegate Young.
Delegate Moon, quick question, or anybody for the panel. Why isn't this entrapment? I mean, I know we give these out in Baltimore City to prevent HIV. I know they say Department of Health on them. I know I can find them on the streets. Why isn't it entrapment?
I would say we had a pretty cautious rollout of syringe service provider programs. Many counties did not actually take advantage of that law, and so there are giant holes in the state, and so you will find many people participating in informal clean needle programs and distribution that are not part of that law, and that's an existing problem. Now, as to people who are participating in the program, we have plenty of implementation problems with that. Compliance with law enforcement respecting someone who does happen to remember their card, and then those who don't remember to carry it. Again, all of this seems way too complicated. Like, why are we making the syringe the problem? The drugs already come with a year. It's very unclear to me what we think we're accomplishing by putting a high stakes 4 years on the syringe. Again, whether or not the syringe came from one of the official programs, you know, so if we're not really tying law enforcement's hands if they can already get you on the drugs. But again, I just think there are too many problems when you make the syringe the program, whether or not it came from one of those official programs.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Thank you, delegate and witnesses, for coming in to testify. Delegate Moon, does this bill only deal with syringes or needles as paraphernalia?
I believe we also took the word spoon out of controlled paraphernalia in this. So there's a whole section, there's regular paraphernalia, and then there's controlled paraphernalia, and that's where the 4-year penalty comes in. So we tried to go through the code and clean it out as much as possible, but that would probably be the one other thing.
The 4-year
I would
penalty, does that include the baggie that the marijuana might come in?
Not for marijuana, and that specific marijuana paraphernalia is specifically cleaned out from the bill we passed last year dealing specifically with marijuana legalization.
Okay, so if a person was caught with a pipe, you would be able to tell what kind of pipe, I mean, was it used for, I guess, hashish smoking or something like that versus for marijuana smoking? I mean, you could tell the difference? A brand new pipe or bong or whatever you call it?
I think there are a lot of problems with criminalizing the paraphernalia itself, and I think that's why you've seen the state move away from it, and on the first offense, it's just a ticket. I mean, if you look at page 4 of the actual text of the bill, you'll see a list of very common I didn't even bother dealing with strainer, sieve, or stapler. I mean, you could just as well have taken all of those out of controlled paraphernalia also. In the right context, they might land you with 4 years in prison for something that's an ordinary household object that most of us have, but, you know, in a different context.
My concern to that issue is page 3, line 5 for the first violation, a fine not exceeding $500, or is that stricken out of this bill?
Well, that's existing law for
I understand
non-controlled paraphernalia, so we would leave that. So for regular paraphernalia, however you want to define that, right now we already have first offense as just a ticket. We have in existing law also this special category called controlled paraphernalia, which I guess someone decided, you know, has some extra danger or care, and that's where the 4-year penalty comes on.
So back to my bong or hashish pipe question, can you tell whether it's controlled or whether it's not a special paraphernalia or not when you get it brand new out of the store?
I mean, at the point of sale, I mean, if it was marketed as such, it's quite possible, and there might be a design for certain pipes that are specific to certain substances. But again, you know, we've managed to splinter the code in Maryland a bit on this.
Last bit. Can you speak to page 3, lines 11 through 14? If a person is at least 18 years old who violates this paragraph, and what is the penalty?
This was creating a stiffer penalty for doing these offenses with minors.
Is this current law?
Yes.
And
Untouched.
untouched. Thank you very much.
Delegate Boucher.
Thank you, Chairman. It's good to have you back. Delegate Moon, you're in front of us so much, you should get like frequent flyer miles with the judiciary.
No, you'll start to not see me up here anymore.
All right. Back to business. Have other state jurisdictions who have enacted similar legislation seen an increase or decrease in IV drug use?
I don't know that you'll find any good data indicating that the prison penalty associated with paraphernalia has done anyone a lick of good in terms of taming their drug abuse or substance use disorder rates or their overdose rates or anything, to be perfectly honest. I mean, in 2015, when we took the penalty down on heroin even and things like that from 4 years to 1 year, it was after a year study and discussion with all the stakeholders. And part of the argument was, in fact, those 3 extra years of dangling incarceration over people's heads were not yielding a lower recidivism rate, were not yielding better public health outcomes, wasn't yielding better overdose response rate, but cost taxpayers, you know, $30,000 to $50,000 a year for the incarceration, at least some money if we're talking supervision for parole or probation. So again, I think you would be very hard pressed to find any data indicating that, keeping these numbers, especially the larger numbers on the books for syringe possession, is doing a lick of good for the opioid problem.
Delegate, I appreciate the response. Having lost a daughter to the opioid epidemic, I'm always willing to look for a solution to this problem. I keep a very open mind, so thank you for your reply.
Can I add something to your question?
Yes, please.
There's evidence, and I'm looking at a study here, there's evidence that reducing fear of interaction with law enforcement has great potential to increase people's access to and willingness to attend treatment services, broadly defined.
Thank you.
No problem.
Any other questions for this panel? Okay, thank you all very much. Now we're going to go mostly to the people who are on virtually, so they should all get ready here. But I think there may be a couple more people in the audience, and I know Ms. Hilliard is here. So, Ms. Hilliard, please. Jesse Dunleavy, did I call? Maybe not. Jesse Dunleavy, you're here. All right, come on up. Harriet Smith was on the last panel, right? I just did not, okay, right. All right, so I've got that and that. All right, and then everyone else appears to be online, appears to be available virtually, including Ms. Pompa, Mr. Hilliard, Ms. Bradley, and Ms. Park. So we'll hear from the two people at the table. Who are you pointing to?
Christine DeFore.
I think John Giannetti signed up on behalf of Maryland Criminal Defense Bar, and I was going to stand in for him.
Okay, I missed that one. That's fine. Then we're going to make you go first. Partially to be
It's only
Ms.
fair.
Hilliard for pointing you out, but other than that, no, it's fine. So go ahead, Ms. Dufour. We'll hear from the people at the table, and then we'll do everybody here. Okay, thanks.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman. Thank you for supporting or endorsing this bill. My name is Christine Dufour. I'm an attorney with the Law Office of Jezik and Moise, formerly of the Public Defender's Office, and I'm on the Executive Committee of the Maryland Criminal Defense Bar Association. I formerly practiced in Montgomery County, and I currently practice all over the Eastern Shore. And to the delegate's point earlier, and Delegate Vice Chairman Moon's explanation, the disparate prosecution of these cases is exactly that, disparate. So while you might have someone charged in Baltimore City not being charged with having a needle, I've seen many and represented many clients on the Eastern Shore where they're routinely charged with a 4-year offense, and the 1-year offense is really what they're guilty of, but the prosecutor knows they can put it all out there and leverage a plea. I would also note that this bill is also attempting to reduce the subsequent offender penalties for a second-time use of paraphernalia, and I think it's significant because if you see a 2-year penalty, and I've had clients sentenced to 2 years in DOC, it prohibits a local sentence. So that means if someone is given a 2-year sentence for subsequent offender paraphernalia, it's DOC time, which could significantly be more money than housing an individual locally. Locally can only be up to 18 months. A DOC sentence is a year and a day. So reducing this subsequent offender penalty down to 1 year permits a sentence in our local detention centers. I've had clients charged with all sorts of things. I've had clients go to jail, go to DOC on the subsequent offender. And I'm just an observer, having been a public defender and a private practitioner for over 25 years. I don't see any good, as Delegate Moon said, in criminalizing the paraphernalia.
Good afternoon, Chair, Vice Chair. Thank you for bringing this bill. Members of the committee, the Office of the Public Defender urges a favorable report on this bill because we know that addiction is a health issue. We know that substance use is a health issue. It should not be a criminalized issue. We want people who are struggling with addiction, who are trying to seek assistance in treating their addiction, to feel safe contacting 911, going to a hospital or other treatment care facility without fear of facing 4 years in prison. Now, 4 years in prison may seem small compared to some of the other penalties that we see before this committee. But I assure you, it is life-changing. As Ms. DeFore mentioned, even the opportunity, the availability of a 4-year sentence in the hands of the state's attorney can substantively change a person's life. We urge this committee to favorably pass this bill and to move Maryland into the realm of taking care of its citizens who struggle with addiction, as opposed to penalizing them. Thank you.
My turn. Thank you, Chair Clippinger and members of the Judiciary Committee, for allowing me to speak in favor of HB 173. My name is Jessie Dunleavy. I'm a retired educator. I'm an advocate for drug policy reform, and I'm a lifelong resident of Maryland. It's satisfying to witness over time, since I've been an advocate for drug policy reform, the acceptance of harm reduction initiatives and the recognition that they save lives. I've seen this unfold slowly over the 6 years since my son died of an overdose, a time when there were no services whatsoever available to him because of where in Maryland he lived. And despite my joining his fight, he and I were in it together, and I'm pretty resourceful, but we struck out. It was an era of abstinence or die. Instead of health-centered care, he was incarcerated for a relapse where he was physically abused, he was hungry, he couldn't buy food or toiletries, because every time I sent him one of those green dot money cards that you need to purchase something in the commissary, it was stolen from him instantly. He was a vulnerable person with a lot of disabilities, and he was a target. So this did him no good whatsoever. Had he gotten the health care that he needed, much less the assurance that he was worthy from some system out there, I know he'd be here today. I can't fight for my son anymore, but I can fight for yours, and I can fight for every son and daughter out there that would need us to join hands. But here's the thing. We know that these harm reduction services are proven to save lives. We know that syringe programs reduce HIV and are a bridge to wellness, but we continue to arrest people for trying to access the services that keep them safe. So it makes no sense, and we complicate the understanding on everybody's part. And so I urge you to pass this. It's certainly supported by the American Medical Association, and it makes sense just to trust that people who have substance use can use these supplies and not be arrested. Trust that the healthcare providers cannot be arrested, and trust in the police, who wouldn't be confused and who could spend their time focusing on more important matters, protecting all of our well-being.
Thank you. Thank you very much. We'll hear now from our virtual people on Zoom. Well, they're real people, they're just on Zoom. And we're going to hear first from Ms. Pompa, then Ms. Bradley, then Dr. Park, then Mr. Hilliard. So Ms. Pompa, please.
Yes, good afternoon, and thank you to the members of the House Judiciary Committee for this opportunity to speak. My name is Susan Pompa, and I'm the Associate Director of the Maryland affiliate of the National Council on Alcoholism and Drug Dependence. And we are here today to support House Bill 173, which would decriminalize possession of items that can be used to inject, ingest, inhale, or otherwise consume a controlled dangerous substance. As Maryland continues to consider and implement programs and strategies that reduce the harms caused by substance use, the decriminalization of paraphernalia will continue to help ensure that people are accessing services such as syringe service programs and avoid arrest and incarceration. The benefits of decriminalization are many, and they include improved treatment outcomes when someone with a substance use disorder is ready to enter treatment, greater incentive to seek treatment as people who are using substances are less afraid of law enforcement interaction, a reduction of the racial disparities in the criminal justice system, as Maryland is among the worst states in the country in its proportion of people of color who are incarcerated, a reduction in the collateral damage caused by incarceration, and improvement in the impact of limited public health resources. We know the collateral damage caused by the war on drugs continues to harm people in Maryland, and disproportionately people of color. As this committee has heard repeatedly over the years and all day today, people with criminal records are too often denied employment, housing, food stamps, and scholarships without any due consideration of the details involved in their records. We highly urge a favorable report on HB 173. Thank you for this opportunity.
Ms. Bradley, please.
All right. Hello, my name is Elizabeth Spradley. I am a nurse. In every healthcare setting, I've worked with people who use drugs. And in every setting I provided care, the magnitude of stigma around drug use is astounding, which is why I'm here today to support House Bill 0173 without amendments to decriminalize drug paraphernalia. Decriminalizing these tools is critical. The passing of the bill without amendments will give clear guidance as to how to approach drug paraphernalia statewide. We need clear guidance around drug paraphernalia for law enforcement and the general public. We need clear guidance for people using drug paraphernalia and spaces serving people using the drug paraphernalia. And speaking to what I know best, healthcare needs clear guidance that these tools are not a reason to deny someone healthcare services or force them into drug treatment or make assumptions that people who use drugs don't care about their health. As a nurse, I want people to know about drug paraphernalia and the benefits of each piece. I want people to be in awe of how such a small item can make a huge difference in public health issues, like mitigating the spread of infectious diseases. I want people to know how these tools are a bridge to other necessary services like mental health, primary care, and specialty care. I want people to use these tools with pride, knowing they're choosing a safer path to drug use. In my written testimony, I tell a story when I was a hospice nurse and a patient's husband was threatened with the police for having a pipe on him while visiting his dying wife. The ignorance around drug use is harming people, and not just the people using the drugs. To continue to criminalize drug paraphernalia inhibits me and other healthcare providers from being able to provide quality care. I encourage you all to please support House Bill 0173 without amendments to decriminalize all drug paraphernalia in Maryland. Thank you for your time.
Dr. Park, please, for 2 minutes.
Thank you, Chairman Clippinger and members of the Judiciary Committee. It's really great to be back here to speak in favor of House Bill 173. My name is JUD Park. I'm an epidemiologist and assistant professor of medicine at Brown University. I work closely with the Maryland Department of Health on HIV and overdose issues, and my husband and I have lived in Baltimore City for 12 years. So just to take a step back, since a lot of great points have already been made, just wanted to reflect on the last 50 years where we know lawmakers before, anyone in the room here was working, decided to punish those who use drugs. And this was at the federal level, state level. Strong linkages were made between urban Black communities and drug crimes to justify these laws. And I know we are all aware of the underlying structural racism that has driven many of these laws. And that means that entire generations of Americans have been burdened with criminal records for things like syringes, cotton balls, Ziploc bags, spoons, pipes. Delegate Conaway, your discussion earlier just really spells this out for us. And this is confusing. What it looks like in practice is that the same materials that are being given out by health departments and CBOs are being confiscated by police or thrown away. But I think Maryland, hopefully, will be joining 15 states, including Massachusetts, Rhode Island, New York, recently DC, where having drug paraphernalia is no longer a crime. And I can just confirm that IV drug use has been stable or declining in most states. So I hope that you'll vote for House Bill 173, vote for science and against racism and fear. Thank you.
Mr. Hilliard.
My name is Mike Hilliard. I'm testifying today as a resident of Baltimore County, a retired major with the Baltimore City Police Department, and a member and speaker for the Law Enforcement Action Partnership, LEAP. LEAP is an organization of criminal justice professionals that seek to improve public safety and reform the criminal justice system. Every time police make an arrest, we search the person before detaining them. As we pat them down, we ask the suspect if there's anything in their pockets or bags that could hurt us. Suspects will often lie if they're in possession of a syringe, hoping to avoid a paraphernalia charge. Researchers have found that 1 in 3 police officers are stuck with the needle while on the job. When we punish people for syringe possession, they do not risk carrying a used syringe with them to dispose of it safely. Instead, they leave it wherever they use it, in a park, in an alley, or in a public restroom. We shouldn't have to worry about our children playing in the park or our custodians being stuck by needles at work. I would urge the committee to favorably report this bill. Thank you.
Questions for this panel? Delegate Young, then Delegate Tomlinson. Delegate Young.
First question is for Mr. Hilliard. First off, we mentioned East Baltimore, Mr. Hilliard. Secondly, I've really found it fascinating what you talked about with folks getting stuck with the needles when you pat down. I guess my question is, and you said 1 in 3. I mean, that seems really often for officers to be getting stuck. I mean, I guess I'm asking, like, what are some of the other challenges? How does that also manifest itself, with health problems for those officers as well?
Well, I mean, one of the things the public health experts have continually testified about is the sharing of syringes and the passage of communicable disease through syringes. Now, it's far more likely through shared syringe use that you are going to pass on a communicable disease, such as hepatitis C, AIDS, or the others we've talked about. But there's still a possibility when you're stuck as a police officer that you could contract one of those diseases. And it's an extreme concern for officers, and it's one of the reasons we continually emphasize when we arrest somebody, do you have anything that'll stick us? Because officers are basically scared of contracting some type of communicable disease from that stick.
Thank you. So this is a really important issue and something that one of the things I really wanted to work on down here. I'm looking at the testimony from the chiefs of police and the sheriff's association, and I just want to get your guys' kind of input on this. One of the things that they state in here is that they believe that this bill has the potential for an escalation of the rising opioid overdose rates by decriminalizing the devices to ingest the substance, and that if the paraphernalia is decriminalized, there would be little to no opportunity to enter treatment through a criminal justice diversion program. So I just wanted to know if you guys had a rebuttal to that.
I could answer that. I mean, I think a lot of us actually think the opposite. Arresting people for having an evidence of a drug addiction to teach them a lesson, force them into treatment, it's inefficient and it's inhumane. It's kind of like, I think I said last year that we don't arrest smokers diagnosed with lung cancer to try to get them into treatment. We really need more harm reduction, social services, medical professionals. Don't put law enforcement in that situation. And I actually have friends who are police officers. So that's been my experience on that topic.
If I may briefly add as well, I don't find that people are encouraged to seek treatment by facing 4 years in prison. I think that we can and should encourage people to seek treatment without interaction in the criminal legal system, and in a way that addresses their public health needs and their mental health needs, and not in a way that ends up with them in a cage.
I have something to say too. The CDC I was just reading this week is unequivocally in support of syringe service programs because they say they're safe, they're cost effective. I took this right from them. They don't increase illegal drug use or crime. They play an important role in reducing the transmission of viral hepatitis, HIV, and other infections. And users of SSPs are 5 times more likely to enter drug treatment and about 3 times more likely to stop using drugs than those who don't use those programs. And so that's been a consistent report over the years, that's been proven with the data. They provide other health-centered support and help decrease overdose deaths. They protect the public and first responders by facilitating the safe disposal of used needles and syringes. So I don't think it's true at all that people would seek treatment more readily if they were able to avoid being arrested for paraphernalia. I think it's the opposite.
Thanks.
Thank you.
All right, seeing no other questions, we thank you all very much. And that concludes the testimony for House Bill 173. Gets us rid of Vice Chair's bills for today. So now, this is the order for the rest of the afternoon and evening. We're going to be hearing Delegate Grammer now for House Bill 233. Then going to follow it with Delegate Love for 226. Delegate Deborah Davis for 280, Delegate Williams for 330, and then Delegate Grammer for 2 more for 221 and 228.
Thank you, Mr. Chair. If I can
Committee, thank
call
you
my
all.
panel, please.
Yeah, please.
Ms. Lewis, Mr. Schellenberger, Ms. Jordan.
Please. Who did you say again? Let's see, Ms. Jordan.
Ms. Lewis, Ms. Jordan, Mr. Schellenberger.
All right, Lewis, Jordan, Schellenberger, that's fine. We have some people who are virtual who want to join in. We'll take those after we take this panel. Please, delegate for 3 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 233. House Bill 233 adds the streaming of child pornography to the current prohibitions under Criminal Law 11-208. I'm joined by Heather Lewis, who is a resident of the 6th Legislative District, and I will be brief and speak to the technicals of the bill so that she can share her story. A member of Ms. Lewis's family was the victim of child sex abuse. Through a criminal investigation, it was found that the perpetrator was a regular user of child pornography. When charges were pressed, it was decided that the perpetrator could not be charged for the possession of child pornography. When Ms. Lewis asked why, it was advised that Maryland's laws did not cover the streaming of child pornography. I called my state's attorney Scott Schellenberger, and we consulted with his sex crimes department, and they confirmed that criminal law section 11-208 does not cover the streaming of child pornography. And what you should take away from this hearing is that it's currently legal to stream child pornography in Maryland. It is not a prosecutable offense. Statute has failed to keep up with technology, and many states have actually encountered this exact issue governing child pornography. Current laws that govern content, they govern the downloading of the content, but not the actual streaming. And this is legislation that's we've had to adopt it across many states. House Bill 233 addresses this issue by adopting the language used in federal law, and that is knowingly or intentionally access with intent to view. This is the standards that's used federally and in many other states. I know that there are many others who want to speak to this issue, including Ms. Lewis, so I will yield. Thanks for the opportunity to present House Bill 233. I'll be happy to take questions, and I'd ask for a favorable.
Whoever would like to go next for 2 minutes, please.
Hi, my name is Heather Lewis. I'm a resident of Baltimore County. I want to thank everybody for taking the time to hear the story of my 6-year-old child, and I'll apologize ahead of time. This is extremely difficult to speak about. In July of 2022, my 6-year-old disclosed to myself, several other members, including their other parent, that they were being sexually molested by an elder member of our family not only disclosed, but laid on our living room floor and demonstrated what was happening to them. This prompted a CPS investigation, which returned a finding of indicated and a Baltimore County Police investigation crimes against children, and resulted in initially 5 criminal charges that included 3 felonies, sex abuse of a minor, sex offense in the 3rd degree, and rape in the 2nd degree, and 2 misdemeanor assault. During the course of the investigation, it was determined that the abuse of my child had probably not been occurring for any great length of time. However, the alleged perpetrator had been terminated from employment in 2019 for viewing child pornography at work on more occasions. Had this been a prosecutable offense or even a crime, my child would have been safe. They would have had no access to my child. 3 years before this happened to my child, we could have saved her. I come before you today to share this story because I couldn't save her, but we can save somebody else from going through the same thing. We could save another child and another family. I can't begin to describe the impact this has had on all of us. There aren't adequate words in the language to do so. So I implore this committee to heavily consider this bill and to help us to protect our most precious residents that can't protect themselves. Child pornography is not a victimless crime. It cannot exist without victimizing a child. Before I had contacted Delegate Grammer and my state senator, I had researched the child pornography laws in all 50 states and the federal law. Not once did a Google search turn up a video that I could have accidentally accessed it. Not once. Not once. And accidental access, even if it is possible, doesn't involve sitting there for 5, 10, 20 minutes viewing something. That's not accidental. And in order for this to exist, there's another child out there that experienced similar things that mine did. That's all. Thank you.
Thank you very much for coming and testifying today. Ms. Jordan and the State's Attorney, Ms. Schellenberg.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in support of House Bill 233. Ms. Lewis, I'm so sorry about what happened to you and your daughter. And thank you. Thank you for coming here and asking for something to help others. Delegate Grammer has already explained that really this is just, it's a technical change to our law, which currently says that a person may not knowingly possess and intentionally retain child pornography. It adds in streaming. And I think Ms. Lewis is completely correct when she points our attention to survivors. The U.S. Supreme Court talked about a victim sexually abused by a relative when she was 8 or 9 and says a major blow to her recovery came at age 17 when she learned that images of her abuse were being trafficked on the internet. The digital images were available nationwide and worldwide. The knowledge that her images were circulated far and wide renewed the victim's trauma and made it difficult for her to recover from abuse. The full extent of this victim's suffering is hard to grasp. I know we often, when we talk about child pornography in this room, I've heard talk of magazines in closets and that sort of thing. That's not the way child pornography is possessed anymore. It is streamed sometimes. It absolutely is something that we need to update our laws on. And I have to say, Delegate Grammer and I also talked, and I said, well, you have to talk with Mr. Schellenberger because this couldn't possibly be right, that, you know, you can't be prosecuted for streaming. And, you know, Ms. Lewis talked about her search. Well, I do this for a living. I have never once accidentally accessed child pornography. It doesn't happen. It's not something you need to worry about. And for these reasons, we ask a favorable report on House Bill 233.
Mr. Chairman, members of the committee, thank you all very much for listening. Ms. Lewis, thank you so much for being here. Certainly your testimony is much more powerful than any of us. What we need to do is just tweak a statute that's been working for a long time because we have to keep up with the modern technology of how people are viewing child pornography now. So imagine even my surprise when I went to the statute and saw that it had to be saved or possessed or downloaded. And then I learned of streaming, which doesn't do either. So we have to keep up with technology. This is really just a very technical tweak that leaves the statute the way it is, the things that were illegal for a long time, the same the way they are. It just adapts to how people are watching child pornography at this time. So we're changing criminal law 11208 with this one tweak, and I think it's very important to know that it will track the current federal statute. So we are catching up with what the feds have done for a period of time, and I ask for a favorable report.
All right. We'll take questions for the panel now, and then there's a second panel here that we'll have in a moment. We have many questions. We'll go first with Delegate Munoz, then Cardin, Bartlett, Boucher, Arakan, Conway. Delegate Munoz, please.
Thank you, Mr. Chair. Thank you, Delegate Grammer, for bringing this bill to our attention, and thank you all for having the courage to come and speak to us today. This is shocking to me, I think, as both a parent and a legislator, that this is not in current law. It seems almost like just a technical update. It's 2023. It seems like a no-brainer, honestly, and I'm not surprised to see an overwhelming amount of favorable positions, both orally and in written testimony. But I do see a couple of unfavorable from the Maryland Office of the Public Defender, and so I was hoping you could perhaps address what in the world their issue could be with this, was mentioned, a very straightforward, simple update to Maryland Code to protect the most vulnerable among us.
Yeah. First off, let me give the credit to Ms. Lewis and the people here. I looked at it and I didn't believe it either. I called around to get a head check, and indeed there's this giant loophole in the law. So I believe the testimony of the Office of the Public Defender is regarding the law as it would pertain to issues of sexting, which we dealt with several years ago. But I would disagree with their argument based on technical grounds. If you look at what we did in that legislative session, is we created a totally separate piece of, I don't think it's actually in criminal law at all. We created a totally different section of law governing sexting that actually has pretty strong protections that would protect against anything that would happen in the arguments that they made. I would also point out that this is already illegal. So if their arguments were true, it would already be happening. So if you look at what we're doing in this particular bill, we're really just tweaking one small section of code that already defines possession. We're just kind of adding one kind of technical, one really just sentence that includes the new behavior.
Thank you so much. It sounds like their arguments may not be relevant. Thank you, Delegate.
Thank you very much, Mr. Chair. Thank you all very much for being here. Very quick question for State Attorney Schellenberger. Are you aware anywhere across the state where there was an attempt to prosecute a streaming and it wasn't able to be done? I guess save this specific example where it came to our attention, or perhaps a judge did allow for it to be considered a possession. I'm just curious if we've missed this before. I'm actually not aware of, but I never asked. But I believe Ms. Jordan or Mr. Grammer may know.
Yes. I believe that my colleague, Ms. Joyce King from Frederick County, has encountered that, and I believe she's also on the next panel. And could give
Thank
details.
Yeah, and just a brief comment on that. Unfortunately, there is a growth in the live streaming of this content, which is kind of pushing the issue here. Thank you.
Delegate Bartlett, Boucher, Conway, Delegate Delegate Bartlett.
Thank you, Mr. Chair, and thank you for bringing this bill, Delegate Grammer. And Ms. Lewis, thank you very much for coming down and sharing your story. My questions are to Mr. Schellenberg, State's Attorney Schellenberg. I have two quick questions. One is, you were saying that this mirrors the federal law. So the language with knowingly or intentionally access with intent to view, that's some federal language that already exists?
Yes, it's under 18, Section 252A4B, and it mirrors exactly what the feds have done and been able to do.
Okay, and so they've been able to obviously prosecute under that language on the federal level?
That's correct.
Okay, so my curiosity is, how many counts would you be able to prosecute under this law? So for instance, could you go with each frame? Could you go with, you know what I mean? Could you really just get them? You know, I was just wondering if you could go with each frame, or would it just be that one time of viewing, and then would it have to be a new viewing, new parties, et cetera, et cetera?
So I'll take a stab at that because I worked in IT. The difference is the downloading and it goes to RAM, which is hard on your electronic device, versus the buffering, because that's essentially what a streaming service does. It's just a temporary buffering of it all. I can't imagine that a prosecutor is going to try and get 20,000 counts of child pornography. I would assume it's one count.
Right, but that child in different, unfortunately, in different streaming scenarios, those could be separate counts.
Each separate one, yes.
Yes, okay, all right, thank you.
Delegate Boucher.
Thank you, Chairman, and thank you, Delegate Grammer. State Attorney Schellenberger, thank you very much for all you do for our community. Since this involves new technology, do you foresee any potential difficulties in prosecuting it if it's enacted? And if so, how do we overcome them?
So the Baltimore County Police Department, as every large police department, has very robust computer forensics units. Ours is very good. I believe they would be able to go into the individual's computer and be able to ascertain whether or not that had accessed it. It's very easy to look at download. It's very easy to look at keeping a copy and possessing. It's a couple more steps to learn what they accessed, but it can be done. And obviously, we would have to prove beyond a reasonable doubt that they did that in a courtroom, not only accessed it, but that it came under one of these qualifications of child pornography.
Thank you very much.
Thank you, Mr. Chairman. I was wondering, and thank you, delegate and witnesses, for coming in. I was wondering, how are you going to tell when a person is streamed this information? If they stream a whole movie and it's a 5-minute segment inside of the movie and they don't know that it's in the movie, it's just one of those things that comes up, and they watch this and they're not sure, and then next thing you know, they watch the rest of the movie because let's say they paid for the streaming.
I think the knowingly or intentionally culpability language within the bill speaks to that. So this isn't something you could accidentally do.
No, that's what you're assuming. That's what some of the video games now have back rooms that a lot of times I find the younger people who play these games know how to access the back room, and you might have to touch a car 2 or 3 times to get the certain kind of weapons. So you don't really know what's in these things.
But that's what the culpability protects against. So if you look at the bill, it says knowingly or intentionally. So these kind of mistakes, the hypothetical, I clicked on a link, I didn't know, those kind of behaviors wouldn't be covered here.
I purchased a streaming movie and I didn't know.
That
Yeah.
would be really hard. That would be a really
I
hard
mean, this is what
defense.
this bill is about.
Oh,
right?
yeah, absolutely.
You're trying to
It would-
refute what I'm asking
It would
you,
be a
right?
very hard case to, it would be a very hard defense to make, to say, I purchased this video and I didn't know it was child pornography. That'd be a very hard case.
What about page 2, line 12, in a state of sexual excitement?
That's
Can
current
you-
law.
can-
We don't touch that. That's current law.
Okay, so, and what does that mean in reference to male and female images, which would come through the streaming?
I'm not sure what your question is, Delegate.
Well, you're moving towards streaming and not videos and other things like that, which are already covered, right?
Yeah, so the only thing we're doing here
Sure.
is we're taking the current law and we're tweaking it a little bit. You know how the internet used to be? It used to be if you wanted to view something, even a video, these are before YouTube, you'd have to download that. And then peer-to-peer file sharing came and you could get on Napster or whatever and you could download files that way. Well, then YouTube came around and we have all these streaming services. And as sad and unfortunate as it may be, there are some technologies that stream child pornography. And what we're saying is we want to bring our statute out of the 1990s. We want to apply it as behaviors of people use these services in 2023. And we want to make sure our statute's up to date so that we can protect victims throughout Maryland.
Last part, if I may. So you might have a video that appears to be a cartoon, and deep inside the video in 40 minutes, and the video is 2 hours long, let's say, there might be this child imagery that's there, and it's computer generated. But under this bill, now this person has violated the law. Law enforcement knows sometimes what this movie might be. So by you just streaming the movie, law enforcement might already tag it and know that you're streaming something that has child pornography in it. Would that trigger law enforcement to come to your house or something like that?
I think it goes back to the culpability question of when does a defendant know, when, you know, that's really what it speaks to, is we're not going to be able to prosecute a person that's been tricked into doing something. I think we've got that covered.
So the knowingly possess and intentionally retain or intentionally and knowingly streaming wouldn't be 5 seconds of a movie that you accidentally download or actually accidentally streamed. I would have to prove that it was your intent to view this illegal material. And I would think that a 5 seconds, oops, I didn't know this was in there, and then turning it off would be really hard for me to prove knowingly and intentionally. If you're then watching it for 5 hours, I think that's a whole different
Right,
story.
and that's the question that I
And
asked.
that's what the jury would decide.
If you pay,
Where between 5 hours and 5 seconds, you know.
so you're saying if there's an offensive scene that might show someone doing whatever they're doing, and I paid $29.95, as soon as I think it's offensive or is in violation of this law, I should turn the television off or turn the streaming off, shut it down.
Right, and you also have in the old law, that is going to be now in this current law, it's a defense to a charge of violating this section that the person in good faith took reasonable steps to destroy each visual representation and reported the matter to law enforcement. So you could affirmatively say, hey, Mr. Schellenberger, I didn't do anything wrong, and oh, by the way, I got rid of it right away, and I called the police and let them know what happened. So this is a very good statute. It's been around a long time.
And so if you don't call the police, you didn't do your.
I still have to prove knowingly and
Okay.
intentionally.
Thank you very much. Thank you, Mr. Chairman.
Delegate Munoz.
Thank you, Mr. Chair. Based off those questions, I had a couple clarifying questions. I believe I heard testimony that, ma'am, I couldn't remember how many years you said you've been doing this work. But if you could remind me, and I believe you said in all that time you've never accidentally stumbled across any streaming versions of child pornography.
That's correct. It's my 29th legislative session.
Okay.
And all of that has either been on domestic violence or sexual assault work. And so certainly in the course of working, we read articles, we look at laws, we look at things for our clients, we have all sorts of things. It's a wonder the FBI has never shown up at my house, but, it's just, it never happens accidentally that you access something.
Thank you. And my only other clarifying question was, since this is just adding what seems to be a very small common sense piece to this bill, have you found in any of your experiences, anyone on the panel, incidences of people accidentally obtaining child pornography in any of the other forms and then using it extensively to the point where it becomes a criminal offense?
Usually those cases don't even get to me. Usually that's, decided at the police level, and that's what the investigation is about. The vision I have, Delegate Conway, is, this is going to be a case where we're in this person's house and grabbing this computer for another reason. A judge has authorized us to do a search, and the search includes grabbing all computers, and that this computer will then go back to that crime lab and those forensic people, and they will start digging in. That's kind of my vision of how it would be. I don't think it would be anything, other than that.
That's very helpful. Thank you so much.
Seeing no further questions for the panel, we thank you all very much.
Thank you.
We're going to hear from a range of other people right now still in favor of the bill. Joyce King, Peggy Cairns, Brykina Kay, Vince McAvoy is signed up to testify in favor. Those will be the last 4 people to testify in favor. 2 of them are virtual, so I see Ms. King, so we'll take Ms. King and then the 2 people who are here virtually, all of them for 2 minutes. And then there are 2 people set to testify in opposition, and we'll get to them right then. I have to step back for a moment, so you'll get the Vice Chair for. Please go ahead for 2
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Again, I'm Joyce King. I am Chief Counsel at the Frederick County State's Attorney's Office. I'm here on behalf of the Maryland State's Attorneys Association. And coincidentally, I lead the Cyber Crimes Task Force, so I prosecute solely child pornography. And I'll address some of the questions and some of the comments earlier. I do stand that this is just a modernization of the child pornography statute. And Delegate Cardin's not in the room, but as to his question, yes, we are unable to prosecute this. We have things, and I'm going to be very careful about my testimony because obviously what I do has some sort of intelligence, forensically, investigatively, so I don't want to put out there how you can get child pornography, so I'm going to try to be tactful, and if any of the delegates have any questions offline, I'm happy to answer more transparently. But yes, there are forensic artifacts that we cannot prosecute at this time the way the statute is written. And as to Delegate Conway's question, I want to add another lens. We're talking a lot about streaming and things like YouTube, right, in the dark web, which that exists. Cloud storage links exist of child pornography that we currently cannot prosecute. Chat rooms where they delete the content, but there's artifacts that existed and it was viewed. And something most disturbingly that we haven't touched on yet is live sex streaming shows of minors. And that is something that currently I have the most of my cases on. And they exploit children not just here in the United States, but third world countries. And you could imagine how difficult that is to prosecute. But we have individuals here in Maryland that will pay a facilitator in a third world country for a live sex abuse show of a minor. And we cannot prosecute that under this statute. So this is absolutely a necessary expansion of the definition, a modernization. There are things like artifacts, cache files, temp files that do exist, and would, to Delegate Conway's fact pattern, we would be able to see that this existed within a movie. So that's not a scenario that I'm concerned about. So that'll be my remarks. And we ask for a favorable report.
All right, I believe we are now turning to our virtual. Yes. Well, I think these folks testifying online are on her side. Yep. Yeah, we have I want to say 3 online people, and we'll go 2. No. Vince McAvoy also. Okay. Yeah, Vince McAvoy, you need to unmute yourself. Okay, why don't you go ahead? You can go first.
Grateful. Thank you so much, committee. I very much appreciate Delegate Grammer bringing this bill. I very much appreciate that this has a cross-file. The issue of the federal code as well as our state code, which mimics that, came into discussion in December. I had attended the NCOSI seminar in November and saw that this is not a small issue. These are millions, so I very much appreciate Frederick County representing very strongly that we need this, and we need this to be able to prosecute these cases. There was a horrific case that just made light of day early this year. I'll send you all the email from that, where the case was used to actually sell adopted children. This is a horrific thing, and I very urgently ask you to approve this bill, to get it through. I think it's a very small measure to ask. Thank you for your time.
All right, next we'll hear from Peggy Cairns and then Brickena Kay.
Thank you. My name is Peggy Cairns. I'm with the Maryland Coalition Against Pornography, and I act as the education chairperson and newsletter editor. Our organization has been in operation since 1986, and I'm a mother of two and a grandmother. And of those years of operation, I've been watching for articles about child pornography for about 32 of those years, and like one of the other testifiers, I have not accidentally come across child porn, never deliberately either. I won't repeat a lot of what has already been said, except I just want to say that the live streaming aspect of this has truly become horrific, and one of the extreme forms of it. The people who are viewing the porn are able to watch children and perform according to what their traffickers are being told to have them do. It's tailor-made porn for the viewer. These images are not being downloaded, so it's hard to have digital evidence that an investigator can delve into, and it's occurring in more horrific ways than ever. So I hope you will see this as we do, that we really need to provide a legal recourse to pursue those kinds of perpetrators. We've provided in our written testimony a link to the article in Wikipedia dealing with cybersex trafficking, which would give you a great overview of the history of it. Footnote number 104 mentions cybersex rape that was being viewed back in 2009. So this is not extremely new technology. It's been going on for quite some time. We urge a favorable report on this bill. Thank you for your consideration.
All right, and last but not least, you have 2 minutes for Brickena Kay when you're ready. And you need to unmute yourself.
Good afternoon, and thank you all. My name is Brickena Kay, and I am a volunteer for the Maryland Coalition Against Pornography. I am a mother of two. I have a daughter in high school and a son in middle school. And when I think about the wild cyber reality out there, it just, I can't rest. I don't know what they might come into contact with. Now, regarding that live streaming of child sexual abuse, MCAP actually recommends that article that we submitted in writing, and that will give a background and more details in the history and technology that is included in the background and all the permutations of this kind of crime. Now, statistics on the magnitude of cybersex trafficking are actually elusive. That's because it's very difficult to document and to track live streaming because there is no trace of it. But the fact is that it is a billion-dollar industry and it is surging. It's still expanding. And That is because of globalization and technology advancements. And there's another big problem that is the encrypted nature or the capability to encrypt things. So it's very hard to track. Now, in 2021 alone, the National Center for Missing and Exploited Children received nearly 85 million images, videos, and other files containing or related to child sexual abuse and exploitation. And those are only the ones that were able to be detected and reported, not the entirety. Another aspect is the shockingly low cost of all this bill. For example, the Australian Institute of Criminology found that, generally speaking, these sex offenders are able to pay around $51 per live stream. But behind all these live streams, there are actually live victims, live children, and they're being put in danger and emotional and physical trauma. So we believe that Bill 233 will actually move Maryland law in a crucially needed step to uncover and recognize these extreme wrongs and maybe help our law enforcement to correct these wrongs. Thank you.
All right. Delegate Bartlett, you still have a question? No. Okay. Delegate Conaway and then Grammer.
Thank you, Mr. Chairman. Thank you, witnesses, for coming in to testify. I believe your name is King, is that correct?
That's right, sir.
Thank you, Witness King. I was wondering, you said law enforcement knows about the subcontent of a stream, and I was wondering if accessing the stream, does that trigger law enforcement? Does some kind of trigger come through to law enforcement, say, hey, this person just downloaded this stream that we're aware of?
Not necessarily. The way that it currently works through the National Center of Missing and Exploited Children, things are called, something that is called a cyber tip is generated. So for currently, internet service providers usually watch if on their platforms there are child pornography and there are known images, known hash values that are kind of the fingerprint of an image, and that will generate a report to the National Center of Missing and Exploited Children. Those reports are then sent to the appropriate law enforcement jurisdictions for investigation. So in some instances, yes, if the stream is located on a compliant internet service provider, but in the instances of dark web or these more underground arenas, we usually start investigations with undercover operations and things of that nature.
And how does that work in reference to computer-generated images?
So right now with the National Center of Missing and Exploited Children, they will identify known child exploitation images. So if that's a known image, then that's a known file to them. So unknown images, that would have to be seen by law enforcement to be identified whether it's a child or not.
So once you have this cyber chip, it's not really that difficult to track the stream?
Correct.
All right, thank you.
Thank you, Mr. Chair. And Ms. King, very briefly, it's the first time I've been amazed by a bill I've sponsored. Seriously, this is crazy. Can you tell me how long this hole in criminal law has existed?
I've been doing this for almost 10 years, and I think that there's been an upsurge post-pandemic with a lot of the live stream. We've seen a dramatic increase. I think Nick Mick said that it was about a 200% increase after the pandemic.
Final question. The Office of the Public Defender, you're familiar with the sexting case and the girl who was prosecuted.
Correct.
The Office of the Public Defender makes the case that this could kind of expand the law so that it could re-enable the incorrect prosecution of that particular crime. Can you because you deal a lot with this kind of subject matter, can you speak to that technically? Is there a conflict here? What's your position?
I did. These are two different tracks. We do not prosecute sexting any longer. I mean, that is something that, like I said, this is my subject matter, and we do not deal with any juveniles whatsoever. Those are all rooted through our juvenile division. So this statute would not affect that whatsoever.
Okay. Thank you, and thanks for your support.
All right, that looks like the end of the questions. For the proponents, we have two people signed up in opposition, Elizabeth Hilliard and Michael Gross.
Good afternoon, Vice Chair, members of the committee. I understand that there are a lot of questions for our office's opposition to this bill, and I will do my best to answer them. We first want to sincerely express our concern and our care for people who are subject to the production of child pornography. And we in no way intend to minimize the damage that that causes. But we have sincere concerns, and Michal, my coworker, will discuss the sexting piece more extensively, but we have sincere concerns about the breadth and the scope of this bill and its potential application. First, as has been extensively discussed, the accessibility and the popularity of streaming and, for example, communication media such as Snapchat. I know there are other ones that my nieces and nephews would know that I don't know, but that allow a video or other photo to be delivered to a person could fall under this statute, even if that person does not know that the subject may contain images of someone under the age of 16 and fall within this category. So for example, if you have a 19-year-old and a 15-year-old sends that person video images of either themselves or other people involved in conduct prohibited by this law, that person would be subject to prosecution under this law, regardless of whether they had any knowledge of that law, of what the video content would be, and regardless of whether they solicited or requested that video. And in fact, a concern specifically is, for example, if a 15-year-old and a 19-year-old have a relationship and then break up, this could possibly be used in a detrimental way against the 19-year-old because there may be some discord following the breakup, and that the 15-year-old could, almost using this as a sword, send images and videos that could create a violation of this law. We will also point out that while this language is very similar to 18 U.S.C. 2252, it is not actually the same. This law permits, as drafted, knowingly or intentionally accessing with intent to view. The federal law only permits knowingly accessing with intent to view, and it includes an exception for less than 3 images. With that, we urge an unfavorable report on this. We again thank everyone for bringing this bill and understand the import of this issue, but we ask the committee to return an unfavorable report.
All right, you go ahead.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Michal Gross, and as my colleague Ms. Hilliard said, I represent youth and young adults, and so I will be focusing more on how this bill, HB 233, would affect adolescents. And I'm testifying today in opposition to HB 233, which would expand criminal law section 11208. So as have been discussed, the expansion would be to include individuals who just knowingly or intentionally access, instead of those who intentionally retain. And the expansion could have unfortunate consequences of selective criminalization of adolescents for mere curiosity. So I won't go into the details of the 2019 case in Ray SK, but what happened in that case, the result of that case, was that a child was prosecuted for child pornography based solely on images or videos of themselves engaged in consensual behavior. And the court called to the legislature to fix this, saying there may be compelling reasons for treating teenage sexting different from child pornography. What happened in 2021 is that a bill was passed. However, that bill, while well-meaning, instead endorsed the court's finding, leaving the matter of whether adolescents should be prosecuted for sexting to the discretion of prosecutors, police, and judges, and allowing them to continue to be charged with distribution, possession, and production of child pornography for sending or receiving images of themselves engaged in consensual sexual behavior. So instead, what the bill did was it endorsed that this could be charged as child pornography and just made the consequences, what happens in the juvenile court system, discretionary. This is happening. It happened to SK, and it's happening to other youth in the state of Maryland. The problem in SK was the discretion that led her to being charged, prosecuted, and convicted for sexting. Therefore, any expansion of child pornography laws, because in 2021, the bill that passed can lead to disastrous results for youth, the very children that child pornography laws intend to protect. Teenage sexting is not child pornography, and until we change the definition of child pornography to treat teenagers whose sex is entirely different from adults who possess, produce, or distribute sexually explicit images of children, any expansion of the definition of child pornography runs the risk of selective criminalization of youth. And I'm happy to answer any questions.
Are there any questions? Yes. Delegate Munoz.
Thank you, Mr. Vice Chair. So to the last person, I hear about sexting again, and I think we already established that that has nothing to do with this bill. So I'm going to go back to our first witness. And I just want to clarify, you were discussing images and videos in a broad sense, and based on the change that this makes to this aspect of the code, is your office against this entire aspect of the code altogether?
I'm sorry, I'm confused by that question. As in the existence of a prohibition against child pornography in general?
Yes.
No. What I'm trying to clarify is that there are many circumstances that will fall into this new definition that do not fall into the category of child pornography, and that this opens a broad scope for prosecution when there isn't necessarily all of the other components that we traditionally associate with viewing child pornography.
So
as I mentioned, Snapchat and the other services.
In the way the law is already written, does your office take issue with anything in particular the way it's currently written, or are you happy with it the way it's written right now?
It's a good question. I think I would have to say that the way that it is currently written, with the piece requiring knowingly possess and intentionally retain, creates a safeguard for people that we used, McCall and I used in our examples, that does not exist in this iteration of the bill.
And so this is knowingly or intentionally accessing. So you take issue with retaining versus accessing.
Retaining require
the opposite. You're fine with you have an issue with retaining, but you think it's okay for people to access with the intent to view.
Other way around.
Okay,
the retaining requires someone to cognitively make the decision, right, to retain something that has been produced and qualifies under this statute as a child pornography, production of child pornography, whereas merely viewing does not demonstrate the same cognitive awareness and cognitive decision to engage in consuming and retaining child pornography, and creates a much broader scope than the one that is existing within the limitation intentionally retain. And that's also why I pointed out the restriction in the federal law, which creates a safeguard for, under 3 or 4 images.
Okay, so that's a fascinating interpretation. Do you have any psychological data or studies to back that argument up, that retaining versus accessing are different? And then if you do, is there anything that differentiates like an age group? Because I'm assuming an 80-year-old, a 50-year-old, even a 40-year-old is not necessarily going to be understanding streaming, and maybe they're still downloading things. But anyone 40 and under right now would be streaming almost everything. So that's an interesting argument. I'm just wondering where it comes from.
Like the intentionality, right? Someone could view something, see it, and not want any part of it, but they've already viewed it. Whereas if they're retaining, they're taking that additional step because they actually desire to participate in it and are expressing desire to retain it. Our concern is that if we limit it to view only, there isn't that ability to say, well, I didn't want that, I didn't, I don't want that. And that's our concern with the breadth of that scope.
Got you. And were you in the room when the original panel spoke?
I was.
And dealt with that issue? Okay, awesome. Thanks so much.
Delegate Erican.
Hi. Do you have any children of your own?
I do not.
Okay, thank you very much.
All right, I think that's going to end this bill hearing. We are moving on to House Bill 226. Delegate Love.
Good evening. May I bring up my panel?
Yes, please. Looks like you've got 7 in-person witnesses.
Yes.
Does that sound right?
That sounds about right.
Okay, so we'll break them in 2.
Okay, great. Thank you. Good evening, Mr. Vice Chair, acting as Mr. Chair, members of the committee. Thank you all for being here and for your attention this evening. I am Delegate Sarah Love, here to present to you HB 226, Criminal Law, Person in a Position of Authority, Sexual Offenses with a Minor. Some of you will remember this bill. I have brought it before this committee before, but many of you are new. So for all of you, again, thank you for your time and your attention to this issue. I want to start with a little bit of background. As most of you probably know, in Maryland, the age of consent for sex is 15. We have said as a state that there are certain people who can consent, 16 and 17-year-olds, who we do not believe should be having sex with certain adults. And those adults we categorize as persons in positions of authority. This is separate and apart from family members. This is a part of the law that's called person in the position of authority. And it says if someone is 21 or older and is employed by or under contract with a school, they should not have sex with a minor. That bill, or that law, while it's very important and great, has a big loophole to it. And this bill today is to close that loophole. This bill is to recognize the reality of our children's lives. I have 2 teenagers, so I can tell you that kids spend a lot of time with coaches, with music teachers, with art teachers, with all sorts of other adults who are in positions of authority, but who are not employed by schools. So that is the loophole that this bill looks to close. This bill actually came to me from a constituent. There was a father whose daughter was interested in music, and a local school recommended a guitar teacher. This guitar teacher was not employed by the school. And for 2 years, this guitar teacher groomed this young woman. And when she passed the age of consent, they started having sex. That destroyed the young woman. It destroyed her family. That family is still dealing with this trauma, and sadly, that young woman died last year. So we have state's attorneys who will testify you, but that situation is not unique. This happens all across our state with all fencing coaches, art teachers. It happens. And so that's why this actually is a priority bill for the state's attorneys who practice in this area. I will just close with this bill is cross-filed by Senator West, and Senator Folden has asked to be on this bill because of his experience as a cop and as a coach. Based on what he has seen, he wants to take over and sponsor this bill in the Senate. So with that, I will turn it over to my panel. I'm happy to answer any questions, and I thank you again. I ask for a favorable report.
Whoever would like to go next.
Good evening, Chairman Moon, members of the committee. My name is Lindsay Carpenter. I'm a prosecutor in the Special Victims Unit at the Frederick County State's Attorney's Office. I'm here urging a favorable report. I did submit written testimony. I did want to expand upon the case that I had in Frederick County. As many of you may know, child predators actually seek out areas of employment that give them access to children. The case I had in Frederick involved a martial arts instructor who was 22 years older than my victim. He started grooming her at the age of 14, and he specifically told her that they could not engage in any type of sexual activity until she turned 16, as that was the age of consent. Shortly after she turned 16, he took her virginity, and the abuse continued for years after that. He specifically knew the area of law and knew where his boundaries were, or so he thought. I was able to prosecute him for a few incidents of abuse, as he did have care and custody for very little incidents. However, there were numerous incidents that I was not able to capture as a result of this loophole. I also wanted to touch base on Ms. Feinstein's case. She unfortunately was unable to be here. Her case also, that music teacher groomed that student knowing the age of consent was 16. Groomed the student for years leading up and waited until the student turned 16 to engage in that sexual activity. There were also 2 cases in Charles County. One was a gymnastics coach with a 16-year-old. There was also a cheer coach and 2 different 17-year-old students. This individual was a volunteer coach, was not employed by the school, did not have care and custody. So there is this loophole that these child predators are exploiting and they are aware of. We ask for a favorable report.
Thank you, Chairman, Vice Chairman, and members of the Judiciary Committee. I write in favor of support of House Bill 226. I'm Christine Dula-Rickard. I'm a Deputy State's Attorney for Queen Anne's County. I'm a leadership member of our Child Advocacy Team and a member of our Sexual Assault Response Team. In my role in all of those things, I'm approached often by people who are looking for help when their families have been harmed. In a recent case, a mother approached our team because of something that had happened with her daughter. She had learned her daughter was having a sexual relationship with a former teacher who was supervising her daughter's participation in a nonprofit art program. The child was 17, struggling with her own sexual identity and her parents' recent separation. The adult had been a short-term substitute at the child's school. That's where they met. And she was a recent divorcee with 2 small children. Her full-time job was the head of a nonprofit art program, which included the supervision of children who were under the age of 18 years old. While the adult was working at her school, the child found in this teacher the role of confidant and ally. And when she left the school and began that mentor-mentee relationship, that progressed into a sexual relationship, and they became lovers. As the adult was supervising her, the mother was permitting her daughter to participate in this nonprofit art program, and that was where they began exploring her child's sexuality. They began planning a future together in which this child was going to become her husband and the father of her children. The child no longer was interested in college or finishing high school. It was just her role with the adult. She was malleable and susceptible to abuse, just like all children. I urge your support of this bill. Thank you.
Good evening, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 226. This is an extraordinarily complicated area of the law, and so it's also something that has developed over time, the statute. So just to walk people back for folks who are not aware of it, child abuse, child sexual abuse, you need to be a family member, a household member, a person with care, custody, supervision. Right, so those predators can be prosecuted now. And then because of a Court of Appeals decision, we added in this law here, the 3308, that specifies certain school teachers. So it's this very narrow category of predators who are not people who have care, custody, supervision of the child and are not working for kids. And you know what, from the kid's point of view, it doesn't matter. Right? It really does not matter if that adult in their life is someone who works for a school system or doesn't work for a school system, or is teaching them guitar at that moment, or taught them guitar 5 minutes before, but the lesson is over now. And so this bill is trying to close that remaining loophole. A couple of things to note. There's been a lot of discussion, particularly across the street, about people who are close in age, and kind of a concern that we not somehow criminalize, young love, right? The person, the older person has to be at least 21 years old, right? So we're not talking about an 18-year-old who is having, a relationship with a 16-year-old or 15-year-old. So the child also must be a minor. You'll see language here that talks about the inability to have a relationship with someone if you used to work at the school, right? Well, that goes away when the child turns 18. So it's not a lifetime ban on having a relationship with your children. So this really it's very carefully balanced. I think that it's probably reasonable to expect that your sister committee across the street will have some additional amendments to it, but we do urge a favorable report of House Bill 226 as it's written. Thank you.
Mr. Chair, I'd like to correct the record. I believe I misspoke and said the age of consent was 15. Ms. Carpenter clarified it's 16, so I just wanted to correct that. Thank you.
All right, are there any questions for the sponsor or witnesses? All right, Delegate Munoz.
Thank you, Mr. Chair. Delegate Love, thank you for bringing this bill. I remember it from last year, and I'm so sorry to hear of the death of that young woman whose story I heard for the first time last year. I cannot seem to find our votes on it. We heard this in committee, but did we not vote on it last year?
To the best of my knowledge, you did not.
Okay. Okay. And is there anything that you would like to add to share with the rest of the committee about, I know you said this is a priority for the state's attorneys, but why we should be moving this through both the House and the Senate this year?
To protect any other 16 and 17-year-olds, because this is happening, as you hear, and they can't be prosecuted. And these predators know. They know what they can get away with. Thank you.
Thank you.
If I can just add to that, if we don't prosecute them, they can continue to get jobs in places where they continue to have access to children.
That's a great point. Thank you so much.
All right, Delegate Boucher and then Conaway.
Thank you, Vice Chairman. Thank you, ladies, for bringing this forward. I'm bringing over the evidence from the testimony from the Office of Attorney General. They're supporting it with amendments, and they go into 4th and 2nd degree sexual offense. It's very confusing for me to understand. Could you clarify that for me?
I think he's here. He's going to be on the next panel.
Take it later. Okay. Thank you.
And I have no objection to that amendment.
Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. I was wondering in a case where the minor might be a male who's underage and can express that they are attracted to, let's say, their teacher who's clearly over their age and has the age difference. Who presses the charges in that kind of case where you could talk to the individual who's underage and they say, actually, I was in pursuit of the teacher? Who presses those charges?
Well, in the case that we had, we could not prosecute the teacher, for the sexual relationship. She did send some very explicit text messages, so we did charge her with telephone misuse to get her on a probation so that she could get some mental health counseling, but that was the most we could do.
I'm
sorry.
The victim, I'm sorry. The victim was a minor, is that right?
The victim was a minor, that's correct.
Did the minor say that they willfully, I know they can't consent, but did they say, well, I was engaging in this ongoing situation with this person, and I edged it on? So does the parent in that case have to say, we're going to bring the charge, I would like to press charges for my child, or or does the state pick it up, or the city picks it up and says, we're picking this up because it was a minor involved? How does that work?
I believe the parent went directly with either the Department of Social Services or the local police agency first, and then an investigation began to see what happened, because I think initially there was some confusion about whether or not the relationship actually, the sexual relationship began while the woman was teaching at the school. But after we learned that she was not teaching at the school and that it happened while she was a mentor at this nonprofit, it was the mother of the child who made the initial report.
Okay.
The child did cooperate with the investigation.
Right. Thank you very much.
All right, looks like we can move on to the next panel. I think we're looking for Molly Cupid, Scott Schellenberger, Debbie Feinstein, Joyce Lombardi, and we might as well bring up Chair Walter also. All right, whoever would like to go first.
I'll go first. Good evening, Vice Chair Moon, members of the committee. My name is Joyce Lombardi. I represent the Center for Hope. We are a comprehensive violence intervention program that's located in Baltimore City, and we serve the Baltimore region. Because it's late, I will largely say me too to many of the other panelists, but I do want to only bring your attention. I know a lot of you are lawyers, so my point, and it's written in our you have our written testimony from Center for Hope, and it's just for those of you that like to harmonize statutes. I'll only direct your attention to Family Law 5701, and the definition of child abuse in that statute is already somewhat akin to what we're trying to do here with fourth-degree sex offense under the criminal law, in that their definition under family law for child abuse actually includes what we're talking about here, a person who, because of the person's position or occupation, exercises authority over the child. And I only bring that up because the intent perhaps is the same here, which is it's not a care or custody, it's do you exercise authority because of your position? As Ms. Jordan said, we don't care who's writing the paycheck, we just care who's hurting the child, and we ask for your favorable report on 226. Thank you.
Stuck in an earring. Good evening. Thank you all for your attention. I know it's been a long day for you. My name is Molly Cupid. I am the clinical director of the Treehouse Child Advocacy Center in Montgomery County. And I also previously investigated child sexual abuse allegations for Montgomery County Child Welfare Services. In my time with child welfare, I investigated several cases involving 16 and 17-year-old children who had been sexually abused by teachers and coaches while believing they were in consenting, intimate relationships with these adults. In fact, I had one case where a 16-year-old girl believed she was in a consenting relationship with her biological father, and she did not understand she was in fact being abused. In my current role with the Treehouse Child Advocacy Center, we have had 3 16 and 17-year-old children referred to us for trauma-focused therapy this school year alone, because these children had been sexually abused by an adult in a position of authority, and the children believed that they were in consenting sexual relationships with these men. All of these cases are covered by the current law, but I share that information to outline 2 things. The first being the prevalence of adult predation on 16 and 17-year-old children, particularly girls. The second being the false belief held by 16 and 17-year-old kids that they are able to understand and consent to a sexual relationship with an adult at all, but particularly when there is a power imbalance. As children are taught from a young age to listen to adults, respect adults, follow instructions, and not talk back, I would argue that by solely being an adult, you are in position of authority over children. When you include formal authority in the form of a teacher-student relationship, you have further positioned the adult as an expert authority figure whose role is to teach and guide. Whether these classes take place in a school building, extracurricular facility, or a home, we are still presenting the teacher as a trustworthy authority figure, and not just to the child, but to their parents and caregivers as well. It is our responsibility to protect those who cannot protect themselves. As such, I ask for a favorable ruling in this bill. Thank you.
If you don't mind, actually, why don't we do favorable with amendment after we finish all the straight favorables?
I'm a straight favorable. Good evening, Scott Schellenberger, State's Attorney for Baltimore County, asking for a favorable report. I think everybody has really covered it. We passed this statute years ago because we had a case involving a teacher, and there was a hole in the law, so we crafted this statute, we passed it, and it was used for teachers, but now the changes to the statute faces the reality of what the children in our lives do every day, and that is, you know, the swimming coach, the art teacher. You've already heard the list, but of course, here's one more. In Baltimore County, we had a case. It was a fencing coach. The young lady was 16. She was getting private fencing lessons. The parents would agree that the fencing coach could bring her home. Unfortunately, he was driving her to a park, and they were having sex. And when we tried that case, we lost the sex offense charges because there was an issue of consent. And so if we had this fix, we could have prosecuted him under this statute and been very successful. Because at that point, we want to make sure that this individual doesn't take advantage of other young people. And you've heard some very good testimony about how they actually seek these children out and try and get these kind of positions to take advantage. So I would urge a favorable report. We think it's extremely important that we fill this gap, and we think the statute is well thought out, but we'll certainly defer to some ideas that the Attorney General's office has.
And good evening again, Jer Welter on behalf of the Office of the Attorney General. And I'll just get straight to our proposed amendment because we agree with everything that the previous panelists have said. It's a relatively technical point, but it's an important one. And it arises when this offense, which is it's fourth-degree sex offense. This person in a position of authority is one type of fourth-degree sex offense. It arises when this offense is charged in conjunction with other crimes. So there are multiple crimes alleged against the person. Fourth-degree sex offense carries ordinarily only a potential 1-year penalty. And especially when you are adding additional potential elements to it, as we are in this bill, it creates the prospect that it can be considered a greater inclusive offense of the other offenses because it has more elements. And then it would cap the potential penalty for all of the offenses to that 1 year. And that was the case in the Frazier case, which is cited in my bill or I cited in my testimony, where the defendant was convicted of both fourth-degree sex offense and second-degree assault. Second-degree assault carries a 10-year penalty. But because second-degree assault was considered a lesser included of fourth-degree sex offense, it was capped at the 1 year. And so that's the purpose of our amendment, is to ensure that fourth-degree sex offense, not exclusively, but particularly in this circumstance of person in position of authority, is not considered a greater inclusive offense of any other offense, so that it does not have that sentence capping effect. And we'd ask for your support with that amendment.
Any questions? All right, looks like, Delegate Conaway.
Thank you, Mr. Chairman. Thank you, witnesses, to come in and testify. I was wondering on page 2, where it's talking about lines 23 to 27, if the, Mr. Schellenberg, if the minor was 16 years of age and the offender was, let's say, 25, but they weren't instructing the minor, but were instructing people at the institution who were minors, would that person be able to be charged?
I mean, that's a really close one.
I'm looking at page 2, 23 through 27.
And I'm sorry, are we under contract? Yeah. Because he would be under contract for the institution. You are correct.
Yes, I'm correct. Thank you so very much.
Right.
I'll leave that at that.
All right, that looks like the end of testimony on House Bill 226. Thank you very much. We're going to go on to House Bill 280 from Delegate Davis. Thirty-four witnesses left? All right, 34 witnesses left in the evening.
I have 8.
All right, whenever you're ready.
Thank you. Do I have to push this?
It's already on.
You don't need to touch anything.
Good evening, Chair Moon, and esteemed members of the Judiciary Committee. My name is Delegate Deborah Davis. I'm from District 28 in Charles County. I'm here to present HB 280 entitled Cannabis-Related Offenses, Civil Penalties. This past November, the legislature took the bold step of presenting the legalization of adult use cannabis as a referendum. Marylanders overwhelmingly voted to support legalization of cannabis in our state. They entrusted us to create the framework for legalization. It is our responsibility at this time to do our part in stopping mass incarceration, minimizing police interactions, pretextual police stops, loss of employment, underemployment, excessive fines, and loss of generational wealth, which has debilitated over-policed neighborhoods related to the use and possession of cannabis. HB 280 aims to replace criminal penalties with alternatives of reasonable fines, rehabilitation programs, and community service. It centers our citizens' safety and equality and quality of life as the focal point for the proposed legislation. I submit to you that these policies and practices of incarceration and if these policies of practices of incarceration and excessive fines continue, we have failed our communities. I respectfully request a favorable report on House Bill 208. I want to make a note that it is a Black Caucus, this bill is a Black Caucus priority, and I want to turn it over to the people with the boots on the ground. Thank you so much.
Good evening, Chair Moon and members of the committee. My name is Yanetta Emanuel, Public Policy Director with the ACLU of Maryland, here in full support of HB 280. In 2014, the General Assembly decriminalized the possession of 10 grams or less of marijuana, in large part because of the disparate enforcement of marijuana laws on Black people. Similarly, this last November, Maryland voters decided that recreational use of marijuana should no longer be criminalized. However, simply legalizing will not fix this issue. Criminal penalties for marijuana-related offenses are still on the books. Under current law, possession over the civil use limit and possession with intent to distribute are misdemeanor offenses and carries a penalty of 6 months to 3 years of incarceration. A criminal record can and does create a barrier to employment for many Marylanders. A misdemeanor conviction also hinders an individual's access to stable housing and a range of public benefits. With higher conviction rates of persons of color, they bear the brunt of collateral consequences stemming from misdemeanor convictions. Exclusion from the job market, stable housing, and countless other crucial services perpetuate a cycle of imprisonment plaguing communities of color. And without gainful employment and stable housing, individuals are forced to livelihoods of criminality. Last year, the Maryland State Commission on Criminal Sentencing Policy released data on sentencing trends in Maryland courts. And just really quickly share some stats with you. Between 2017 to 2021, Black people made up almost 68% of the people sentenced with misdemeanor or felony offenses, and Black people served longer time for these offenses, and almost 50% of them that were sentenced, this was their first offense. And lastly, I'll leave you this. Furthermore, according to the racial impact statement that the Department of Legislative Services provided, a total of marijuana-related charges in 2020, only 23% led to convictions, and Black people accounted for 52% of those convictions. So for that and all the other reasons, in our written statement, we urge a favorable report on HB 280. Thank you.
All right, good evening. Davon Love, Director, Public Policy Leaders of a Beautiful Struggle. The notion of the inherent criminality of people of African descent is ubiquitous in the American collective consciousness. I don't have the time to go into all the historical markers to substantiate that claim, but when we look at the past 50 years of the policies of the war on drugs and the politicization of this inherent notion of criminality, we can see that law enforcement has become dependent on cannabis prohibition policies as a crime-fighting tool. And unfortunately, when we look at, for instance, in the state of Maryland, the judiciary provided some numbers for 2018 and 2019 that in those 2 years combined, in the blackest jurisdictions in the state, Prince George's County, over 2,700 charges for marijuana possession, cannabis possession, and Baltimore City, slightly over 1,400. So it's clear that law enforcement is dependent on, relies on cannabis prohibition policies. The challenge is that there is no evidence that cannabis prohibition policy is an effective public safety strategy. In fact, the Mayor's Office of Neighborhood Safety and Engagement on the 17th, I don't know if they testified here, the commissioner, the state's attorney, but they testified over in the Senate. And one of the slides provided by Director Jackson of the Muncie office says that only 14.5% of the homicides in the Western District were connected to illicit drug activity. So if we take that as a reasonable sample size, what that leads us to believe is that cannabis prohibition policy actually doesn't square with the data as to what precipitates the violence in the community. And so I wanted to make it a point to emphasize this because law enforcement will continue to talk about them needing this in order to effectively address public safety. Last thing I want to say, in California, when cannabis was legalized, one of the things that was urged by many of the major beneficiaries of the industry, many of them not black or brown, they urged lawmakers to crack down on cannabis prohibition policy in the name of trying to do something about the black market. And so the exposure of people of African descent to the criminal justice system under the guise of public safety is what exacerbates these problems in the first place. And so with that, we urge a favorable report on House Bill 280. Thank you.
Good evening, and thank you for having me here. My name is Michelle Hall, and I'm an attorney with the Office of the Public Defender, testifying today in favor of HB 280, which would eliminate the criminal penalties for possession of cannabis and possession with intent to distribute cannabis, and we urge a favorable report. The goal of this bill is simple: to ensure that in a Maryland where cannabis will be legal, that individuals do not continue to suffer the harsh collateral consequences of a criminal conviction for engaging in the cannabis market outside of the legalized scheme. This bill really strikes the appropriate balance between the state's interest in regulating the marketplace while not criminalizing individuals for engaging in the very same practices that will be an economic boon for the state. The civil penalties in this bill are proportionate and appropriate responses to cannabis possession and distribution after legalization. Perhaps most importantly, I would really emphasize, as my colleague Yannette did, the racial equity impact note that makes clear how Black individuals are disproportionately arrested and prosecuted for cannabis possession under the current regime. This is the reality that I see every day as a public defender. When defending cases in Prince George's County, I never had a marijuana case from the University of Maryland, but there were plenty originating in the Black neighborhoods in the county. This will only continue when legalization becomes a reality later this year without this bill. Legalization means nothing if we leave in place the tools that have led to the disproportionate arrests, convictions, and mass incarceration of Black people and continue a two-tiered system of injustice. We urge this committee to issue a favorable report, and thank you.
Why don't we go ahead and take our virtual witnesses also before we roll on to questions? I think we just have the three. So why don't we go in order? Michaela Wilkes, Heather Warnken, and then Kiki Wilson in that order. You guys can go for 2 minutes. Michaela?
Hello, my name is Michaela Wilkes. I'm a resident of Charles County and also someone who has been directly impacted by the racist war on drugs that we have in this country. I think that since the majority of Marylanders did vote in favor to legalize marijuana in the state of Maryland, we need to center decarceration. I know that there are other bills in the Maryland General Assembly that talk about the market, but I can't understand how we can even possibly begin to start having a conversation about the market when Black people are in cages, and we still have not had the conversation around censoring decarceration. Here in Maryland, the majority of people who are incarcerated for marijuana possessions are Black people, and it ranges from anywhere from 9% more likely to be arrested from all the way to about 30% more times likely to be arrested in Garrett County in Maryland. And those numbers are from the ACLU organization's website, if anyone is interested in looking up those statistics. This bill is needed if we are going to move forward with the legalization of marijuana, because we just have to tackle this and stop the racist war on drugs. And that's just all what it boils down to. We have to do the right thing and center those people, center those voices, those people who are going to continue, people that look like me that are going to continue to be disproportionately impacted while we have corporations and businesses out here operating as Apple stores, selling marijuana on the market and getting no penalties for it. But people like me are used as a tool for, as was stated before, public safety, because they know that marijuana is the easy way to get them. The odor of marijuana is the easy way to get them. And it just becomes this perpetuating cycle that is never going to end. And the reason why most of Maryland voters voted to legalize marijuana is because a lot of us are patients, right? And so if you're not going to pull me over, or if you're not going to see me out in public with, a bottle of Percocets that I am prescribed to because I need it, you're not going to arrest me for that. Why do you want to arrest me for possession of marijuana? And I think that substituting civil penalties with substituting jail time for civil penalties is a great way to intervene in that process and start to focus on decarceration and to start to repair the relationships that we have with the judicial system, as well as marginalized communities, especially Black communities in the state of Maryland. And so I would really urge this committee to move forward with a favorable report and center those who have been directly impacted and keep our Black people and our Black babies from becoming a part of this system, becoming even more traumatized by the racist war on drugs. Thank you, Delegate Deborah Davis, for entering this bill. Thanks, y'all.
Heather Warnken, you can go ahead.
Good evening. I'm the Executive Director of the University of Baltimore School of Law Center for Criminal Justice Reform. The center is dedicated to supporting community-driven efforts to improve public safety and address the harm and inequity caused by the criminal legal system. In direct alignment with this mission, we are grateful for this opportunity to testify in support of HB 280. It is well documented throughout the research evidence that people of color have long been subjected to police stops and searches more frequently and have been charged and sentenced to incarceration more often and for longer periods of time than their white counterparts for marijuana-related offenses. Also well documented are the significant consequences of such convictions. Even a misdemeanor can lead to an extensive list of collateral consequences that can follow a justice-involved individual for years, spanning numerous areas central to a person's ability to survive and thrive, impeding access to stable housing, employment, and much more. Following the overwhelming ballot support for legalization of cannabis, altering our state's criminal penalties for this now legal substance is an imperative step for our legislature in addressing the immeasurable racial injustice of the misguided war on drugs, and for ensuring that our limited public safety resources are used appropriately to the benefit rather than the detriment of our communities. Recent changes in law in other jurisdictions demonstrate legalization without additional proactive measures is not enough. In Virginia, despite legalization of recreational use, Black adults accounted for 60% of all marijuana-related charges and only 20% of the state's population. And in Washington, D.C., over 95% of those arrested for marijuana-related charges in 2020 was Black, despite accounting for only 45% of the population. For these reasons and many more, we urge a favorable report on HB 280. Thank you.
All right, Kiki Wilson, go ahead. You have 2 minutes. You need to unmute yourself first, though.
Kiki, we can't hear you.
Hang on, we can't hear you. Hang on.
Now.
All right, let's go now.
We can't hear you. You could have meant.
I'm sorry, we can't hear you, unfortunately.
She did touch a button at one time. Hit a button.
All right, we're going to try and bring her back.
All right.
All right, you have, wait. All right, you have 2 minutes. You're going to have to turn off the audio on your YouTube feed because it's bleeding through your microphone now. Yeah, turn off the live stream that you're watching. It's just got to be the Zoom. All right, I apologize. I think we're having insurmountable technological issues here. All right, well, I'll tell you what, if you can get us your testimony, I promise we'll circulate it to the committee after the hearing. Is that okay? All right, thank you. All right, colleagues, do we have any questions for the sponsor or this set of witnesses? Delegate Conaway, and then Delegate Young. Conaway, and then Delegate.
Anyway, on page 3, line 4, this cannabis is called the controlled dangerous substance. Is that correct?
It won't be.
On page 3, I believe it is, line 4 of the bill. The controlled dangerous substance is cannabis. Is that correct? You want to speak up? Anyway, the second part that I wanted to ask about is on page 2, line 27. There's a statement that says you can have 2 or fewer cannabis plants. And then you go to page 2, line 22 through 28, and it describes what personal use amount means. But I wanted to know, did you know that we had in previous testimony was given to us that 1 plant could yield from 1 to 5 pounds of marijuana or cannabis? Did you know that?
Yes.
Okay, so do you think that's proportionate with the fines and what we're doing here? Or you think in the future we'll strike all of this? I mean, if you have a plant that can grow 1 pound to 5 pounds, theoretically, in the future, we're going to notice that people are going to have 2 plants outside, and they'll have 1 pound or 5 pounds, and they'll say that's more than, 1.5 ounces or whatever, and therefore we need to strike this in the future. I understand this is a beautiful first step, but I just wanted to note that 1 plant might yield 1 pound to 5 pounds.
And that would make it illegal. I think I get your point.
Right.
And that would make it illegal.
Thank you.
So the law is
yeah, so you're going to have to watch what's growing outside in your backyard just in case if you have 2 plants.
Delegate Young.
Thank you, Mr. Vice Chair. So I was reading the Judiciary's testimony, and they oppose for the specific purpose of it impacts their discretion. My reading of the bill doesn't really lead to that, so I just wanted to give you an opportunity to respond to that point of view from the Judiciary.
Well, as a lawyer, I would say that everything we do here impacts on their discretion. Is that not true?
Amen.
Anyone else want to?
No further questions.
All right, that looks like the end of the proponents. We have 1 person signed up in opposition online, Vince McAvoy. Okay, Vince McAvoy has canceled. That means we can end the hearing on House Bill 280. And we're going to go to House Bill 330 from Delegate Williams. You have a panel you want to bring up with you?
Yeah.
All right, whenever you're ready.
Okay. Yes. Okay. Okay, good evening, Vice Chair Moon and members of the House Judiciary Committee. I'm Delegate Nicole Williams here on behalf of House Bill 330, also known as the Post-Conviction Review Motion for Reduction of Sentence. Earlier today, if you may remember, I know it's been a while, the state's attorney for Prince George's County was here, and she did briefly provide testimony about why she is in support of this piece of legislation. And really, this legislation would allow any state's attorney a clear legal mechanism to file a motion to reduce a sentence of an incarcerated individual if a lesser sentence is in the best interest of justice. According to For the People, an organization committed to criminal justice reform, whom you'll hear from later on, this law ensures a system of checks and balances by vesting judges with the ultimate decision in these situations. Victims would be notified of any resentencing proceedings and afforded all rights as stated in the Maryland Code for Criminal Procedure. And we're aware of the proposed amendments from MCASA regarding adding the ability of the victim to submit either a new victim impact statement or for the court to review a previously submitted impact statement. And we welcome those amendments as a friendly amendment, which you'll see in the written testimony that's been submitted by them. Maryland taxpayers currently pay about $54,000 per year for each person who is incarcerated, well above the national average, and reducing our prison population will allow us to redirect these funds. This bill, as stated, will allow the state's attorney of the jurisdiction in which the criminal case and sentencing took place to ask the court to reconsider if they believe this would be in the best interest. And we've seen this play out most notably recently in the conviction of Aned Syed in Baltimore City. However, this bill would, as I stated earlier, put in place certain protections to allow victims to be able to participate in these situations if such a motion like this were to be filed by a state's attorney. And will also offer incarcerated individuals a second chance once they have proven that they pose little to no risk of perpetuating further violence. Multiple factors must be taken into consideration when petitioning the court, such as the inmate's disciplinary record of rehabilitation, and evidence that shows that the age or time served has lessened the likelihood of future violence, and whether or not the individual circumstances have changed since the inmate's original conviction. And so I know I'm running short on time, but I just want to state that this is not a decision that would be made lightly, but one made in the best interest of everyone in mind and approved at the end of the day ultimately by a judge. Incarceration has devastating effects on an individual, their family, and the overall community. And if someone has made an effort to truly change and better themselves during their period of incarceration, then it would be unjust for us not to revisit that. And for those reasons, I ask for a favorable report for House Bill 330.
Mr. Chairman, Vice Chairman, members of the committee, my name's Robert Biddle. I've been a criminal defense attorney in Baltimore for almost 30 years. And before that, I was a federal prosecutor in New York. HB 330 is an essential addition to the toolbox for the judiciary, the state's attorney, and defense counsel to remedy unjust, too lengthy sentences. The state's attorneys can already move to vacate an entire conviction, but there are many cases where defendants are guilty, but their sentences are too long. Maryland Rule 4-345 only allows judges to reduce sentences within 5 years after the sentences have been imposed. There are cases where years later the state's attorney recognizes that the defendant's sentence is excessive. There's no readily available remedy to that situation now. HB 330 provides that remedy. I have clients who were not juveniles at the time that they committed their crimes, and there are few available remedies to shorten their prison sentences even after they have 30, 40, or even 50 years in the Division of Corrections, and they are not public safety risks. When a state's attorney agrees that justice requires a reduction of sentence, the state's attorney should be able to ask for a reduction of sentence as the bill provides. The kinds of cases where this reduction can be appropriate include cases where, as time passes, the defendant's role in the offense is less than it was believed previously, or the defendant's rehabilitation has been extraordinarily compelling. In such cases, due to backlogs and other factors, the Parole Commission may not be available to take action and address the situation. This bill lets the state's attorneys act with a court making the final decision on a reduction of sentence. I ask you to favorably report this bill. Thank you.
Mr. Vice Chair, members of the committee, it's a pleasure to be here. I'm Doyle Neiman. I'm Assistant State's Attorney in Prince George's County, and I'm in charge of a unit in our office that handles sentence review. And I can testify that this bill fills a critical gap in our legal system. Currently, Rule 4345 provides a way for somebody who's been convicted of crime to ask for reconsideration. But those have to be filed within 90 days. They're frequently denied right away. Once denied, they cannot be come back for any reason. And there's also a 5-year cap on the vast majority of convictions since 2004. This bill would allow a state's attorney to file a motion to reconsider a sentence. It doesn't allow the state's attorney to do that, to reconsider the sentence, just to ask a judge to look at it. The judge makes the decision weighing all the facts of the case, the history of the victims, and everything else. This is a narrowly crafted bill that was designed to address the criticisms of earlier efforts. First, it makes the state's attorney the gatekeeper. That's important. It prevents what the Court of Appeals, when it considered a proposal from the Standing Committee on Rules, weighed of a flood of cases that might come forward. So these are only going to come forward with the state's attorney. Some will argue it should be broader, but this is the conservative compromise, if you will. It also addresses the criticism you'll hear again of victims having to come back to court over and over again because the state's attorney controls, and it's the individual state's attorney in the jurisdiction where the crime was committed that will make the decision. They get to decide. If they don't want to do it, they don't want to do it for whatever reason. But if, as in our jurisdiction and some others, there's specific cases that deserve to be looked at again, this gives us the ability to do it. So I urge a favorable consideration.
All right, we've also got a couple people signed up virtually. Mike Hillard and Hillary Blount. Why don't we take them in that order?
My name is Mike Hilliard. I'm a resident of Baltimore County and a retired major from the Baltimore Police Department. I'm also a member and speaker for the Law Enforcement Action Partnership, or LEAP. I am here to support HB 330, which would allow prosecutors to initiate post-conviction reviews. LEAP is a group of police, prosecutors, judges, and other criminal justice professionals who speak from firsthand experience. Our mission is to make communities safer by focusing law enforcement resources on the greatest threats to public safety. HB 330 is a step in the right direction to help Maryland's officers regain the community's trust. This legislation would allow the state's attorney to review past cases, and if it serves the interest of justice, recommend a reduced sentence for an incarcerated person. These individual case reviews would contribute to restoring faith in the criminal justice system. I cannot overstate how important the community's faith in the criminal justice system is to the police's ability to protect and serve. We also know that shortening unnecessarily long sentences reduces overcrowding and frees up criminal justice resources to focus on those who really do pose a public safety risk. We must reserve our limited prison space for those who threaten our safety. Having the opportunity for sentence review would also incentivize positive behavior in prison. I would request the committee favorably report this bill. Thank you.
All right, Hillary Blight, you have 2 minutes.
Good afternoon. My name is Hillary Blout. I am the founder and the executive director of an organization called For the People. We are a national nonprofit, bipartisan organization that supports prosecutors across the country who are looking to reevaluate past sentences to see if there are people in prison that could be safely released. I am a former prosecutor, and in 2018, I worked on passing the first prosecutor-initiated resentencing law in the country, or PIR as we call it in California, which is very similar to House Bill 330, which, as you've heard, gives prosecutors this ability to look back and provide redress if there are people that can be safely released. And what we have seen from across the country where this is operating, these are typically sentences where a person is serving a sentence maybe 10, 20 years ago when the sentence was handed down. It may have been appropriate and reasonable at that time, but now today it may be inconsistent with current sentencing practices and may warrant a review. Or, as was previously mentioned, somebody that has completely transformed their life, taken advantage of every single rehabilitation and programming course in prison, and deserves this extraordinary relief because through the evaluation of this case, it is clear that the person could be safely released and reintegrated into our community. Since the law passed in 2018, it's been enacted in 4 other places: Washington State, Oregon, Illinois, and Louisiana. And it's also been proposed in 7 other states, ranging from Massachusetts to Texas. All of these bills proposed and passed have this critical piece that involves victims, making sure that their rights are protected through the entire process. To date, there have been about 600 that have been resentenced and released and reunited with their families. Thank you for your time.
All right, are there any questions for the sponsor or witnesses? Boucher and then Bartlett.
Bring everyone's attention to line 23 of this bill, notice of hearing to supply the victim with the notification that this is being processed. I am the victim of a brutal attempted murder, and someone is doing a life sentence right now for trying to murder me. If the state's attorney makes this motion and I'm notified, what would be the process for me to participate in that and protest that from happening? What would be my rights? Thank you.
I can speak, from experience in that regard because we handle precisely those cases in our unit. We talk to the victims ahead of time usually. First we find them, which can be hard in an old case. So we do an investigative research, talk to the victims, we get their input, we let them know what and why we're thinking. Then we advise them the notice of the hearing, and they have a right to participate in the hearing, to go and make a statement, to speak, to be present under the current laws for victims, present at any proceeding in which the defendant has a right to be present, and to be represented if they want to be represented by an attorney. The Maryland Crime Victims Resource Center has shown up frequently on behalf of victims. If they can't be there physically, we arrange for a video connection now, thanks to the pandemic and what we learned in it. Or if they have a written statement, we make sure that that written statement is presented to the court and that the court benefits from that. And I can tell you it makes a difference as well when we do that. Even if we have a different position than they are, we are very committed to respecting the rights of the victims and to minimizing any harm and concern that may come along, but also explaining what it is that's going to happen.
And I was just going to add as well, Delegate Boucher, as I mentioned, the proposed amendments from MCOSTA. Also, if the victim doesn't feel comfortable kind of rehashing that and coming forward, they can also, the court can also rely on their previous impact statement that they submitted at the time of the initial case.
Thank you. So this bill would in no way mitigate my existing rights as a victim of this crime?
No, absolutely not.
Thank you for clarifying.
Of LEAP, can you draw the nexus for me between how this bill helps you with respect to witnesses or getting witness testimony? I think I see the connection with the community, and you're saying that, you know, we can prevent crime. Our detectives depend on information from witnesses to come up with leads. So can you help me understand how this bill involves your ability to have witnesses or better witnesses or witnesses to come forward, or in any way impact witnesses?
Is it directed at me, Delegate?
Yes, it is, sir.
So one of the significant problems the police have, particularly in the minority community, is the lack of relationships with the community, and the criminal and the communities really is alienated by the criminal justice system. And part of it goes back to the war on drugs and substantial sentences being issued for insignificant amounts of narcotics being seized. We see this as a way that state's attorneys can assist us as police in connecting again with communities by showing the criminal justice system serves communities and it's not an us against them situation.
I see. Thank you.
All right, I think that's in, oh, wait, we got one more. All right, Delegate Phillips.
I generally kind of concur with this, but you mentioned the Adnan Syed case, right? And in many respects, I get concerned that those cases that have high visibility might get more attention than others. And we're leaving this to the discretion of the state's attorney, which then suggests that there may be a scenario where the squeaky wheel gets the oil. How do we ensure that we have a fair assessment? We're putting this in the hands of an individual. That's the only thing about this that concerns me. Any thoughts?
Well, I mean, the first step is actually to make it available to everybody, and that's what the bill does, is it opens it up. Now, for somebody, Mr. Syed's case is unique in that he came forward under a couple of different things in the law already, related to being a juvenile, but also related to whether his conviction was wrongful or not. That's a separate issue. But for the reconsideration, there needs to be a process. There are, frankly, I can say from our experience in Prince George's, we have ways to bring some cases forward. But it's arbitrary and capricious in some way, dependent on somewhat what happened in the past, whether there was a motion to reconsider filed before 2004 or not, whether, there have been post-conviction actions. This way, it puts it very clear and simply and straightforward. We don't have to, I called it gimmicks, but the state's attorney always says, we don't have to be creative in how to get a case in front of a judge. This puts it in there. The decision is still going to be the judge's decision based on everything.
I can also follow up in that Maryland law provides a right to counsel for post-convictions in Maryland, which for most cases now have to be brought within 10 years of the date of the sentencing. So there's a 5 to 10 year gap in there right now because the courts can't address a modification motion after 5 years. And this law, if passed, would permit that attorney, if they have a meritorious case, to bring it to the attention of the state's attorney and ask for the state's attorney to pursue relief. And I can also say, having done a number of these cases where I supported relief, the state opposed me and I lost, but I've won some as well, and I've certainly won cases where the state supported relief, that it's an important factor in any case to contact the state's attorney's office. So it's the kind of thing that an attorney would do anyways. So with a right to counsel, that means that there'll be a lot of defendants who are in DOC will have someone who could go to the state's attorney and say, you know, this is a meritorious case, please file this motion.
And there will be I think you may get some testimony as well from some of the folks who would like to go a little further, but none of this happens without there being somebody representing the petitioner, the person in prison, because we can ask the court to consider a case, but they have to make the case. And so all we're doing is giving them the opportunity to make an argument as to why there should be a change in the sentence.
All right, thank you very much. I neglected to mention that Doyle Neiman is a former member of the House of Delegates, so welcome back.
Well, thank you. And I have to say, I had the maybe good fortune to never have to serve in judiciary. But I admire your stamina and your perseverance here at 7 hours, 4 hours after your colleagues have gone off to the Frederick Day. You're still here doing your job.
Yeah,
So thank you.
We got a few more bills left, too.
Oh, I'm sorry.
So we do have a few more people signed up. Do we have Michael Pinnard here? I saw Nicole Hanson-Mundell, I think, walk in. And we have a couple favorable with amendments, if we could just bring them up now, and they'll go after Elizabeth Hilliard and Ann Kirsch. And with this panel, I'll just remind folks about decorum, and we don't want to be walking the line on impugning people's motives or characteristics as they seek to testify. Folks are allowed to come here and express an opinion. So just a quick reminder on that. All right, so why don't we start with, we'll go Michael Pinnard, and then Nicole Hanson-Mundell, and then we'll go to our favorable with amendments.
Good evening, Mr. Vice Chair, members of the committee. I am Michael Pinnard. I'm a professor at the University of Maryland, Carey School of Law. I hope this is not breaking decorum, but I am also testifying in favor with amendments really to allow defense-initiated motions as well. So I hope I'm still allowed to. Thank you. So I teach the Youth Education and Justice Clinic at the law school, and we represent, on the one hand, children who've been pushed out of school through suspensions and expulsions. On the other hand, we represent older individuals who are in their 40s, their 50s, their 60s, who remain incarcerated for crimes that they committed when they were 18, 19, 20 years old. They are known as emerging adults. And we have been working with the Prince George's County State's Attorney's Office and Doyle Neiman for the past few years, together searching for pathways for possible relief for individuals who are like my clients. And these pathways are very limited, and for too many individuals, essentially non-existent. And again, I'm focusing, for purposes of this testimony, my clients, the emerging adults. The adolescent brain science that was very much discussed in this committee when contemplating the Juvenile Restoration Act does not stop at 18 years old. Okay, the science demonstrates that the prefrontal cortex, the part of the brain that deals with deliberation and long-term thinking, fully forms when we are around 25 years of age, and that's just an important sort of data point. HB 330, this bill understands that people change as they grow older. Many individuals in prison rehabilitate and transform over time. Who they are at 45, 55, 65 It's not who they were at the time of their crime. That is, they live with the benefit of reflection, perspective, understanding, maturation, and wisdom. One other point, because I know my time is already ended. It is important to always be conscious of the fact that 80% of our incarcerated population who have served at least 10 years in our prisons are Black. So we should be compelled to do everything possible to reduce these disparities, and we need an all-hands-on-deck approach, and this bill with these amendments is an important step in this march toward justice. Thank you.
Good afternoon, Chair, committee members. My name is Nicole Hanson-Mundell, Executive Director of Out for Justice. Out for Justice is a grassroots advocacy org that is led by formerly and currently incarcerated individuals who have made a decision to change their lives. And so this bill is near and dear to Out for Justice members, especially our incarcerated loved ones. Mr. Chair, I am also staying in decorum. After great deliberation by our members, we are favorable with amendments that was submitted by the Office of Public Defender as well. And so I will leave time. Oh, I also support the amendments of my colleagues, specifically D and E. Is that D and E? Is that D and E? Yes. So thank you very much, and I'll allow for some of our other experts to speak.
Good afternoon, Vice Chair, members of the committee, Elizabeth Hilliard. I promise you'll only hear from me 2 more times tonight, so really not that many. I speak from both the general Office of the Public Defender's Office, but also as someone who worked in post-conviction division for 6 years. I actually just got a very, very exciting announcement from one of my clients who was let out through a motion for modification in this nature. He is working full-time job, he has his own apartment, he has a girlfriend, he is in therapy. He is doing better than a lot of the people I know who have never interacted with the criminal justice system. And honestly, it was really, really difficult to get his case back in front of the court. And so we are so appreciative of Delegate Williams bringing this bill. We do, however, ask for a consideration of an amendment that would allow defense attorneys to bring the motion. There are 3 primary reasons we're asking for that. First is equity. If we're allowing state's attorneys to bring the motion, we should be allowing public defenders to bring the motion. We are incredibly grateful for state's attorneys like Aisha Braveboy, Marilyn Mosby, Doyle Neiman, and multitude others who have been receptive to and understanding of the import of reconsidering people's sentences. But we don't have state's attorneys like that in every jurisdiction in the state. Second, state's attorneys don't have clients. They don't have client confidentiality. They aren't beholden to anyone other than the state. We are. Public defenders are, and defense attorneys are, beholden to their client. They have client confidentiality, and they have a duty to effectively advocate for them. I'm running out of time, but we urge a favorable report. We really appreciate this bill. We just hope that you will consider an amendment that will give it some equity and consideration that it needs. Thank you.
Hi, my name is Ann Bocchini-Kirsch, and I am Director of Advocacy for Prepare. We do parole preparation and reentry services. And I'm also a returning citizen, so I have seen this from every possible angle. The idea of a bill that puts sole discretion in the hands of the state's attorney's office is a scary and new thing, but that doesn't necessarily mean that it's a bad thing. It just means it's something that we haven't tried yet. I think it's really important to note that whenever we're trying something new, and this rather goes to Delegate Phillips' point, we need to gather data, we need to have a structure, and we need to have some way to evaluate whether what we're doing is effective or not. There are 10,000, over 10,000 Black men in prison in Maryland right now. There are over 14,955 sentenced incarcerated people according to the 2022 ADP report in total. So the need for decarceration is clear and pressing. The amendments that I proposed would give a structure where somebody could put forth a request to the state's attorney's office that would then have to be tracked and reported on. That means that the state's attorney wouldn't have to seek and find these people, but they would be able to put their names forward, much in the way that they currently do in Baltimore City and PG County. And then that information would have to be produced, and it would have to be given back to you and given back to us so that we could make sure that this program is being equitably administered across the state. We have a lot of historic inequities that have led to this problem that we're trying to solve here today. And I think it's really important that as we move forward in a way that makes sure that we're accomplishing our goal. Thank you for listening.
All right, are there any questions for this panel? All right, thank you very much. We have a few people signed up to testify in opposition. Michael Algio, Stephen Kroll, Scott Schellenberger, and a virtual Vince McAvoy, maybe. All right, and you know the drill, whoever's ready.
Mr. Algio's waited the longest, we'll let him go first. Good evening, Mr. Chairman and members of the Judiciary Committee. I came this afternoon at 12:30 from the Maryland Racing Commission meeting. I thought that was bad. But here we are. My name is Michael Algio. I am a retired circuit court judge from Montgomery County, Maryland. I am presently working with John McCarthy in the State's Attorney's Office from Montgomery County as special counsel to the State's Attorney, and this year co-chair of the Legislative Committee with the Maryland State's Attorneys Association. We are here today, and let me begin by saying, as a retired judge who has handled many of these types of cases, I believe in reconsideration. I believe in post-conviction, and I believe in second chances. I also believe in finality, and I believe in victims' rights as well. The job as a circuit court judge was difficult in many ways, in many different rotations that I had, both civil, juvenile, and criminal, and family. But I will tell you, the most difficult part of the job that I had in my years as a circuit court judge was at sentencing. Always at sentencing, because you held the life of another individual in your hands. I took it seriously. I listened to victims. I listened to the state. I listened to the public defender or defense attorneys. And most importantly, I listened to the defendant. When I sentenced somebody, it was considering issues of deterrence, punishment, as well as rehabilitation. It is one of the most important jobs we have. I have a lot more to say, but my 2 minutes is up. But for the many reasons that I have mentioned and would still mention, for those reasons, we are in opposition of this bill. Thank you.
Thank you, Mr. Chairman. Scott Schellenberger, State's Attorney for Baltimore County. You're the victim of a sexual assault, or your loved one's been murdered. You wait through the criminal investigation. It takes weeks, sometimes months. Finally, the charges are filed. Finally, a year later, after 2 postponements, you're sitting in a courtroom and a jury says guilty. And you walk out in the hallway and you think, finally, it's over. Wrong. Under Maryland law, motion for new trial, motion to modify sentence, motion to modify sentence based upon it being fraud, mistake, or irregularity, 3-judge panel review, appeal to the Court of Appeals, appeal to the Supreme Court, post-conviction. Many times you get more than one hearing, post-conviction, writ of coram nobis, writ of habeas corpus, writ of actual innocence, motion to vacate judgment, which you just passed last year, so we haven't even gotten started on that one yet. Post-conviction DNA testing, and then we go to the parole commission. When does it end? When do I get to look at a victim or a victim's family and say, it's over, it's done? If you pass this, it's even more. And if you put the amendments in, oh boy, it's going to be even more. I thought the draft was very brilliant in putting the power only with the state's attorney, but you've heard what folks want. They want the power to ask too, and then we're all back at it again. One more look back for the victims and witnesses to be dragged back into court. I urge an unfavorable report.
I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. We're asking for an unfavorable report as to House Bill 330. We at the MSA are not asking for this bill. We do not want this bill. The elected state's attorneys have voted. We do not want this bill. The way the statute is written, the victim has no right to appeal. They have no right to appeal. People who said they're victim-centered, they have no right to appeal. As Mr. Schellenberger said, they can never have their case closed. 16 times a defendant could access the court system. 16 times. To answer Delegate Phillips, this puts politics in the process. Keep politics out. You're looking at 3 prosecutors. We're not politicians. We're prosecutors. Keep the politics out. So if you have a famous person, they're going to get recognized. What about that indigent person in jail? Got a hot topic? They're going to be recognized. Not the indigent person in jail. You have discrimination going on between the two. So in fact, this is a political process. Keep the politics out of it. Second, the parole board is the answer. And you can always petition the parole board, and that's the consideration that you have there. Finally, 3 years is not helpful to victims. Every 3 years, they're going to come back and live this again, over and over again, and they're going to be in front of a judge. A judge who's going to hear this case who most likely did not hear the original trial. They have no idea about this case. They didn't live it at all. They're going to pick the case up. And what if that judge is running for election? And in small jurisdictions, that could happen. So you have what? A prosecutor running for election? A judge running for election at the same time? Keep the politics out of this bill. We are not asking for it. It is anti-victim. As Mr. Neiman said, it's arbitrary and capricious. His words, no law should be arbitrary and capricious. Vote this bill unfavorable if you're pro-victim. We're asking for an unfavorable report as to House Bill 330. Thank you.
All right, Delegate Bartlett, then Tomlinson.
Okay, thank you. I appreciate the passion, and I understand it. It's difficult. I understand, Your Honor, what you said. Essentially, on one hand, you feel X, Y, and Z, and then on the other hand, you feel something separately. I think most of us in this committee feel that way. My questions are, I don't know, maybe Mr. Kroll, you can answer this question. So if a person was sentenced with life without the possibility of parole, would they be eligible under this bill to have reconsideration?
The way I'm reading it, yes.
Absolutely.
Mm-hmm. That's what I thought. Okay. Okay. I think that's my only question.
If I could add to that, I had a case that Renee Bowman, who murdered her 2 adopted children and stored them in a freezer. She is serving life without parole, consecutive sentences. Under this legislation, she would have the opportunity to come back and revisit that.
All right, Delegate Tomlinson and then Munoz.
I think you made a point of, well, you definitely made a point of saying that the State's Attorneys Association does not want this. But you also made a point of saying that there was a vote and everything. I mean, was that unanimous? Or no? Or?
It wasn't unanimous.
No, okay. I was just wondering, okay.
It was almost unanimous.
Almost, okay. Thanks. That's all I had.
Thank you, gentlemen, for staying out and working this late with the rest of us. It's our normal job, but we appreciate you guys being here. I have a couple questions because this is bringing me back to the very first thing I ever drafted as an intern at a circuit court, which was a post-conviction. And I'm wondering if you find, I mean, I heard everything that you said already, but do you find that this legislation is duplicative, or is it just going to sort of harm victims and bring, you know, a greater burden on the court? And the reason I'm taking the time to ask this question is I had a father in my office just stop by about a completely different bill, and his son is currently serving a 20-year sentence having to do with drugs, and he's in his 4th year. And the father shared with me that, you know, not to offend anyone, but he shared with me verbatim that his son had found Jesus and he had formed a close connection with a group in the prison, and he was trying to keep himself safe, and he'd experienced things that, you know, no one should ever have to experience or witness. And so I'm just wondering if you think that the post-conviction route would help people in that situation, because I know it is a 10-year sort of window. Or do you think this is something separate altogether?
So the main part is the part you mentioned earlier, and that was finality. You know, the finality needed for the victim. With regard to that example that you gave, 20 years on drugs, if it's not a crime of violence, which it sounds like it's not, that means they're only going to have to, you know, probably serve around 6 or 7 before they get their first parole hearing. If they're doing the things that they're supposed to be doing right, that's the system we've had. We've had the parole system for years. We're constantly tweaking it, but that's what we all decided was, okay, now the prosecutor's done, the judge is done, now we're leaving it to the people who are in the parole system. And so, and that also wouldn't prevent some of these other extraordinary writs that I've already mentioned here today. So it's my point is, you know, one of these, the motion to vacate judgment, we just passed last year, and now we're trying to add another one. And so I just feel like there needs to be some finality, and there's plenty of places for that particular individual to have an outlet.
Thank you.
Delegate Phillips.
Okay. I have a few questions, if you don't mind. So and I don't recall the young lady's name, but she commented on if this were to take place, kind of reviewing it to see how state's attorneys were applying it so that we'd had some level of equity. Did you want to comment on that?
Sure. I think that, you know, probably what you would do is have maybe a well-balanced committee in your office to review these cases, to make determinations as to whether we would be making those kind of recommendations. I know this is past history, but when I first came into office and Maryland still had the death penalty, I created a well-balanced, equitable group who got together and reviewed all the cases. And we did so without anyone mentioning the race of the individual. It was a very formal process. You know, I think something like that could be done in a state's attorney's office to make sure that it's being done fairly and equitably. I would imagine that the way this might work in real life is I might get a letter from the public defender's office or a private attorney who says, you know, please, you know, take a look at this case for us under this statute. And then it would be up to the state's attorney to make a determination on that. I can honestly tell you, sitting on my desk, because the phone call came in yesterday, was the mother of a man who's serving life plus 20 in prison, calling my office, asking to speak to me because his parole hearing's coming up. And, you know, we do these things all the time. So, you know, I just don't think this is necessary.
But that would help with kind of depoliticizing the process if everybody had a process?
If we had a process, and I think, most of the offices would do that, and then we all share those processes with each other. I can speak of Montgomery County. When they have officer-involved shootings, they have an arrangement with Howard County where they exchange. So, we do adopt processes.
There was testimony regarding the reduction of incarceration, particularly of African American and people of black and brown persons. This to me seems like it would be a tool that a state's attorney could use themselves to help address an ill in our state. We incarcerate at a higher rate than any other state in the nation as it relates to black and brown people. Would you not consider this a tool that could be used to help with that in your capacity as a state's attorney?
I try to balance the tools that you all want to give us with the rights of victims and witnesses. And I just remember when we were talking about the motion to modify several years ago, I was able to demonstrate and was able to not get it was both a bill and a rule. And I was able to let people know that the Caprio family, Amy Caprio was killed in Perry Hall. She was a police officer, and there were 4 co-defendants. And if they had passed that bill the way it was written several years ago, that family would have been subjected to 34 hearings over a period of 10 years. And what I'm saying, and this is nothing like that, I'm just using that as an example. What I'm saying is there are so many tools available now. And what you all are saying is we want Scott to have one more, and I'm saying enough. There needs to be, when we balance those things out, there needs to be finality. I need to be able to look at the Caprio family and say, you're never going to have to come to court again. And right now I can't do that. And now we're going to have one more.
But if they don't come to court, they may end up in a parole hearing.
That's true.
Right.
That's already there.
Right. So that I guess I'm trying to say that they're always going to. We're talking about finality. I don't know that there's ever, unfortunately, true finality.
No, but we can get close. And all we're doing now is adding another one. That's my point.
Delegate Simpson.
Thank you very much. There's does seem to be a bit of a difference between the panels that are for and against. It's very clear here that this is prosecutor initiated. All 3 of you have said, we don't want it. So it's a tool in the toolbox you're never going to use, correct? That's what you said. You don't want it. It's a tool we'd like to give, not necessarily you, but other individuals, prosecutors, who find, you say you don't want this to be political, but let's face it, there are decades of time in which we have made very political decisions that has put people in prison, separated families, and this is coming from someone who's a domestic violence and a rape survivor, so I totally understand the survivor aspect. But there are people that we've put in jail for long periods of time that if they did it later, they wouldn't be there. So this is just a tool for individuals, prosecutors who come forth and say, maybe we were wrong, or how about the individuals who've made a change in their life? I'm sure you all have met individuals that you, as you said, you're making a life decision. And at the time when you made that life decision, you may not have thought somebody was going to make a change, right? But I'm sure
I always hope they made a change. That's the purpose of rehabilitation.
And has anybody on this panel not experienced someone who's gone to prison and made a huge change in their life that was a completely different person from the day you saw when you sentenced them?
Absolutely. And given the tools that have been made available already, I have had situations where I have revisited a sentence. There was a reference earlier to reconsiderations, and reconsiderations are denied out of hand. I didn't do that. In motions for reconsideration, typically, attorneys would file them within the 90 days so that time could be preserved, so that they had in fact filed the motion for reconsideration. And I would frequently hold that in abeyance until such time as the defendant had an opportunity to see how they were going to do. And frequently would come back and we would reconsider that. Our point is that I'm not in any way against having another tool in the box. I just think tools need to be effective. And I think the tools that we have available to us right now, and Mr. Schellenberger went through the litany, the myriad of tools that are available to us, that's what we rely on.
And you're a judge, and this is
Retired.
right, but you were a judge,
Yeah.
so it's a little different, because this is putting the tool in the hands of a prosecutor who wants that tool. They're asking for it. Some people feel it's reasonable, to have those individuals. It doesn't automatically mean someone's getting out, nor does it mean, nothing in here says that a prosecutor has to use this tool.
Right.
It's just individuals that realize that perhaps there was some mass incarceration or individuals who shouldn't have been. It allows them to make a change.
I can only point to an article in the Washington Post I read over the weekend of a similar legislation in the District of Columbia. And the judge was was having a reconsideration very similar to this, an individual who had made great strides, notwithstanding the fact that they brutally raped the victim and held her overnight after a carjacking and raped her over and over and over again. And the judge had to turn away listening to her testimony on a legislation that is remarkably similar to this. And the victim said, "When do I get a reconsideration? When is it my turn?"
Nothing in this bill that says that those types of situations are the ones they're letting out.
All right, isn't that so? We're getting new questions popping up now.
I thank you for your question.
All right, we're going to go Delegate Conaway and then Delegate Young, and hopefully that'll close out this round on this bill. Thank you.
Thank you, Mr. Chairman. Thank you, witnesses, for coming in to testify. With the proposed legalization of the marijuana, how does that affect this, or how does this bill affect people who are already incarcerated for marijuana-related charges?
Well, it's my understanding that the bill that you all passed and are currently crafting would let individuals who are serving sentences for distribution of marijuana, I believe, lets them out of jail. And it also provides for an automatic expungement for possession cases. I do hear this all the time, that there are people in jail for possession of marijuana, and when we were talking about this last year, I asked the Division of Correction if there was anybody in the Division of Correction for possession of marijuana, and the answer was no. But you were correct. Distribution of marijuana could potentially come under this, but I think that you all put a provision in the marijuana bills to take care of that.
Okay.
That's my recollection.
Thank you very much.
All right, Delegate Young and then Munoz.
Thank you, Mr. Vice Chair. I think I recall a few years ago, Baltimore City, our state's attorney sought to overturn something like 800 convictions because they were all tainted from the gun trace task force. I thought they brought some legislation as it pertains to that. Can't recall what happened to that legislation.
So I believe that was the writ of actual innocence.
Uh-huh.
And my recollection, it was somewhere around 600 plus, but it was totally due to the gun trace task force. And I know they were working through those cases based on that writ.
I'm just wondering if this could support that kind of an effort if this bill existed or if this passed.
Well, the thing about this bill is it doesn't nullify the conviction. So then you might have somebody who was convicted under gun trace task force. You use this bill to get them out of jail, but you need to use one of these other statutes that you've passed, like the writ of actual innocence, to get the conviction taken away. So it really doesn't really fix that problem.
Okay, I'm just getting some clarity. I appreciate it. Thank you.
Thank you, Mr. Vice Chair. Gentlemen, I think everyone can tell that our committee is struggling a little bit with this particular issue. And it feels a lot like it's coming down to an issue of mercy. But I think given, your expanded responses, I would just like to ask, do you think that you are taking, I think so many of us think, well, people should get another chance, right? They might change, we should offer them mercy. And what I'm hearing is you're saying they have so many opportunities for that. And by opposing this particular legislation, what you three are here doing is protecting victims. Would you agree with that? Could you expand upon that if that's the case?
So that is my intent, is that I'm trying to take one more court hearing away from a victim to have to show up to. I'm trying to add a closer level of finality, and if that person deserves mercy, we have a system to take care of that, and that's the parole system. And so, and you all have changed the parole system. It used to be that governors could veto the parole commission who was saying that somebody should get paroled. If they were serving a life sentence, the governor had the right to say no. You took that away last year. So, you've already made changes that give these people options that where they can get that mercy. And I say, let's leave those systems in place. Let's not add to the victims.
Okay, so at the end of the day, you feel this legislation, if we have to choose between protecting victims and protecting the perpetrators.
I think there's enough protection of the perpetrators. I think we need to protect the victims on this one.
Thank you so much.
All right, that looks like the end of the questions for this panel. Do we have a virtual Vince McAvoy testifying? No, okay, no virtual Vince McAvoy. So that's going to end the hearing on House Bill.
Thank you all.
Wait, I'm sorry. Hold up, folks. We've got one from Delegate Taylor. Welcome back.
Thank you, and you'll be happy to know this is a really quick question. Do you know the statistics for the Black men that are incarcerated currently in Maryland? How many are victimless?
I'm sorry, I don't know that. I think that's something we could get from the Department of Public Safety.
I'd love to see those statistics. Thank you. I would.
All right, now we will end the hearing on House Bill 330. We still got a couple more left, so don't go anywhere, folks. We're going to go now to House Bill 221 from Delegate Grammer. And you do have one person signed up with you, is that correct?
I believe so, and I'll show you how to have a quick bill hearing, Mr. Chair. So should I wait for them to?
Is Deborah Levy here?
Yes.
Oh, there you are, online. Okay, Delegate, can we, folks, can we pay attention for a second? Delegate Grammer, whenever you are ready.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 221. House Bill 221 prohibits the use of law enforcement quotas. When former Baltimore City police officer Michael Wood was asked what his suggestions were for improving police culture, he recommended that we think about what our goals are. He told a story about how the metric that he was given by leadership was arrests. He told about how he would drive through his assigned detail looking to satisfy his arrest quota. He couldn't fill his quota in the rich part of his assigned precinct that was predominantly white, so he drove to a black community to arrest people for jaywalking or littering. Proper policing is community-driven. Officers form partnerships with community members, build trust, and follow the evidence. In many places in our state, we implement the opposite. Politically driven policing implemented through quotas. Behind closed doors, officers are squeezed to produce a product that elected officials can sell to the public. Under a regime of quotas, some officers feel empowered to bend or break the law as long as their superiors continue to reward them for numbers that look good in the paper. The series We Own This City demonstrates the realities of what can happen when elected leaders are allowed to press their officers to hunt. This bill was requested by a member of Maryland's law enforcement community in response to this issue. A separate member of Maryland State Police community reached out to my office to share his concerns about this issue. This person shares concerns about troopers' mental health and said that most troopers disagree with this policy but have no voice to help to combat this practice. This person specified that state troopers are threatened with disciplinary action if they do not meet these required goals. I have attached their anonymous letter with an actual quota, which is illegal under Public Safety Section 3504. I've submitted to the committee communications by state police leadership. As I mentioned, this is illegal via the current law. In addition, I have shared an email from law enforcement leadership comparing quota enforcement actions to help determine who is getting a new car. That's an actual quote. Please note that the number one producing officer listed in this email is delivering 4 times the numbers delivered by the lowest. Leadership is punishing officers who don't generate numbers and rewarding those that do with trinkets. House Bill 221, the Community-Oriented Policing Act, discontinues the use of law enforcement quotas in the state of Maryland in hopes that all aspects of Maryland law enforcement are derived from community concerns, not political aspirations. Paraphrasing the words of former Officer Michael Wood, we cannot set this terrible stage and gasp in horror, screaming, "Look at this terrible stage." Thanks to those who have submitted written or oral support in favor of this legislation. Be happy to take questions, and I ask for a favorable.
All right, Deborah Levy, when you are ready.
Thank you. In his law review article titled Police Quotas, Professor Sean Osei-Wusu from the University of Pennsylvania's Carey Law School argues that quota-based policing is one unique area where there's widespread agreement and possibilities for change. It's a unique intersection where liberals, libertarians, conservatives, police officers, police unions, and racial minorities have shared the same viewpoint criticizing quotas. As Professor Osei-Wusu explains, these vastly different constituents have argued that quotas distort police discretion and produce unnecessary police-civilian interactions. Because of this common viewpoint, police unions, criminal defendants, civil rights plaintiffs, and aggrieved police officers have all supported statutes aimed at preventing quotas. Maryland is no exception, already outlawing most quotas, but this bill takes this action one step further, prohibiting directives which aim to change the culture and the mindset. It aims to change the culture and the mindset that influences formal and informal quotas. In 2023, as we all hopefully know by now, police quotas introduce perverse incentives into an already stressed aspect of our community. They distort any valid public safety concerns that community groups say are served by policing. And as Professor Osei-Wusu documents, they pose significant issues for 3 separate groups: marginalized communities, who are almost always the target of an officer's need to fulfill their quota, police officers who are forced to comply and not allowed to use their own discretion during their shifts, and the public, which is deprived of a more efficient use of resources based on quotas. Quotas can be formal and informal, with specific policies like the letter that references increased patrol in the area of North Avenue and Mount Street, which encouraged the action that led to the death of Freddie Gray, or citation quotas that led to the death of Michael Brown in Ferguson, Mississippi. Quotas affect the mindset of the police and the ways in which communities and criminal defendants perceive them, and there's simply no place for them in Maryland's law. We urge a favorable report.
All right, do we have any questions for the sponsor witness? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate and witness, for coming in to testify. Delegate, was this information shared with the Legislative Black Caucus and the Baltimore City delegation?
Yes, it was shared with the Black Caucus. I do not believe they took a position, but we did have a hearing.
Okay, and the statement of the law enforcement was driven to hunt, did that directly come out of We Own the City, or is that?
Yeah, have you seen the series by any chance? So there's a scene in they're in a bar, it's a local bar, and Sergeant Wayne Jenkins, he kind of goes on a speech and he talks about quotas. It's where he essentially says, as long as we keep driving in these numbers, we can do whatever we want. Okay, and that he says straight up, like, we're going hunting.
The character that was portraying the officer said this. Is that correct?
Yeah.
So therefore, that might not be a direct quote of what the officer said.
Not the real life officer.
Right. Okay. Thank you very much.
But Delegate, I will add that the Pew Research Center documented in January of 2017 in something called Inside America's Police Departments. And they do have language of other officers using, other similar quotes of other officers, most unfortunately, using that very same vulgar language of going hunting to meet their quotas. And that admittedly was in New Jersey, but it was the same mindset that these quotas force police officers into because they have to go fulfill their quota and get their tickets and get their citations.
Yes, I'm aware of that. I was attempting to help diffuse this situation and the potential situation that could arise from the use of this word hunt.
I see. It is a tragic use, I agree.
Delegate Tomlinson?
Thank you. I did watch the show, by the way.
It's a good show.
Oh yeah, so anyways, the question. Yeah, so have any states or what states, if there are any, have already done what you're trying to do, prohibit
That's a
quotas?
great question. I'll list them briefly. Arkansas, California, Connecticut, Florida, Illinois, Louisiana. Louisiana has really a great standard. Michigan, Minnesota, Missouri, Nebraska, New York, North Carolina, Pennsylvania, Rhode Island, South Carolina, Tennessee, Texas, Utah, and Wisconsin.
All right, thanks.
Delegate Embry.
Thank you. I share your concern with the use of quotas, but what confuses me is as I read the current law, that would prohibit what you've described, and also I think you shared this document, which would seem to be already prohibited under the current law, and I'm concerned, especially in the amendment to job performance, and MSP's letter I thought was really helpful, that it means that you can't consider whether it's anything about whether or not arrests are made or citations are made, whether it's good or bad, too little, too few. It's even though it's a core part of what an officer does, now it wouldn't be able to be considered at all.
So I would say to that, if other states have banned practice, how do they judge their law enforcement officers? So the first point I wanted to make is that this is illegal. We are told that this never happens.
Right.
3504 says that you can't do this. This is the Maryland State Police, Princess Anne Barrack. This is quotas, it's on paper. You will never get this from a local jurisdiction for a reason, because it's not legal. So yeah, I would say, yeah. So the history of this bill is Delegate Michael Smeagol tried to pass this many years ago. It was amended and chopped up to the point where it's frankly, the current law means nothing. Currently, you're prohibited from using quotas as the sole or primary criterion. Well, what the hell does that mean?
Not quotas, sorry, I'm sorry, I don't mean to interrupt, but just the number, sorry.
Yeah. Well, same thing. What does that mean? You can't use it as a sole or primary. Well, if you look at the last page, which is admittedly submitted anonymously, and when this was sent to me, this had names on it of officers. And I'll read it so everybody knows what we're talking about. Supervisors, I just pulled the last 6 months of stats to help determine who was getting a new car. I added the information below for your reference to help you identify any troopers who were falling behind. The average point total was 1,089. If you have a trooper that is significantly below that, it is an indication that there may need to be additional coaching or corrective action. I will note that the lowest number is the highest number is 4 times or 5 times the lowest. That's a great disparity in enforcement between officers in the same barracks. But I only see one method of grading in this system. Do you see a secondary or alternative number for providing a police officer a new car? And I'm sure there are 1,000 other things that aren't listed on this sheet, that don't fall in the nice column of a quota. But I think the premise stands. I think using quotas as a way to direct officer activity is toxic. And from every single officer I've ever talked to, whether it's in Baltimore County, who does not use quotas, or in Baltimore City, who does use quotas, they will be very frank, and they're terrified to even talk about it. Because if it comes out that they're spilling the beans about the quotas, they're going to get fired. So, I think we submitted this bill last year, and then we got a nice HBO miniseries articulating the toxicity of quotas. I think it's time.
Thank you for your answer.
Thank you.
Delegate Taylor.
Thank you, Chair. Delegate Grammer, please remind us why you sought the support of the Legislative Black Caucus.
I think quotas do disproportionately impact Black communities, poor communities, other minority communities. And this isn't just my opinion. You know, when I talked about police officer Michael Wood, he's a former Baltimore City police officer. And he said it straight up. He said, and the police officers who live in my district tell me the same thing. They are told to make arrests and they are told to give citations. You have to go where the river's deep. So what they do is they go to Black communities. And Baltimore City is majority minority. You know, it was, and I'll tell a story, and I know everybody wants a story at 8 p.m. You know, when we started the discussion about police accountability several years ago, I stepped outside to smoke to relieve myself from these multiple hour-long sessions, and out walks a police officer. His name was Luke Montgomery. He sits right out here at this little booth coming in. And we get to talking. He's a Black cop. He works in the sheriff's office for Baltimore City. And I say, well, isn't this interesting, Mr. Chair? So I strike up a conversation about quotas. And he says, well, they don't really give us a piece of paper, you know, but they will say, you know, we're getting pressed about the speeding out on blah, blah, blah road. And they go out and they start handing out tickets. And I said, well, what do the people look like that you're handing out these tickets to? And they said, well, they're predominantly Black. Well, yeah. When you go into a particular, most districts in Baltimore City, the people who you are shoveling citations at, because somewhere up in the ether somebody has requested you do that, they're going to be Black. It's such an outstanding issue. It's so easy to see.
Delegate Valentine and then Young.
Thank you, Mr. Vice Chair, and thank you, Delegate Grammer, for bringing this to this committee. I have a question, but first I just want to give a little background and perspective of where I'm coming from this with my professional career and kind of give an overview of some of this as a whole. So I've lived on both sides of this fence, both as an officer as well as a supervisor and administrator. So I just want to, and I want to ask a question when I get through these couple of points. Having been put on a board with a insufficient number of traffic stops in a month, I've lived that. I've had performance evaluations that where I may not have met what was a expectation, which is kind of funny in this document. For this particular category, the year that I received that, I would have exceeded their expectations, so that's kind of ironic. So that being said, my question is, from a supervisory and a performance perspective, the only performance plan I ever authored for an officer was based on lack of productivity. And let me explain what I mean by that. We're talking about an individual that did nothing for like a 45-day window. I mean, we're not talking about any traffic stops, any arrests, didn't handle reports. Basically, there was an underlying issue, and with that particular individual, it ultimately led to his termination for unrelated matters. But the flashpoint came from his lack of any overall productivity. So I'm fearful that the fact that we take out any type of performance as any type of criteria for performance evaluations, that leaves me concerned in that aspect. And when you mentioned how else do we do performance, I was always very big in my performance evaluations where, you know, reports, your follow-ups are done on time, you go to court on time, you engage with your community. So statistics are but a small portion. So as written, this would eliminate that at all as part of the equation is what my question is.
Well, I think, you know, the first thing to be said is what's the grading system for a delegate? You know, we write the rules for the state. Where's the, you know, who's the judge and how do they make decisions? It's a little bit different, but it's a similar kind of principle. And I think there are maybe numbers you could judge a person on. But what we're saying here is it's just arrests and citations. Those, because there's someone on the receiving end of that. In Baltimore County, where I represent southeastern Baltimore County, we have a lot of liaisons, and they come out and they work with the community. And if you ever go to one of the meetings, they're always very similar. It is a liaison who's typically, they will come and they will first talk about, okay, well, here's the numbers for this month. We saw an uptick in this, we saw a downtick in this, we want to get information about this, and then we'll let the community talk about what they are seeing. And that creates this excellent exchange. And if the officers that patrol, they know the people, they know the perpetrators, they know where they live, they know their families, they know the whole community, they know their whole precinct. Excellent exchange, there's the trust there. You could grade them on community interactions, you can grade them on the number of leads that you've generated. There's a certain toxicity when you're allowing your governing bodies to aim at arrests or citations. You know, I'm not saying I'm a professional at creating a system of policing, and I think we have a lot we could talk about there. But for these two metrics, I think the proof is in the pudding, whether it's in Maryland or Baltimore City or the state police or any other state, is we've all seen the same results of this, and the results are toxic. So I hope I've answered your question.
Yeah, my only question.
If I could add to the answer, if that's possible?
Yeah.
The law review article, that NYU law review article that I addressed, talks about lots of different suggestions in response directly to the delegate's question, substantive coaching, going through somebody's shift at the end of the night, looking at what types of calls they made, what was the reporting that they did to follow up on those calls, and analyzing how thorough their activities were during their shift, having nothing at all related to the numbers or numbers-driven enforcement, or it's just completely not relevant to substantive coaching at the end of one shift. I'm happy to provide the article too, because I think it's one of the first scholarly explorations of this topic and what are alternatives and answers to the argument. I think it's a helpful read if anyone would like it.
Please.
All right, Delegate Young and then Conaway.
So the thing that I think I found most disturbing about this document and enlightening is I pulled the last 6 months of stats to help determine who's getting a new car. So we have an incentivized circumstance. You know, I mean, in Baltimore City, we have been trying to update our police department under the consent decree in many ways. Y'all know our whole government needs upgrading in some regards.
Yeah.
Right? But this would be crazy. I would imagine that every officer that's out there, regardless of, I mean, as long as you're doing your job to a certain extent, I mean, you should deserve the tools you need to be successful.
Yeah.
As any government official would require. I would first ask, would you be interested in an amendment that prohibits that sort of an incentive?
Yeah, I'm fine with exploring that, you know, but you could, so I want to start off, like, this is an anonymous letter, but it was a real letter that was sent to my office. And I would first look at the kind of letter they wrote first, because it kind of corroborates what police officers are saying in Baltimore City, and they're talking about mental health, they're talking about unhealthy conditions, talking about things not working. As to the specifics of rewarding officers for performance, yeah, you know, I hesitate. I always bring small bills, and I hesitate to start to try and fix the whole world on one bill. But I'm happy to talk about that if you want to talk about that.
Thank you. And the second thing I want to just is that so type of question real quick, and I'm gonna forecast that for y'all. You know, a few years ago we had passed legislation with ACLU, and I was there. We had a great partnership with state police to get this bill passed with race-based traffic stops. And at first, it was like a report every year. The report had some stuff, it didn't have some other stuff. We came to a great compromise that really saved them with bandwidth work and created better transparency, where we created this dashboard that's on, it's not GOCAP, what's it called now? Governor's Office of Youth Victim Services, you know, the old GOCAP, as everybody calls it now. It's on that website. And so I'm looking at it. I realize I think what we have is a deficiency in the law. I would imagine all state police don't do this. I would hope. I would hope every agency doesn't do this, but frankly, our data only breaks down by agency. I would imagine it would be valuable, especially as you sought support from the Black Caucus, for us to potentially break that information a little bit further down.
Sure.
So do you think that would be helpful, isn't it?
Sure, yeah, I think so, and I'll make a couple more brief notes. You're never going to see this again, Delegate Young. This is never going to happen again. You're never going to see another forum like this. And the second point I wanted to make is I actually did talk a lot with the local FOPs, state FOP, and I think the lack of testimony from their organizations is more of a function of me getting to them late as opposed to them not wanting to take a position here.
Thank you.
All right, Delegate Conaway.
Thank you, Mr. Chair. Thank you, Delegate. So you keep adding meat onto the bone here.
It's what I do.
So what, I see that. I like that. So what do you think the FOP would have said about this?
From every single police officer that I've talked to has supported an abolition of quotas.
Did you check to see if this was an official officer?
Well, it's anonymous, Delegate. How do you check
I
anonymous?
mean, no, I said the officer. It says from on page 2, from Timothy so-and-so. Did you check to see if that's a real person?
Well, I didn't want to start persecuting local officers.
Yes or
Frank,
no?
no, I did not.
No,
I
just
did
to
not.
say if it's
No.
a real person. not
Oh,
to
it's
say-
definitely a real person.
Okay. And are you saying from when you were talking about that the river runs deep where you go get the black people and all of this, are you saying that the rules of the shallow water fishing include tactics such as not fishing out of season and catch and release? Is that what you're saying?
I don't know if I'd agree. I'm not sure what you mean there, Delegate.
Well, you said that it was known to go to the black community where the river is deep.
So
what's in the river? Water?
So Officer Wood.
So in other words, you don't go to the shallow water to get deep.
I really wanted to show you the video, but I'll paraphrase
I
him.
don't wanna see the video.
And what he said, what he said is, I can't satisfy a quota in a certain part of my precinct. And he made the analogy, he said, I'll go to another part of my precinct and I'll arrest black people for having pocket knives. And he said the statistics show that white people and black people don't carry pocket knives at a different rate. But that's what we would do.
Thank you for clarifying that.
Thank you.
All right, Delegate Tolles with the last question.
Thank you, Mr. Chair, and thank you so much for presenting to the Black Caucus. I think that we definitely appreciated, the intent of the bill. One of the, I know questions came up was, what is the difference in terms of, if you don't have the quotas, how will there eliminate discrimination and employment opportunities and advancements? Because I guess the quotas were, in some cases, put in place to allow for proof and show, cause of work and to be able to promote that. So that was sort of my first sort of clarification. And then the other thing I was going to ask you is if you can compare, you indicated that Baltimore City does have quotas and Baltimore County does not. Could you talk about those differences and what that means for, showing that, that Baltimore County is successful and still promoting folks of color and not showing biases without having to, without showing that bias within the workplace and having to go to black communities and meet these quotas. Just tell us how that is working versus Baltimore City.
Yeah, so we've got, and I tried to, I was interested in another bill this session on the topic of police hiring and equity. So it starts here. Baltimore County, there was a lawsuit, and the lawsuit, Baltimore County Police were sued because it was found that the test, there were two tests, written, physical, and it was found that the written test was preclusive to minorities, and it precluded them from participating in Baltimore County Police. So I believe the agreement was that they would have to change the written part of the test so more people, not only there would be damages, but more people would get access to the process. So there are problems because I believe in certain jurisdictions we require an AA degree I believe that's the case. So I have to ask myself, how in one jurisdiction do we require a 2-year degree, and in Baltimore County, the written test is preclusive? So if it sounds like I don't have an immediate answer to your question, it's because I don't have an immediate answer to your question. So, but look, it's the question of everywhere in the country right now. Like, how do we hire police? How do we engage more people from more communities? How do we make the law enforcement officers from that community look like people from that community? And I don't, talk to anybody in law enforcement, and we don't have a complete answer for that right now. The second part of your question was regarding Baltimore City and Baltimore County. I think every police chief, after We Own the City came out, every police chief in the state of Maryland should have said, we don't have quotas in my jurisdiction. And in Baltimore County, we do not have police quotas. We do, people will say it publicly, privately, leadership, frontline cops. We don't have quotas in Baltimore County. And we have a lot of trust, like I talked about. Community association meetings with law enforcement officers coming out. It's a partnership. Don't get me wrong. Even people in Essex and Dundalk, we're going to give law enforcement officers an earful because we see a lot of crime that people perceive as not being addressed. But there's that trust there, and I think that trust, and that's why I named the bill the Community-Oriented Policing Act, because that's what reform is striving for. Law enforcement that's driven by the community. So you will never hear anybody from Baltimore City tell you that they're ever using quotas. They are using quotas. And I think the results are clear. We have a jurisdiction, I don't mean to be attacking of any jurisdiction, but you have a jurisdiction who has completely unstable criminal justice system and completely unstable public safety. And I think that's the result. When I said at the beginning of the session, I think you can have both improvements on public safety and improvements on criminal justice reform. This is how you do it. You say, we're not going to allow politics in policing. We're going to create an environment, we're going to create rules and statute that governs how police can act, and we're going to put in prohibitions in place so that politicians can't squeeze law. And that's what's happening. Politicians are squeezing these law enforcement officers for numbers, and then they deliver the numbers, and then they get labeled as a racist. So I think that's the big difference in Baltimore City and Baltimore County, and we just need to bring it to an end.
Mr. Chair, I know it's the hours late, but I just wanted to, if it's okay, just a quick follow-up. So as a former council member, it's important to bring this point in, that the police chiefs are generally, let's just say in Prince George's, are hand-selected, picked by the county executive, confirmed by the county council. The county council goes out to the community and want to know what the heck is going on. The council members spend more time, many of your council members probably spend more time in the community than we have time to do. I stepped away to get on the police call with the community. And the first thing they want to know is, what statistics, what's happening, what are we doing to address this issue? So it's kind of, not virtually, but it's sort of impossible to take politics out of it, just how a police chief gets the job. So with that being said, I definitely always believed in community policing. And I am one of the favorite gals of the police department. Keep that a secret, y'all. But so I will be interested in working with you to see how, we can come to an agreement and understanding that, Baltimore City and Baltimore County are different jurisdictions. Maybe just like Prince George's County and Montgomery County are different jurisdictions. And politics is not going to come out of it, just as by the way of how they get there. So I'll be interested in working with you to see how we can meet in the middle, particularly with some of the issues that was going on with the caucus and some of the issues I've seen in my time as a local council member in the policing issue and how to make that work. So
absolutely.
All right, thank you, Mr. Chair.
All right, looks like we're still generating new questions. Delegate Simmons.
I'm a little bit worried now.
I just wanted to ask you, is the practices that you're speaking about here, is that a trade craft in a sense of training and execution of police officers far as their training?
I would say no. I mean, nobody's ever told me, no law enforcement officers I've ever talked to have said, I've been taught how to juice up the numbers. They've always told me that they're getting pressure from above. And we all see it, we all feel it. You're going to feel it. People are going to come to you and they say, I see crime. And the officers tell me, look, they're coming down on me. And, they're telling us to go get the numbers.
So between the police academy and the field training officer, you don't think there's something that transpired between that level of training that teaches them how to do that, what you're speaking about here?
Well, you're a law enforcement officer, you tell me. How to get numbers? No. No, I've never.
How to pursue, so, when you're talking about predatory policing in minority communities or underclass communities, obviously there's a level of training there, right? So the average person not just gonna go out and, target a group of people just because they're staying on a corner. It's gonna be a trade of how to approach, how to look and identify. So I'm asking you, do you believe that is something that is institutionalized when it comes to departments?
You're talking about maybe behaviors, here's how we get them, like that kind of thing?
Yeah.
Probably.
Okay. In addition to that, do you feel that the high number of these incidents is a result of the fact that majority of officers are not from the communities in which they serve?
No, I feel it's straight up because of pressure from above.
So if an officer lives in Pennsylvania, works in Baltimore City, or works here in Anne Arundel County, and there is a racial disparity between where they're from compared to where they're policing, you don't think that factors into their conduct when they're in uniform?
I know officers who work in Baltimore County, Baltimore City, surrounding jurisdictions. Some live in my community, some live in others, some live in Pennsylvania. And for me, it always seems to be the character and the integrity of the person in question. So I know people all over the place who are good cops, who are great cops, and I have minority communities in my district, and I would trust those people to execute law enforcement with integrity.
Okay. So as a black man, do you feel that it would be something that pursued as I look guilty?
I'm sorry?
Therefore, as a black man standing on a corner, a police officer being a white or other, see me, do you think that they perceive me as looking guilty if I'm in a high crime area, for example? Do I look guilty?
I would say not the cops I know, but I could say that from the statistics we see where quotas are implemented, minorities, black Americans, Latino Americans definitely tend to be disproportionately the target.
Thank you, sir.
Thank you.
All right. At the end of the questions, it looks like it. And I think that's it for this bill. So we've got one left, also Delegate Grammer.
Thank you. Mr. Chair, Mr. Vice Chair, members of the committee, for the record, Delegate Robin Gramber to present House Bill 228. House Bill 228 adopts a framework for the legal use of persistent aerial surveillance, including the constitutional check of the warrant requirement. When persistent surveillance systems started surveilling the city of Baltimore, it did so in discreet agreement without any public awareness. The wide area live feed surveillance system was developed for wartime use. After being shut down in Los Angeles and Dayton over privacy concerns, the program was brought to Baltimore and authorized by Baltimore City Police. The Fourth Amendment is not a guarantee against all searches. What it does do is limit searches to only those found reasonable by law. The Supreme Court has held that aerial surveillance does not constitute a search in considering the Fourth Amendment. However, the persistent monitoring makes aerial surveillance more equivalent to GPS monitoring, which the Supreme Court has already considered a search. It was on this premise that the Fourth Circuit Court of Appeals based its opinion when it ruled the Baltimore City program was unconstitutional. The question that needs to be answered by this committee is, how does Maryland law enforcement know what is reasonable under the Fourth Amendment by law if we don't have a law? And defining that is the purpose of this bill. We should provide clarity to empower law enforcement to use these technologies when need be. Thanks for the opportunity to present House Bill 228. Happy to take questions, and I'd ask for a favorable.
All right, are there any questions for the delegate on this bill? None on this, oh, wait, Delegate Conaway.
Thank you, Delegate.
Not my fault. So what is it that you want to do with this bill?
With this bill, I would like to provide a legal framework for what constitutes a legal search for persistent aerial surveillance systems.
But as you know, when they had the two balloons up, I think the two balloons could cover the whole city. So how are they going to?
The ones in Harford County?
Well, yeah, they could cover the whole city, they were saying.
More than that.
Okay. So how do we control who is under the surveillance and who is not when the balloons will be just taking in raw data?
This history has a long sordid past of violating people's personal privacy rights. And I think the way to deal with that is you put in place legal protections like we do over and over again, which guide the use of these technologies. You know, every single one of these technologies was abused, whether it was the aerial surveillance plane or the stupid blimps that detached and destroyed property up into Pennsylvania.
Okay, thank you very much.
Thank you.
Delegate Young.
So, you know, my ACLU bone is kicking in on me. It's still in there somewhere. So my difficulty here isn't the technology that exists, but the technology to come. When it comes to mass collection of data, namely artificial intelligence, which is imminent, if not already here. My question is, recognizing what you're trying to do, and I appreciate some sort of a framework because they was just doing it willy-nilly. You know, how do we prepare and forecast for the inevitable, which is that mass data collection is going to become easily digestible, easily usable, you know, very quickly? And so let me pause right there, let you respond.
What's the question again? How do we prepare for use of these tech? You prepare for the use of this technology or any other one by looking at what we've done in the past, by looking at what other states have done. This bill is ripped from directly from, I believe, Montana, and many states have adopted this specific law. So, you know, our country knows this technology is here. We want to provide for the general use of it. It will be used at one point or another. And the question is, what do we do to govern that and tell law enforcement when it is legal, when it is not legal, and when they're going to have to get a warrant? How long does that warrant last? I mean, I think these are questions we have to answer in this committee. And respectively, we have a jurisdiction who decided upon itself, despite the fact that it was shot down in several other jurisdictions across the country for not having a warrant, to use this without public disclosure, recording hundreds of thousands of people.
So I think my difficulty here is that we're talking about persistent aerial surveillance, right? And then we are asking that a subdivision cannot use persistent aerial surveillance but for a valid search warrant, right? But the search warrant should be prerequisite to the persistent surveillance. And at some point, a search warrant has a lifespan that the persistency of the surveillance will probably lapse beyond. So I'm questioning how we have a persistent surveillance and concurrently a limited search warrant. That persistent surveillance has to already exist. So now the question is a matter of access as opposed to surveillance.
That's the beautiful elegance of this bill, Delegate Young. If you read this, and what other states typically adopt is there is a warrant requirement, or there are a handful of other, cases which law enforcement can be empowered to use this. For example, if there's a terrorist attack. If there's a terrorist attack, law enforcement would not have to get a warrant in that case. They would be empowered to say, okay, Homeland Security has said there's a terrorist attack. We, under the law, consider that a reasonable use of persistent aerial surveillance. Another clause that other states use: if a law enforcement officer reasonably believes that use of aircraft is necessary to prevent destruction of evidence or serious bodily harm. There are laws in place in other states which, and we could debate the particular specific policy solutions there, but they have in place solutions that govern the use of this technology. And we did it with stingrays, we did it with genealogy, now we're going to do it with facial recognition. So, I think, the answer to your question is we can set the rules for this technology that we think are prudent.
I think my difficulty is with, Stingray, for instance. I got to go to a certain place, which, I got a problem with stingrays too, don't get it twisted. But, it's not, if I'm in my home and I leave my home and someone in my neighborhood is under a search warrant or falls in alignment with here, then I'm under that same government surveillance, ultimately. The point of persistent aerial surveillance is the large catchment. That's the point. It's to be able to catch that data for future use. It's to be, and I don't see where, and I don't see how persistent surveillance can be, persistent aerial, what I'm trying to say, a bird's eye view, constant bird's eye view from the government can be limited. Stingray is in one spot, LPR is in one spot. We're talking about a constant camera on all spots, which means by definition, I'm under surveillance, which means by definition, the government is surveilling me without a warrant, which to me, I understand the Supreme Court doesn't agree, but I think under Maryland law, we could say, if we wanted to, that might be egregious.
Yeah, and I think the starting place is that we have no law that caps the use of this technology. Here it is, Delegate.
All right.
And we could debate the specifics,
Yeah.
but until we get this bill on the vote list, we don't have any law.
Well, I appreciate your effort here.
Thank you.
Thank you.
All right, we got Delegate Simmons. And it looks like that's it on this one, all right.
Can you tell me, have there been an increase, do you know if there's been an increase in drones being used for this purpose in communities?
I have not seen evidence to indicate that drones have been used for persistent aerial surveillance, no.
All right, thank you.
Thank you.
All right, so we have two people signed up oral. They're on different sides of the fence, but you're one of them, so we're going to bring them both up at the same time. Scott Schellenberger and Elizabeth Hilliard, stepping in for Andrew Northup from OPD, testifying informational. So we'll start with Schellenberger on the unfavorable when you're ready.
Great. Thank you so much. Delegate Grammer, you either owe me a ride home tonight or 3 hours of additional sleep. So I'm opposed to this. So let's start. Remember, we're at the Fourth Amendment. Ever since 1967, Katz versus the United States, the Supreme Court ruled that the Fourth Amendment protects people where they have a reasonable expectation of privacy. But then the Supreme Court went over to hold that photographing people's homes and surrounding areas from a flying airplane at 1,000 feet does not violate the Fourth Amendment. That's California versus Cirillo, 1986. It also held the same with regard to a helicopter that's 400 feet above, and that was Florida versus Riley in 1989. So why would we pass a law that, again, takes away or tries to severely limit a very effective law enforcement tool that's used? Now, I understand that this all started when a certain jurisdiction decided to use this technology without having consulted with anyone. To my knowledge, right at this moment, it's not being used by any jurisdiction in the state of Maryland. But it could possibly be doing that. And what I'm saying is that what's next? If you can do it at 1,000 feet and you can do it at 400 feet, why doesn't 20,000 matter? Why is that different that the persistent aerial surveillance, just like the law says, I can, as a police officer, follow Delegate Robin Grammer everywhere he goes and stand there. I can follow you. And that's not against the law. Now, when you go into your house, I can't go in there, obviously, because that's where the Fourth Amendment kicks in. But the things we hold out in public, there is no Fourth Amendment interest. I understand. I'll echo Delegate Rosenberg, who always asked me, can't Maryland law be stronger than the Fourth Amendment? And my response always was, Delegate Rosenberg, yes, but I don't think we should do it here. This is a good technique.
Are there any questions for our opponent?
You don't have to.
Okay, oh wait, all right, we got one, Boucher.
With this, based upon your years of experience, if this law was passed, do you think it would fail judicial review?
I don't think so. I think they would follow the Supreme Court's lead. I think it would pass constitutional muster.
So that if this bill passed, it would survive judicial review?
I believe so.
All right, thank you.
All right, Delegates Young and then Conaway.
So notwithstanding thank you, Mr. Vice Chair. Notwithstanding my constitutional or just general privacy wants, understanding the constitutional analysis of the Supreme Court, one of the primary rationale for the use of this technology was the reduction of crime. You just mentioned it and referenced it as an effective tool. I haven't seen any data, particularly from my jurisdiction, articulating such. My question is, have you?
I have not, because they ended the program and they were not sharing information when the program was underway. But think of how many times on the news you hear that police responded to a certain location because they had gunshots and the shot spotter went off. This is ShotSpotter's ears, and the ability to use persistent aerial surveillance are eyes. And what the Supreme Court has said is, what you put out in the public is not private. It's not protected by the Fourth Amendment. And therefore, just like ShotSpotter allows police to use that for ears, they can run right to the scene where the gunshot went off. Eyes should also be an option, the ability to use it. Just think about the ability to persistently watch the Baltimore Marathon to make sure everybody's safe. Suddenly, is that now going to be illegal because they want to fly over top the marathon runners to make sure they stay safe?
No, I think we would just block off the streets, frankly. I mean, we do that, right? But what I want to remind you of is that we did do this again. It wasn't just the first time when they didn't tell us. It was also the second time when Mayor Young did it, when Brandon Scott was council president. And they did this for, I believe, I can't remember, was it a year, 6 months? I can't remember how long they did it for. And they ran it.
6 in my mind.
They ran a pilot program.
Yes.
And again, I've yet to see the data that's shown that it's been an effective tool for crime fighting. And specifically, how many cases did it lead to convictions? I don't recall us having a significant number there. So
I'll see what I can find.
Thank you, Mr. State's Attorney. Appreciate your time.
All right, Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Mr. Schellenberger, for coming in, and witness for coming in to testify. Thank you, Delegate, for saying that I remembered it correctly, that we did have surveillance in Baltimore, as I thought. And in reference to the bill, you're talking about eyes in the sky as an option. And on page 2, line 20, number 5, it says to locate an escaped prisoner. Would that be done through a manual search of live stream footage, I guess? Or would that be done using the facial recognition program?
You could use all of the above. You could use the aerial surveillance. You could use facial recognition at locations where they believe the person may have gone. And you could also use the other ones. The police have all those tools that they could use.
So just to be clear, I'm just trying to be clear to my constituents that you're talking about maybe viewing half of Baltimore in one go and using facial recognition and determining whoever it is in whatever crowd and whatever community.
And I'm sorry, I didn't quite understand. This aerial surveillance is so high that you could not use facial recognition. Facial recognition requires you to be closer and get a better look. My understanding is that when the pictures I remember seeing on the news from the aerial video was that you would see little tiny dots moving around, and they were the people. I do not believe you could launch facial recognition from that high up.
As I understand it, and I'm just going to make this as a statement, they have cameras now, especially mounted on satellites and things like that, where you can see the image of a nickel on the ground, tell what year it is. So I thank you. I'm a little out of date on my technology.
I'd be happy to. I don't believe that what we used before and what that would be used again rises to the level of that technology.
Thank you very much.
Delegate Simmons, that question.
Thank you. Yeah, I was just wondering, when you talk about area surveillance, so one of the most common area surveillance obviously is aviation units with law enforcement agencies, including the Coast Guard and Natural Police. With them using that, do you find that the fact that they use that as a surveillance tool, that let's say, for example, they was flying over somebody's house and noticed that they got more than those 2 marijuana plants in the backyard, and now that subject them to executing a warrant based on what's being seen on that residence? Do you think that type of futuristic technology is going to be used?
Well, I don't think they're going to use it for marijuana anymore.
Well, based on the plant requirements or limitations, I think it can be.
Well, I certainly guess that if you didn't have a cultivator license and you were growing a whole bunch in a greenhouse, theoretically aerial surveillance could spot that. But then, as you've correctly pointed out, I'd need to go to a judge. I'd need to have probable cause. I'd need to get a warrant to enter into that property. But the way the Supreme Court talks is when I'm flying over top, that doesn't count if you are revealing it in public.
All right, thank you. Oh, wait.
Oh.
All right, yes, very briefly.
So, Mr. Schellenberger, it is correct that your presence in the public is not protected by the Fourth Amendment.
Correct.
Is it true or is it not true that in Supreme Court case law, they have found whenever a system starts to track you, similar to a GPS system, that is protected by the Fourth Amendment?
Yes. But I think this is different than that.
So a persistent monitoring system that can show your location throughout the whole day does not track you in a similar way to a GPS system.
My understanding is that's not how this technology would work. My understanding is it would just persistently fly over a very large area. People would be dots. I wouldn't be able to say, oh, there's Delegate Grammer. I'm going to follow him down Bel Air Road over to 695. I don't believe that this technology is what we're talking about.
So you don't believe that persistent aerial surveillance tracks you?
No, I don't.
Okay, thank you.
All right, now, we have one final person signed up to testify with information. Do you have something to say that's going to generate questions?
I'm like nervous. Delegate Grimmer, thank you for bringing this bill, but I don't know. I feel like I should get like gummy worms or French fries or something. A lot of pressure on me. What? Oh, sorry. Like the candy kind. It's the Office of the Public Defender's position that persistent aerial surveillance should never be used. We think it's an overly broad, invasive tool that acts as a general warrant capturing data on broad swaths of individuals. And, we appreciate this step and this attempt to curb that usage. We are hopeful, as Delegate Young pointed out, as technology rapidly advances, we could come up with a broader and more prospective approach to these types of developments in technology. I'm not asking you guys to do that tonight. Please don't ask me any questions about that, but I think I will be talking to Delegate Grammer and Delegate Young before next session about crafting something. So we sort of are taking no position on this particular bill in the sense that we would hope we could go further, but we appreciate the efforts and we appreciate the attempt to curb the use of persistent aerial surveillance.
All right, I don't see any questions. Oh. Delegate Bartlett?
To adjourn.
Wait, Delegate Phillips, do you actually have a question?
It will end with, isn't it so?
Real quick, real quick.
So there's a reality. When we talk about, and I'm somewhat of a techie, when we talk about where the technology is going, we're in persistent surveillance today. All of us. That's a reality. And so as we think about this, I do think we need to think about how we're going to apply it to individuals as we go forward. Isn't that so?
Absolutely.
All right, thank you. That's going to conclude the hearings. We did 14 bills in just under 8 hours. See you at 1 o'clock tomorrow.
There's a reality. That's how we found Osama bin Laden. The military got persistent aerial surveillance going on. NSA got persistent. We under NSA right now. So my former FBI agent knows. We under persistent aerial surveillance.